Kia tātou katoa, te atawhai o tātou ariki I raiti, me te aroha o te aroa, me te whiwhi nā tahitanga ki te wairua tapu ake, āmene.
Ko Cindy Robinson, tōku ingoa. I am a lawyer from Christchurch and I am the chair of the hearings panel. I'll just invite my panel members to introduce themselves, starting on my
Morena koutou. My name is Ros Day Cleven. I'm from Dunedin, Ōtepoti, Dunedin. I've got a background in planning. Thank you.
Kia ora koutou, ko Megan Mackay, tōku ingoa, no Taumitu Ahau. I am an independent hearings commissioner based in the takiwā of Taumitu, residing in Lincoln.
Good morning, my name's Jane White and I'm based in Christchurch and I have a background in planning.
Good morning, Stacey Scott, Commissioner, also Timaru District Councillor, here today.
Yes, good morning. My name's Raewyn Solomon. I'm an independent commissioner from Kaikoura but based in Christchurch.
Thank you. As with all of the hearings, the panel have made a number of disclosures of actual and potential conflicts. These are recorded and may result in different courses of action depending on the significance of the issue at hand. In some cases, it's merely just a disclosure for the record for transparency purposes. In other cases, where, for example, a commissioner may have acted professionally on behalf of somebody appearing in the hearing process, we may have a process where that commissioner is recused from deliberations on that hearing topic. I'll just invite commissioners if there are any matters they wish to place on the record this morning.
I have previously disclosed, and it's been in a minute, that I have whakapapa connections to some of the owners of Waipopo Trust, but I'm not a owner of any Māori land.
The only new disclosure I have for this hearing is my husband has engaged the services of Mr. Bruce Spears, who is a submitter, but that is it for this hearing. Thank you.
I don't think I have any conflicts of interest. I don't think I'm a landowner in the Waipopo Trust land, so I have no conflict of interest.
And I have no further matters to disclose either. Just a bit of housekeeping. Just the health and safety matters. Just follow the exits in the event of an emergency or siren sounding, and we'll be guided by council staff as to assembly point, which I think is in the car park out the front. As you will no doubt be aware now, there is a schedule of proceedings available on the council website, along with all of the council reports and evidence that has been filed to date in relation to this hearing stream and in relation to earlier hearing streams. And that will be updated as more material comes in throughout the course of the hearing. I would now like to hand over to Ms. Vila, and if you make introductions on behalf of the council team. Thank you.
Kia ora. Thank you, Madam Chair. Kia ora koutou, ko Jen Bella Aho. I'm counsel for the council, and I'll start by introducing the council team. There's a few of us here today. The council's filed 4 Section 274 reports, and those Section 42A officers are known to the panel. They've all appeared before. On my right, I have Mr. Andrew Willis, who's doing the energy infrastructure, stormwater and transport chapters. Next is Ms. Liz White, who is doing the sites and areas of significance to Māori and the multi-purpose zone. In the back corner is Mr. Nick Boys, who is doing subdivision and development areas. And next to him is Mr. Andrew McLennan, and he's doing historic heritage and notable trees. I have handed up, because there are so many of us, what I should say is each of the, except for Mr. Boys, each of the 42A reports have additional memoranda from experts or council officers. And so I've just handed up a list of witnesses to help the panel navigate who those people are. I believe that we have most of them either online or council offices in person. So we have, in relation to the stormwater chapter, Ms Sarah Dudson from WSP. She's a stormwater and flood risk engineer. And just in case the panel has any questions from a council officer perspective, Mr Andrew Lester is sitting in the back. Sorry, thank you, Andrew. In the back over there. He's TDC's drainage and water manager. In relation to the transport chapter, we have Mr Matt Collins from Ably. He's a transport planner and engineer. And I've just also handed up a statement of qualifications and compliance with the code of conduct for Mr Collins, because that wasn't included in his memo that was attached to the 42A report. And we also have Ms Susie Ratahi, who should also be, thank you Susie, in the back row. She is TDC's land transport manager. And we just have those officers here in case the panel has any specific questions that can't be answered by the experts that are council specific. In relation to sites and areas of significance to Māori, we have at the end of the table here Mr John Henry, who's kaitiaki and the cultural expert for Kati Huirapa, and you've heard from him before in hearing A. And also Mr Aaron Hackhart, who's sitting in the back row, who you've also seen before, and he's provided some evidence around consultation in relation to SASMs. And in terms of historic heritage, Dr Anne McEwen should also be online. She's a heritage consultant, so she provided a memorandum and a report to support Mr McLennan's 42A report. So she's from Heritage Consultancy Services. So if I just turn to my legal submissions, I'll just pick up on a few points along the way. At paragraph 3, I've just set out for completeness the other submissions that have addressed, other legal submissions that have addressed issues that might be relevant to this hearing. So set those out at 3A and 3B. I think also just to bring to the panel's attention, my legal submissions for hearing D are relevant to the submissions by Rangitata Diversion Race Management Limited in relation to the jurisdiction to have a SASM overlay on riverbeds, and also the just to bring to the council to the panel's attention to the memorandum of council from the 14th of June. That's the one that sets out the proposed approach to hearing information on SASMs in the event Mr Henry considers that some of the questions that you might ask are best answered in a private session. And so our sort of thinking at the moment is just to deal with that as it comes up, and Mr Henry's alert to the fact that that's an option and that we can address the panel on that if that becomes necessary.
Thank you for that. And yes, we will be reliant on you to guide us as to when those issues may arise, and just also to flag that the panel may have questions which we consolidate at the end and
Yes.
issue a minute, and some of those matters may fall in that category as well, and
Yes.
we'll deal with the process for hearing those matters.
Thank you.
At that time. Thank you.
So I think at paragraph 9, I've just set out the issues that are being heard in this hearing, which we've really just gone through in terms of introducing the witnesses anyway. So there are just a few points that I really need to address, and the first is around the sites of significance to Māori. So that starts at paragraph 12 of my legal submissions, and for completeness I've just set out, there's been various bits of information that have been filed with the panel along the way. So at paragraph 14 I've just set out what those are so that both the panel and submitters are aware of the information and evidence that's before the panel now. But just in terms of the evidence, just to remind the panel that we've had evidence from Mr Hackhart from the 20th of June around the process that was followed by the council in preparing the SASM chapter and planning maps. And then also from, I should have put in there a statement from Mr Henry for hearing A. And that was around the approach that the council has taken in collaboration with Kati Huirapa to prepare the SASM chapter. And then, of course, for this hearing, a statement of evidence from Mr Hackart that was filed alongside the other evidence on the 23rd of January, which just captures the work that he's done, in particular to work with landowners to both feed into the 42A report and opportunities for consultation after that report was released. And then Mr Henry has an Appendix 3 to Ms White's 42A report, which is drafted in the form of evidence, and that's putting into evidence the methodology that was adopted to identify SASMs and cultural values and responses to specific submissions. So I think what's evident from the submissions and evidence that the panel has before them is that there's been a lot of water under the bridge since the notification of the PDP. And in particular, Ms White has done a lot of work with AEC to respond to the issues that were raised in the submissions. And as a result of that, of around 270 submissions that were made on the SASMs chapter, we've got a handful or between 1 and 2 handfuls of submitters who still feel the need to be heard, and only a few tweaks to the provisions, I would say, that are being requested now in the evidence. So I think broadly speaking, the provisions that Ms White is recommending are generally accepted, subject to a handful of requested amendments, and the remainder relates to the mapping of SASMs. And in terms of the evidence that's before you, there's some general concerns from Federated Farmers about the extent of that mapping and impacts on private property rights, although subject to a couple of, as I said, amendments that they're seeking. It appears that, generally speaking, the provisions are now broadly accepted. And secondly, the Limestone Group, which is Westgarth, Chapman, Blackler, etc. They're clearly not necessarily happy with the process that was undertaken before we got to the hearing stage, but accept that there's no obligation to consult with landowners on this, although there was a draft PDP process, and so therefore there was the opportunity to participate and provide feedback on that if they wish to. And I understand that perhaps they didn't take up that opportunity or weren't aware of it. I'm not sure exactly what the situation is there, but the key issue for them, aside from the process issue, is around the rock art sites. And in particular, whether or not that 250 metres around the rock art sites is appropriate, or whether that should be less. And also, they're seeking some additional specificity around the values and threats to particular rock art particular sites to be included in the Schedule 6. So I think they're the key issues for the panel. If we sort of put aside and I'll address these too, but put aside the submissions around the need to start again or pause the process, etc., the actual issues that are left on the table in terms of the evidence are a few amendments to the provisions and mapping of the rock art sites and specificity in Schedule 6. So I might just address the submissions around the need to start again or the desirability of starting again. And so the Federated Farmers are suggesting that because we've got some RM reform on the horizon, we know that's coming, they've suggested that it's irresponsible for the council to continue to pursue this chapter. And that's a position that I'm aware they're taking in other districts as well. But the reality is we are very early in this RM reform process. We know that it's coming. We know that there are 10 basic principles upon which the government is working up a new piece of legislation, but they're quite vague, and we'd only be guessing as to what's coming out, what might come out in that piece of legislation, which we're expecting in the middle of the year. And so the panel can only make its decision based on the law and the planning environment that it is currently faced with. And I think you can take some comfort in the fact the Environment Court has already made a ruling in the Zank case that it's inappropriate to be guessing as to what the future legislative environment might hold. And so the current requirement is to recognise and provide for Section 6E matters, and that's the context in which the panel should be operating.
Ms Wheeler, just you have previously advised the panel that the council has been given an extension in terms
Yes.
of this process. Did you want to comment on that in this context and whether we should take any, read anything into that, or we just carry on?
Well, and I think I was going to address that in because the other suggestion that has been made is that we stop this and we start again via a variation, although I guess that may or may not fall outside that timetable, or the deadline. But that's right, the council is required to issue a decision within 2 years of notifying the plan. That 2 years, I think, has actually passed, but the council has made an application to the minister, which has been granted, to extend that time period. So the minister's given the council until, I think it's March, off the top of my head, March 2026, and so the council needs to make its decision before that date. And sorry.
I was just, it would be interesting to hear from you about that date in the context of variations. Of course, it may be any topic that we hear in this process,
Yes.
that we may find ourselves constrained by the submissions that have been made and feel as if the evidence may fall somewhat short of enabling us to make decisions appropriately under the Act. And out of that, I guess in theory, we could be saying to the council, you need a variation in order to progress this. I just wondered if you had any comment on that.
No, I might need to give some further thought to that, but it is an interesting question because, of course, the district plan review covers a very wide range of matters, and the requirement is to make a decision on the proposed district plan. And so, I mean, my sort of off the top of my head gut feeling is that wouldn't necessarily preclude you from suggesting that this was better dealt with via a variation. But the decision on that would be one of the decisions that you make on the plan. I might think about that a little bit further, but that's my initial thought. Yep. But in terms of variations too, I guess that's the other suggestion that's being made is that the SASM chapter be sort of started again, and we go through a process of consultation and stakeholder engagement and that kind of thing. And I guess the first thing I would say is that whether the decision whether or not to do a variation is a decision for the council, and so there's cost associated with that, obviously, of starting again. And given how little disagreement we're seeing around the provisions and the mapping, I'd suggest that is sort of an extreme response, and that there's no compelling reason really to stop that process and start again. So I think my legal submissions addressed a couple of issues around identification and mapping of SASMs. So at paragraph 18 on, essentially what I'm saying there is that the Section 6E requirement is to recognise and provide for the relationship of iwi with their ancestral lands and other taonga. And so the identification of those sites that are significant to Māori are for mana whenua to identify. And that's borne out in the case law that I've set out in my legal submissions. And that's not necessarily to say that the panel needs to still be satisfied on the evidence that is the case. But the evidence that you can hear is quite wide-ranging in terms of its scope and might sit outside what you would ordinarily consider admissible in terms of evidence. And so the case law that I've set out from sort of 27 onwards is really just saying there's a wide range of evidence that you can take into account when you're considering cultural evidence. There seems to be a suggestion that that the process of identifying, and I could be wrong in terms of my interpretation of the submissions and evidence, but there seems to be a suggestion that the process of identifying SASMs and their values should involve stakeholder engagement, i.e. consultation with landowners, and the council recognises that the landowners who are presenting evidence this week have do view themselves as custodians of this sort of piece of historic heritage in a way, and have taken actions to protect that, and that's to be commended. But the Section 6E requirement is about the relationship of iwi with their ancestral lands, and so I think it's wrong to say that you would need to consult with landowners or to engage with landowners on what those sites are and what those values are. In terms of management of them and how they should be managed, that's a different question, I think. But just going back to the Man of War cases, what is a site of significance is a matter of fact to be found in the evidence, and the evidence comes. And so to say that it's inappropriate for mana whenua to solely rely on evidence from mana whenua as to what those sites are and what their values are, because there might be expectation that comes, is also a tricky question, but the fact is that mana whenua are actually the experts in what sites are significant to them. And so I think we're just in a situation where they're the experts, and that's the expert advice that you need to be considering and that landowners might need to engage. And that's no different to saying there might be some ecological issues that we need to consider in the context of our resource consent application, and we need an ecologist to provide that advice. The fact is that Section 6E provides for a relationship of iwi with their lands, and that's where the expert evidence comes from.
Ms Vila, just in terms of your reading of that evidence, and we will obviously have those submitters in front of us have the opportunity to question them, but is there not perhaps the risk that those submitters perhaps have conflated those two parts of the process as opposed to necessarily a dispute about the significance or the identification of values versus the management of those?
That might well be the case, and that's why I said I may be misinterpreting that. But my reading, I did go back and read Ms Hamilton's submissions a couple of times, and it's obviously a question for her, but it did seem to me that they were suggesting that because they have a history with the rock art sites, and they and some of their ancestors have obviously done some kind of work in terms of figuring out what the history of those things are, and have taken a genuine interest in them, that they have some knowledge to knowledge to impart or share around what the values are. And so I think that's something that you should investigate with the submitters. I think the other thing to say about the evidence of the Lionstone Group is that, and this sort of goes to the 250 metres potentially as well, that Section 6E is not necessarily, Section 6F is about protecting historic heritage. Section 6E is not necessarily about just protecting that one particular site as an artefact of history, but it's about protecting the relationship of iwi with their ancestral lands in taonga. And so there's a wider story around those rock art sites that is to be told, and there's a wider relationship than just with some historic painting on some limestone, I guess. And Mr Henry can sort of talk to that a little bit more, but I think that's something to bear in mind, is that we can't be too two-dimensional about that, and there's a wider story to be told and a wider relationship that might need to be recognised and provided for. The other thing that both Mr Henry and Ms White might touch on, or that you might want to investigate with them too, is that there's been Ms Hamilton's submissions make a comparison between what this plan does and what some other plans do. And there are always options in terms of planning responses to things. But we did notice that those plans that she's referred to are all North Island plans. And the South Island iwi are different to North Island iwi. And on the one hand, the evidence is that we shouldn't look to Mackenzie District and just adopt what they're doing. But on the other hand, the submissions say, well, we should look to the North Island plans. I think perhaps Mackenzie it's probably more appropriate to look next door as opposed to the North Island, and it's the same runanga and it's the same environment. So I think the Mackenzie District Plan, in terms of the requirement to have a look at what else is happening nearby, is probably more an appropriate one than the North Island plans to be looking to. And I think the last thing on the SASM's point is around a concern, I suppose, that, and a submission that the SASM should overall be reduced in size, because there's a concern that if we have a broad-ranging SASM overlay, there's a concern about future rules that might be imposed at some point in the future. And I think it's sort of been referred to as legislative creep. And acknowledging the anxiety that the Federated Farmers evidence says that, you know, farmers have around some of the mapping and things that's been that has been appearing on their land over recent years across a wide range of subjects. We can't be making decisions now based on concerns about what might happen in the future. So there'll be a future process that will need to be gone through exactly the same as this one, at least unless that process changes under the Resource Management Reform, but a future process by which they will have the opportunity to make their submissions, work with council if they like, on providing their views as to how SASMs in the future should be managed. And so the decision, again, that the panel needs to make is in the context of the current, what's in front of you at the moment, what the rules are being proposed at the moment, rather than guessing as to what might occur in the future. And so I'd say it would be an irrelevant consideration, really, to be considering what rules might be imposed in the future. And the only other issue that my legal submissions address is around stormwater management. And I think the only thing really to say here at the moment is that the council recognises there are some sort of gremlins in that drafting. For example, around well, I guess what I should step back for a second. Stormwater connections are currently managed by the bylaw, as I think they are in most places, if not everywhere. And the bylaw is quite broad in the sense that it sort of provides a framework and says we can impose conditions on that connection request relating to stormwater quality and quantity and things like that. And the way that it currently works is that the council has some infrastructure design standards that set out what those conditions would be, or what the standards are that you should meet in order to get a connection. The council desires, I suppose, to bring the consideration of those standards and into the design process, into the design of whether it be a subdivision or house or whatever or building or whatever it is, rather than leaving that to the end of the process. And that's why it's been included in the district plan. Recognising that there are some potential issues around duplication, the standards in the plan are the same as the standards in the infrastructure design standards. And there is the way that the standards are drafted at the moment, it has some sort of positive statement about the fact that the council will grant a connection if those standards are met. The way it's drafted at the moment is that it's drafted as a standard, which of course an applicant can't meet that standard. So there, at the very least, need to be some redrafting of that part. But the council, having received the Prime Port evidence in particular, is considering whether or not that's the approach that they've taken still an appropriate or desirable approach. And so I think Mr. Willis will have some thoughts on that that he may be able to share with you, although hasn't come to a definitive conclusion. But what we've suggested is that we recognise that there's probably some work to be done on that chapter. Prime Port and other submitters will be sort of have a key interest in those provisions, and that this is probably one that we could do some more work on with them post the hearing and report back into the... And of course, if necessary, that can come back into the sweep-up hearing at the end or something along those lines if that's required.
Do you think it's helpful to have a little bit more formality around that?
Yes.
Should we make some directions regarding conferencing? And should it just be planners, or should we bring in, I mean, there's a number of surveying firms or witnesses that are involved that at least have some coalface experience with working through these rules, whether they should be incorporated into that process?
Yeah. Yes, I think a process is probably very worthwhile. I think that's something that you could consider as you hear the evidence and make that decision at the end of the hearing. In terms of whether others should be involved in the process, I'm not clear on whether you're suggesting other submitters or other experts that...
If it's formal conferencing, it would be expert witnesses, people who are appearing before us as experts in their field that may be relevant to the issue of stormwater.
Yes. So I think I'd have to have a think about who else might be appropriate, but at the moment, from the council's perspective, we've got... it probably would be, it probably would be right to have stormwater experts there. I got a bit thrown by the surveyors, but yes, it's stormwater. Thank you. And I think there's just one other thing that I noticed as I was reviewing the other legal submissions that I might just address you on too. And that relates to the heritage listings, particularly where a heritage building has a certificate of compliance. And I noticed that the legal submissions for Prime Port referred back to Plan Change 14 and the submissions and decision that was made there around the fact that a code of compliance forms part of the existing environment. And I'm not super familiar with Plan Change 14, although I know that you are, Madam Chair. But my understanding of that was that in that situation was that there was an area that Christchurch City Council had identified as a residential heritage area. And the question for the panel was whether essentially that should be a qualifying matter in terms of density of development under the MDRS. And Kāinga Ora and others were showing up to say, oh look, we've got certificates of compliance to demolish all of these heritage buildings in this area, so don't count those as contributing to the heritage character or quality of the area itself, because they form part of the existing environment. And so it would be illogical to count them when we're actually going to demolish them sometime soon. And I think that's correct. In this situation, I think it's slightly different though, because we're assessing an individual building against the criteria in the plan for whether or not they qualify as a heritage building. And at that stage of the process, you're not assessing against the existing environment. And so the certificate of compliance forming part of the existing environment isn't relevant to that assessment as to whether or not a building has heritage qualities that qualify as a category 1 or 2. And that's not necessarily to say that the existence of the certificate of compliance is an irrelevant consideration. I just think that it's not an existing environment argument. And so you might decide that you're convinced that that building is going to be demolished next week, and so it shouldn't be included as a heritage building. But if it's not, and the code of compliance lapses, then it still retains its heritage qualities, and it's still a heritage building and qualifies under the criteria. And so I think that's the context in which you might consider the relevance of the certificate of compliance, not an existing environment. And so I don't want to make a big deal of that, but I just, in terms from a legal perspective, just wanted to set your thinking right from that perspective. So unless you've got any further questions for me.
Yes, I have a couple of questions. Just picking up on your last point, and also in Prime Port's evidence, they refer to not just Plan Change 14, but also established case law of Hawthorn. They don't go into Hawthorn very much, but I did want to know, well, what's the relevance of Hawthorn? And it's a question really for them rather than for you, but if you do know anything that can be helpful.
Sure, I can answer that. So Hawthorn is the case, or one of the leading cases that establishes what the existing environment is. So when you have to assess, for example, a resource consent application in terms of its effects on the environment, the question is, well, what is the environment that you're considering? And so Hawthorn says, well, it's the environment, it's what you can see, but also there's a consent to put a 10-storey apartment building over there, and that's not there right now, but it's consented and you're able to do that. So we're going to count that as part of the existing environment. And there's a part of that which says, and I'm just trying to remember, no, I don't think the Prime Port submissions say this. There's a part of that says, so future unimplemented consents will be included in what we call the existing environment if they're likely to be implemented. And as an extension of that, your certificate of compliance, because that essentially acts as a resource consent, that also forms part of the existing environment. And what I'm saying is that's fine and true, but in this particular case, we're not assessing a heritage building, against the existing environment. We're just assessing it for its heritage qualities against the criteria in the plan. Yeah.
That is really helpful, thank you. I had one question around SESM's process, and it was really helpful that you pointed out that future rules are an irrelevant consideration that we really shouldn't be taking into account in our decision making. And then my question was around the raised conflict of interest or perceived conflict of interest, and whether there's any criteria around, does a Section 6 matter that, as you've described it, outweigh any perceived, is there a conflict of interest, number one, and if it's only perceived, what has more weight in the RMA context? Is it Section 6?
Well, I think what I'm saying is, how do you recognise and provide for Section 6E matters without evidence from mana whenua?
And so the legislation kind of directs us in that way?
It does direct us in that way, I think, yes.
Right. Great, thank you.
Morena. In my various readings of all the materials, I noticed that Mr. Boys in his section 42A mentioned that there may be further legal subs being provided in relation to development areas. I noted that it's not covered in your legal subs, and so I'm assuming that it eventuated that you didn't need to attend to any details there, but would that be something you could confirm for us?
I'll come back to you on that if I can.
Lovely, thank you.
Thank you.
And my other question was around, in paragraph 40 of your legal subs.
40?
40, and it relates to the concerns around SASMs and some of the perceived fears. Mm-hmm. You mention the perception that SASMs may result in potential impacts on existing use and property values. So in terms of property values, to what extent is that a relevant matter for our decision-making process in the context of plan development?
Yeah, so of course there's sort of commonly accepted principle that property values are essentially a proxy for other effects. And what that means is that if there's I think if you're talking in the context of a resource consent application, if you have an effect of an activity that affects the neighbour, for example, and might be dust or it might be noise, for example, then what you're assessing is that primary effect of the dust or the noise, etc., on the person, and the value of the property is really a proxy for those effects. So if you were considering the property value, the impact on property value, you're essentially double considering or double dipping in terms of what those effects are. I can't think of a reason off the top of my head why that would be different for a plan. I'm happy to think about that further and come back to you, but I haven't delved into whether or not there's any case law on that.
Thank you. That's certainly my understanding in the resource consenting space. I just wanted to clarify that for my own understanding leading into the process. That would be really helpful. Thank you.
Viola, I just wanted to follow on from that conversation. The concerns of the submitters are more around the loss of productivity on land. So rather than resource consenting issues, I think from my reading too, is it's the loss of productive land that is of concern with the setbacks. So that's just, I think that's the other consideration is on property values.
The other thing I would say about that is really that it's important to have a look at what the rules actually do say and whether they actually do result in a loss of productivity of land. Because I think the sense that I'm getting, particularly from Federated Farmers' submission, is that there is anxiety amongst landowners and farmers, and I'm not suggesting that that's not understandable, but that, and this is kind of reflected in the amendments that they're seeking around access and existing use rights. Neither of those things can be overridden by what the plan does. And so I think there's actually an education piece and a let's just get clear on what impact is actually having piece to understand as well. So it's slightly different, obviously, to the question that you're asking me. But in terms of the comments around loss of productivity, what's the loss of productivity? So you need to understand what that is. And it's similar in terms of the submissions around impacts on private property rights. So I'd be interested to, there might be an inquiry into what's the property right that's been affected by this rule, because my sense is that the issue is not so much what specific right is being affected, but just the fact that there is an overlay over the land creates that anxiety. So I think getting specific about what those issues are is probably quite important.
I think we'll leave it there, Ms. Vela. Thank you for that. I think Mr. Willis is.
Thank you. So I think we'll just go in the order that is in the schedule, if that's okay, and that's how we've got people set up at the table. So we start with Mr. Willis, and just to remind you that we've got Mr. Collins for transport, Ms. Dudson for stormwater, and council officers available if you need to ask those questions.
Thank you, Madam Chair. So what I was going to do this morning was just basically take you through my hearing summary statement. So I think that sets out, I guess, some of the key issues that were identified in my Section 42A report and some of the matters that are still live. So if I just go straight through to the summary of the key issues that were identified. And in my 42A report in Section 3, I identified a matter around the relationship of the EI chapter to zone other district-wide chapters and how best to provide for this. So it is quite a challenge with the energy and infrastructure chapter and transport in terms of a relationship of this chapter with the other chapters. And I've sought to, I guess, that was an issue initially in the plan and has come through in submissions and is one which I've sought to resolve. There's some issues around the level of restrictions and activities on the national grid, corridor and yard. So these were identified in submissions. Need for greater alignment with the NES for telecommunication facilities, whether to provide a permitted pathway for large-scale renewable electricity generation, whether to include an effects management hierarchy, what is the appropriate level of control for new Three Waters infrastructure, whether to restrict managed and controlled fills within the bird strike management overlay, whether to retain the stormwater management chapter or replace it or amend it, whether to exclude specific zones from specific provisions in the stormwater chapter, and likewise for the transport provisions, and also some questions around requiring Indigenous vegetation, landscaping and car parking. So those were not all the matters, but they were the key matters that floated to the top in my mind that I identified in my Section 42A report on the basis of submissions. So looking through the evidence that's come through on these topics, then I've identified the ones that I consider of those that are still outstanding. And that again is the relationship with the EI chapter to the zone and other district-wide chapters, and there's some matters raised in the evidence around the port, the Murray Purpose Zone and SESMs. Again, large-scale renewable electricity generation has come back in evidence, but more particularly in relation to being permitted on buildings, industrial zones. Just the wording of the effects management hierarchy that I proposed in EIP2. And then with quite some significant analysis around the stormwater management chapter and some of the shortcomings and issues associated with that. And then some queries or evidence around Fonterra's Clandyboy site in relation to loading requirements and how to classify it under the high trip generation activity rule. And then in the course of my Section 42 report and the recommendations that I've made, a few other issues have also popped up that's been identified in evidence that were not addressed originally as my key issues. And that is again around Three Waters infrastructure, whether to include operational functional matter of discretion for water bodies in the bird strike management area, the appropriateness of the heavy vehicle rule for the Clandyboy site, the wording of some of the recommended amendments that I've suggested in response to submissions to EIO2, 04, P1, P2 and PX in response to submissions, matters of drafting detail in relation to telecommunications networks, and then some definitions around telecoms as well, and providing or enabling alternative management forms for regionally significant infrastructure for stormwater. There are 4 corrections that I identified from my report. I won't take you through them unless you specifically want to cover them. I think they're reasonably clear. Yes. Thank you, Madam Chair. And so I've identified a list of resolved and unresolved activities in the appendix on the basis of my understanding, and I have identified matters that I think are reasonably clear where I could seek to make some amendments to respond to the evidence that's come through, and I've identified those, such as a review of the stormwater provisions as alluded to in the legal submissions. So on that I would note that, the stormwater chapter is reasonably novel for district plans. There are district plan requirements that I've noted in the Wellington City Council plan and also the Dunedin District Plan, which require resource consent around stormwater matters. So it's not completely novel, but it's not common in plans. I do think it's probably an area where second generation, third generation plans will head, in my view, given the tightening up of requirements at a national level and regional council level around stormwater management. So we're kind of at the bleeding edge, but I think we are at a point where we are considering these matters in district plans. For stormwater, as I said, I'm open to a full review in order to provide some efficiency, better efficiency and effectiveness, but I will note at the outset, and which would inform some of your questioning potentially of other submitters, that the approach has been to pick up the stormwater standards that apply anyway through the bylaw and infrastructure design standards and put those same standards into the district plan. So if there are issues around application of those standards around workability and uncertainty, then those issues already exist because we've picked them up, and if that's the case, then we do need to resolve those, but there are issues that exist now in terms of the standards, and I appreciate that through an RMA framework that does focus your concentration and lens in your mind around those issues and around certainty as well and workability. So potentially that's an issue that's been carried into the plan. And the reason we did that was to avoid duplication, and we tried to say, well look, if you get it approved now through a district plan, then we'll get the tick through the bylaw stage. So that was our attempt to avoid duplication. Whether we've succeeded or not is another matter, and whether there's a better way of doing it is something which I'll consider as part of a review. I think that's all I want to say on stormwater. Which it is quite a major issue, but I'm, as I said, happy to be directed by the panel to go away and work with the parties to come back on that and see if we can come up with a better way to manage that issue. The other things that I have identified as being reasonable: exclusion of the port activities from the EI rules. I need to work on EIR 26 around its intended applications. That's above ground stormwater systems infrastructure, and just what is it and what it should include and apply to. I've agreed with the evidence around the Clandyboy site for how it should be assessed in terms of high traffic generation activities, and also to be excluded from the heavy vehicle rule because of the status and nature of the roads immediately around the port, which I understand have already been developed to a standard to withstand and respond to heavy vehicle movements. So there's no need to cover those. And some amendments around Stormwater Policy P3 for regional significant infrastructure. And a few other changes which have come up, some minor changes in relation to evidence that's come through, such as from evidence of Ms Francis for ECAN around referring to sites and areas of significance for Māori. Add some hyperlinks for the definitions and some changes around some definitions for telecommunications line, telecommunications networks. And so just stressing at the moment that there are some other matters that have been raised in evidence which I also think have merit. I haven't listed them here, in part because I'm still working through the complications or implications of how they might be drafted in the plan, and also looking through to see how and where they might conflict with other submissions that I've already considered. And I'm also seeking some further technical advice from some of the council's experts as well to inform that. But there are other matters as well that I will come back to as part of my reply report and look favourably on in terms of those other submissions. So that's what I wanted to bring to your attention through my summary. Happy for any questions. And yeah, apologies, there's a lot in my report. It's probably one of the bigger ones. So, and there's a lot of detail and they're quite challenging topics.
Thank you, Mr Willis. So I did have a question for you around your recommendation to make the Red Ruth facility regionally significant infrastructure. Mm-hmm. So that's a matter that that was traversed in hearing A in strategic directions in terms of that definition and where that was heading. I'm wondering if you could remind us perhaps any recommendations that you had in hearing A, how that relates to your recommendation in your present report, but also if that leads to any subsequent changes to the strategic directions that we need to be aware of, or any other consequential implications.
Sure. Yep. As the author of that original report for these strategic directions, I think if I recall correctly, I sat on the fence around that and said that matter is going to come up again in the energy and infrastructure. I hadn't turned my mind at that stage to the merit of the suggestion, because I did want to consider that within the context of energy and infrastructure itself. For me, it was very much an unbalanced decision, and I guess we may all have different views on whether that should or shouldn't be regionally significant infrastructure, but found that the evidence for this matter quite helpful around the significance of this particular facility to the district and the value of it being considered regionally significant infrastructure. And in an unbalanced decision, I decided that yes, potentially, that is my recommendation. I don't think there's any conflict that I'm aware of, unless you wish to point that out, Commissioner, around what that might mean for strategic directions. In my view, it just gets caught into that bundle of provisions that apply to regionally significant infrastructure, and I think it just sneaks in my view, into that.
Thank you. And a question for my understanding, and just a clarification, at paragraph 6.5.7 of your section 42A report,
Yep.
you've recommended a term urban location.
Yes.
And my question is, does that in itself simply introduce another potentially confusing interpretation issue when trying to think through what represents or what constitutes an urban location?
Yes, potentially. You'll appreciate if you've drafted plans that certain terms are defined and then, of course, have those meanings, and we also use those words in general everyday language, especially in objectives and policies, and then sometimes are aghast to find that means something else, that it's not what we intended. So in this instance, I made some attempts at coming up with a term which allowed me to express what I wanted to express, but didn't cover the matters in the defined term. So I mean, that was very much a purposeful attempt to get around the definition of urban environment in urban area. So it does introduce another term, but I think I've done it purposefully in order to make the provisions work. I don't think that creates confusion. It is a term, it is hyperlinked. Yeah.
And paragraph 6.12.10.
Yep.
That relates to a recommended amendment to upgrading, and my question was, does an increase in carrying capacity go hand in hand with size? I think the rule is, I think it was capacity and size. Are they mutually exclusive?
I think you can change the carrying capacity of electricity lines with not a huge change in size, that's my understanding. And sometimes it's additional line as opposed to a change in the size of the line. So I guess the challenge with some of these definitions is that it covers a wide range of infrastructure, some of which could be an increase, some which might not. Yeah.
Thank you. And I have got some other drafting questions, but I think that might be something that we can wrap up in more detail in any memo. Thank you.
Kia ora. I have a few questions that follow the structure of your report, but the very first is all about integration. And we've received evidence from Ms Poole from Te Rūnanga-Raitahu that talks about your recommendation that both the EI and the Trans chapter expressly state that they take precedence over the other zone chapters. And what Ms Poole points out is that part one of the general approach already deals with that and says what takes precedence where. So what is the need to have that statement and these chapters, EI and Trans, having precedence over the zone chapters? Like what are we trying to correct?
So one of the challenges in the zone chapters is that they tend to have a default rule which says anything not identified in this chapter is discretionary. So if you haven't in that chapter identified infrastructure, customer connections, telecommunications facilities, then technically it's a fully discretionary activity in the zone. And it hasn't identified those because they're in the energy and infrastructure chapter, and same with transport. So a lot of this is around getting around that rule, which is the default rule in the zone provisions, because the zone doesn't cover it. Zone chapters don't cover it because they don't intend to. That's not the intent of those. So that's why we're saying it takes precedence over those zone rules.
And she does go on to point out that when it comes to a special purpose zone, her interpretation of the national planning standards are that they need to have a specific assessment to go whether or not energy and infrastructure should take precedence over, for example, the Māori purpose zone. So is that your interpretation of the national planning standards, and has that been carried out here?
I didn't expressly turn my mind to that matter that Ms Poole has raised. Again, the Māori purpose zone won't provide or permit for infrastructure in the chapter, which means that all those activities are fully discretionary. So the question for me and for the panel was, is that appropriate in that zone? What is specific to that zone which would make all those infrastructure activities fully discretionary?
That might be the case for all of the special purpose zones, that they need to be considered given the
Correct.
National Planning Standard.
Yeah,
Okay, thank
yeah.
you.
And by way of comparison, Ms McKay, the Waimea Redistrict Plan, it gets around that issue because it says in those default rules in all the zones, if it's not mentioned in the zone chapter, it's discretionary unless it's specifically provided for in a district-wide provision. So it gets around it by doing that way. So in many ways, those district-wide rules all take precedence over the zone provision.
Right. Okay, thank you. And I do have a question on the new policy for National Grid. And I wanted to know why it's written in there in subclause 5 and 6 that this policy prevails over SASMs and the natural areas of character.
Yep.
Yeah, what's the purpose of that?
So that wording is lifted from the evidence of, and the submission from Transpower, and that's my understanding is that this is a nationally consistent policy that they've sought and applied. I guess I didn't go back and test to see whether and how consistent it is nationally, but that is the wording that Transpower provided. I looked at that and thought that seems reasonable on the basis of their submission and the fact that it's a national grid. It does, as a linear infrastructure, it does need to cross through areas as opposed to deviating. And in my mind, that was appropriate.
My next question was about matters of control and discretion, and it was primarily responded to by Ms White in her summary statement, but this again was where Ms Poole did the list or the analysis of where matters of discretion and control should be brought forward across these particular chapters, and all of those recommendations, what it boiled down to was just 3 EI rules and 1 stormwater rule, and Ms White has accepted that, but given that these are your chapters, I wasn't quite sure who should be responding to that, who's accepting that evidence or not.
Yes. So the approach I took was that any area, any sensitive environments are already identified and covered by district-wide provisions, and so it is an integration question. So that was my starting position: was if it's triggered by a rule in those chapters, then those chapters will have the appropriate matters of discretion. So that was my starting position. I've looked at the rules that Ms Poole has identified, and I'd need to have further discussions internally around how those particular rules are considered elsewhere in the plan, or if they are, or if they're not, even as to whether or not I need to have those matters of discretion. But of those 4, the stormwater rule is simply around quality and quantity entering the council's network. It's not a rule around the activity per se and effects on mana whenua. That's not the intention of the rule. And the landfill within a bird strike management area is not a rule about landfills. It's about protection of the airport. So if there were any matters of discretion in relation to sites near Stevens to Maori or Tangata Whenua values, that would be in relation to landfills in general as the rule. That rule is targeted only at landfills within the bird strike management area. It doesn't cover it anywhere else in the district. So it's probably not the right rule to apply that matters of discretion to in the first place. It should be in relation to landfills, for instance, in the rural zone, in the zone chapter, in my view. So, yeah, I would disagree around applying those matters of discretion to a couple of those rules at least.
Thank you. Working through your report, I had some questions on stormwater, but I think that they're better left for now. So I'll move on just to transport. And this might be actually a question for your witness rather than you, but when it came to the Rule 10 and the new rule around high trip generating activities, and there was some discussion in both your report and the expert reports around financial contributions and development contributions, and I wasn't quite sure what regime applied here in Timaru. There was a statement that said there were no development contributions in Timaru, and so I wanted to know what the existing regime was here.
Yes. My understanding is when this district plan was being prepared through the drafting phase, there were significant discussions internally around the approach that this council should take in relation to financial contributions or development contributions, and a divergence of views on that. My understanding is that there are no development contributions currently taken by this council. It's financial contributions. That's the approach in the operative plan. Whether that continues is another matter, but there's certainly some further work to be done around the financial contributions and that chapter, which is coming to a later hearing. And I think then also the relationship between that chapter and these provisions in the transport chapter, I think, need to be looked at.
Thank you. And just one last question on Transport Standard 1. In yours, this is your evidence 6.84 is your paragraph that you deal with this. And this is where Rooney opposes the limiting landscaping to Indigenous vegetation. And your recommendation has been to delete the requirement, just delete Standard 1 subclause 3 that requires planting to be limited to Indigenous vegetation. You've done that on the basis that the NPSIB only promotes Indigenous vegetation rather than require it. And I wanted to know, by removing that standard entirely, how does that actually still enable councils to promote Indigenous vegetation? And is there some type of middle ground here rather than remove it?
I think councils can, yeah, it's a good question actually, and that was very much an unbalanced decision as well. My preference is always to plant Indigenous vegetation where possible. The question for me was, do I require that in a rule, or is that promoted through other means, through advocacy and with developers directly by the council in their own developments, through other means? And I was also mindful of the fact that the RPS has to identify targets for Indigenous vegetation in urban areas, and that hasn't yet been developed. And as part of doing that, and the council responding to that, it may come up with alternative approaches or not. And I wasn't sure whether or not I was too far ahead of that work in order to require that in district plan now. Yeah, thank you.
So I've got a follow-up question from the first question you were asked, and it's around Redruth. And I understand that on balance around the regional significance, I'd like to explore with you the definition of infrastructure, whether that was part of your consideration, particularly in light of how regionally significant infrastructures defined in the RPS and how infrastructure is defined in the Resource Management Act. And is it infrastructure in terms of the definition of the Act? And is there any issue then with altering a definition of regionally significant infrastructure?
Yeah, and it's interesting, I might have anticipated that because I literally got the definition of infrastructure sitting up here on my second screen under the RMA.
They're quite transparent.
You're right, Commissioner, it doesn't fit easily within the definition of infrastructure under the RMA. Regionally significant infrastructure is broader in the RPS. And I guess there are instances in Canterbury plans where their infrastructure statements have taken or moved or included matters that aren't necessarily infrastructure under the RMA definition. So, for instance, the Selwyn District Plan includes, I think, as important infrastructure, milk processing plants. Rightly or wrongly, that doesn't fit easily within the definition of infrastructure in the RMA, nor is it in the definition of regionally significant infrastructure in the RPS. So this is an example where its line of authority comes from the RPS in terms of its uniqueness, its significance, and its and how necessary it is and its ongoing functioning is necessary for the district and the community. But I do appreciate it's an uncomfortable fit.
That's fine. I'm just wondering whether just what's the right outcome, and it's more in terms of where it fits rather than what it is. So
Sure. So there could be special provisions for Red Ruth, but not necessarily in this chapter or as part of infrastructure. I appreciate that. Yeah, I can think about that.
So I've also got a number of quite specific questions, but again, I think I'll pause those and put them in a memo. But there is one I want to ask you about, because it's in an objective, and so it may affect some further questioning.
Sure.
So it's objective EIO1, and it's the inclusion of the supporting emissions reduction part. And I just wanted to ask you, in the report it appeared, your Section 42A report, it appeared quite clear that it was a consideration and it would be good if you could. I'm just wondering if the way it's worded in this objective actually makes it a requirement, and in particular I'm looking at the end of the first chapeau where it says and then it's 3, contributes to the economy, supports emissions reduction and supports a high standard of living. Does that effectively make it a requirement that any regionally significant infrastructure under this objective needs to support emissions reduction? And was that your intent?
It wasn't my intent that it would be so stringent, and this is a matter that's also been identified by the Port in their evidence, and I do agree with the Port that I could certainly add where appropriate, for instance, after that, or where relevant. It wasn't my intention for it to be such a strong statement. Yeah.
Sorry, I'm just going through filtering now, which are
Sure.
things I need to ask now versus not. I do have a general question around the effects management hierarchy and the introduction of that into the provisions. And I understand the difference in relation to Transpower's submission. And the other thing that was excluded in terms of the NPS-IB relates to renewable generation. And I wanted to know, is the approach taken because there just aren't submissions in relation to that renewable generation to the same extent, or was it a deliberate, so was it a matter of scope and consideration, or was it a deliberate thing that the transmission lines are different?
A bit of both. So I was looking for a solution in response to the submissions, and the effects management hierarchy seemed to be a good solution. I needed to distinguish the national grid from that, and had scope to do that. There wasn't necessarily scope to distinguish renewable electricity generation, but also I used an effects management hierarchy as a tool rather than the approach of being to implement the NPS-IB, so I approached it from a different angle. Hence why it's a bit more. It does include renewable electricity generation, I guess, in the round, even though it wasn't purposefully attempting to do that, because I didn't pick up the NPS-IB one. It was simply a tool that I took to respond to submissions. And I understand there's evidence from ECAN and also from Department of Conservation on the appropriateness of that in relation to renewable electricity generation. I am live to that issue, and I think I need to respond to that matter in my reply report.
I think the rest of matters of detail on that one. Sorry, it was... I think the rest for me on that one are matters of detail. And again, I did have a number of questions on the stormwater one, which I'll wait for. That's all for me at the moment, thanks.
As I said, I think, as we've signalled, I think the stormwater chapter does need some wholesale drafting, and so matters of detail may not be efficient to cover now.
I guess I'll probably ask, there's one general principle matter that I was thinking about when doing it, and I understand that you said one of the ways of avoiding duplication was actually to pull the standards the same. And I guess the question is there not just an easier way of avoiding duplication?
And there is, and one of the solutions that I wish to explore with the parties is simply having a framework that says you're permitted if you've got bylaw approval.
Right, okay.
And if you don't, you need resource consent. So that avoids duplication, and it's much clearer, and we don't need to copy over any of the standards. And that is my favourite approach at the moment. I'm just trying to work out if there are any fishhooks with that.
Okay, that's actually quite helpful, understanding kind of what the scope of your
Yes.
thinking is. Thank you.
Yeah.
Yes, Mr Willis, I've got some questions. What types of land use effects could potentially be generated by installing solar panels on industrial buildings? I'm trying to understand what the effects would be.
Yeah, that's a good question. There are some large industrial buildings, and so you can get quite large solar panels, but also you've got the associated equipment that goes with those, be they substations or other components. And my concern was less about the effects in the industrial zone per se, but more about the effects of those activities might have when visible from a sensitive environment. And that was more my concern. So potentially there are opportunities to tailor a response to that and provide for large-scale solar on existing buildings where they're not within a certain distance of a sensitive environment. So there is opportunities for that. I haven't quite confirmed in my mind whether and how that would work, but there is a possibility.
Okay, great, thank you. I've got a couple more. I'm not sure if this was raised in a submission or not, but I'm referring to your paragraph 6.20.12.
Which one was that?
Is there an expectation that regionally significant infrastructure and lifeline utilities would support all standards of living rather than just a high standard of living?
Sorry, Commissioner, can you, which paragraph was it again?
Paragraph 6.20.12.
6.20.12. Let's get that 6.20.
Bullet point 3.
Bullet point 3, got it, thank you.
I'm not even sure whether that was queried, sorry.
Sure, yes, so those are the existing wording, that's the existing wording, the high standard of living from the notified plan.
I think it's from, is that, oh, I see what you're saying, yes. So is that right? Why aren't all standards of living in there? Why is it just a high standard of living?
Well, I think functioning infrastructure does support, well, it does support
Yeah.
a high standard of living. It also supports a high standard of living. So, but I guess what we're saying here is that without properly functioning infrastructure, you're less likely to have a high standard of living.
Okay. At your paragraph 6.24.2, where Forest and Bird have asked to include the words no to minimal adverse effects, do you think that's sufficiently clear that it is 0 to less than minor adverse effects, or could it be interpreted as no minimal effects at all?
Yeah, it was a curious submission on that one. I did look at that, scratched my head a few times, and wasn't entirely sure that there was a huge difference between what I had and what the submitter was seeking. And in the end, on balance, decided to go with what the submitter was seeking, because I didn't think it made a difference in my view.
Okay. Okay. At your paragraph 6.35.3, you talk about, is there an expectation to discourage the use of fossil fuels? Because wouldn't a non-complying pathway support or better achieve discouragement?
So that was 6.35.3.
3.
Got it, thank you. Yeah, that's right. So I looked at whether and how some industries with sort of minor diesel or minor coal-fired electricity supplies would be affected by that approach. I thought discouraging all non-renewable electricity generation was overly onerous across the district for every activity. That was my approach.
Okay.
Yeah.
I've just got a couple more.
Bearing in mind that carbon emissions, etc., are dealt with under other requirements.
What was that, sorry?
Bearing in mind that emissions reduction is dealt with under other requirements as well. Yeah.
Yeah, okay. And I've just got a couple more.
Struggling to hear that section numbers.
So SWS1 has been deleted
Yes.
because Kaiwa Order requested that, and the technical report supported it. In removing the provision, will rainwater storage still be provided for?
Yes, so the SWS1 was the council's attempt to provide certainty around off-the-shelf solutions to stormwater management for small-scale developments. That was the intent behind it. It said, if you do this, you will meet the requirements. That was the intention behind it. In some ways, that was seen as being a little bit inflexible or also unhelpful, and it was, and how that related to SWS2, which referred to other methods around managing stormwater. It was not entirely clear through the standards, and that was one of the key reasons why I decided or recommended to WS1, was because of how it related to S2, and also that it created potentially more problems than it solved in terms of confusion with submissions or submitters.
Okay, great, thank you.
This was just going back to this issue of the energy and infrastructure chapters having precedence or prevailing over other provisions, and it would be helpful if you could provide us with a copy of the drafting solution in the Waimakariri district plan or other plan examples where this might be achieved. But my concern is, what about the objectives and policies of those chapters, and how do they fit with the zone chapters that they apply to, but also further up the line in terms of strategic sections where there is no hierarchy in the strategic objectives in this plan. It's stated quite clearly, but of course there are specific strategic objectives about infrastructure and the like. And I'm not clear in my mind how the use of words like different chapters prevailing or taking precedence apply to their related objectives and policies.
Sure. So, yes, understood. And I've attempted to reference back to the zone objectives and policies in the EI policy by saying have regard to or take into account or whatever the phraseology is, and there's some submissions on that as well. Because I did think there was value in still referencing back to those so that those matters are considered. But generally, the zone provisions don't cover infrastructure. So they're either going to be silent on it or potentially they're going to be in conflict with. And the anticipated developments that occur within the zones usually, almost or always, require infrastructure to be associated with those activities, even though they're not expressly provided in zone chapters. So it is a challenge how to then provide for infrastructure when they're not expressly identified and provided for in the zones, and you've got those catch-all rules which say anything not covered is discretionary, but at the same time not creating an unintended issue by having that precedence approach. It is quite a delicate balance, and does need to be worked through with each of the specific chapters. So at the moment, the approach is that the district-wide chapters stand on their own, including sensitive environment chapters, but just the zones are ones which are subjugated, I guess, in terms of another word, to the EI chapter.
So if there is a conflict between the objectives and policies of infrastructure versus the zone,
Yes. The EI provisions would prevail, or you give them greater weight, or they'd prevail, yes. That's the intent.
is there a way to achieve that, though, by acknowledging the importance of infrastructure within the zone chapters themselves,
Yes.
rather than, it's just the use of the precedents or prevail, to me, it lends itself to arguments about which policies and objectives and policies trump others. And if there were competing or significant issues, whether it's Indigenous biodiversity, whether it's sites of significance, sites and areas of significance to Māori, how that tension is addressed through the planning framework. Is it simply the case that, well, infrastructure prevails, end of story, or is there some greater analysis that needs to occur?
Well, for those district-wide provisions like sites and areas of significance to Māori or Indigenous biodiversity, it doesn't prevail over those chapters. It's just the zone provisions. Yes.
I think it would be helpful. I am really interested in this Waimakariri approach, because have I understood you correctly? That's effectively sort of retrofitting the zone provisions with that cross-reference rather than prevail. Is it just a drafting?
Yes.
Prevailing over the other. It's just that that zone does actually contemplate infrastructure, and here are the rules and that you go to that address that.
Well, yes, or any other district-wide chapter or provisions. I mean, I drafted that catch-all rule for each of the zone provisions early on in development of that district plan, and said, well, we don't want to capture those automatically, so let's exclude something that's expressly provided for in a district-wide chapter. That was the intent of that. That approach could be adopted.
So does the Waimakariri example then go on to address the objectives and policies and how they relate? Or is it just a list of rules that apply?
So those are the zone rules specifically. There are also statements elsewhere in the plan around how infrastructure relates to other provisions. It's not as significant as what we're proposing here because the rules matter has already been dealt with.
And the issue of the Redruth landfill site as well, just picking up on, you mentioned that it could be addressed in another way. What are you contemplating in that sense, that there was a specific set of rules or provisions that would apply just to the Redruth landfill, as an alternative to adding them in or catching them in the definition of regional infrastructure?
Yeah, I'd probably put it in the relevant zone rule that it sits in. Would be probably the easiest, simplest approach.
And do you have a preference?
That actually would be my preference if there's scope within the submissions. Yep.
Okay, thank you. Right, I have no further questions for you. I think that just a follow-up from Commissioner Solomon.
Sorry, this is just about the WSP report. In there on page 5, it refers to a tailwater condition. What is a tailwater condition?
Sorry, Commissioner. I missed the reference again. Sorry.
In the WSP report on page 5, it refers to a tailwater condition. What is a tailwater condition?
Perhaps Ms Dudson's available to answer that, and given that it's her report. Is she online? Yes. Did you hear that question, Ms Dudson, or do you need it repeated?
I can't hear you.
Can you hear us?
Yep.
We can't hear you.
Maybe I
I
could.
don't know what that is.
Right.
Tailwater. I think it's probably a
Two questions.
typo.
Why don't we take a break
Okay,
now, and you can perhaps get that question answered.
Got
over
two
tea break.
questions, yeah.
Yeah. Did you have another
Yes,
question?
I do.
Perhaps ask the question, and
Okay.
Mr Willis can take a note, and we can see if we can resolve the technology over the break.
So the first question is around the tailwater condition and what that means. And the second one is, why is it that by increasing the impervious surface area from 30 square metres to 500 square metres, does it require a lesser standard of treatment? I didn't quite understand that.
And just to help us out, Commissioner, that's in relation to...
On page 9 of the WSP report,
Thank you.
why is it that by increasing the impervious surface area from 30 square metres to 500 square metres, does it require a lesser standard of treatment?
Thank you.
Well, we'll take a break now, morning tea break for 15 minutes, and resume, and perhaps if you could clarify that and we'll resolve the technology, that'd be great.
Sorry, Madam Chair, could I just double check? Could we release Mr Collins? No.
It's just, I've got one transport question, whoever you're I'm not sure if that was Mr Collins or not, from Abley.
Yes, that's
Okay.
right, yeah.
And my simple question was, I wanted to know, had he been to the Fonterra site in
Okay.
Timaru?
We'll come back to you on that as well, and we'll wait to release the others until after the break.
I have one for stormwater, and that was understanding what the key difference is between impervious surfaces in trafficked hard stand areas. Yeah, the key difference there, because there's been a suggested change. Thank you.
If there are more substantive questions, we can come back after the break, but if you just... Okay. Yeah, all right. Not wanting to rush anyone, we've got a lot to get through this morning. Okay, thank you. We'll break for 15 minutes. Okay, we back online? Thank you. Welcome back. Ms. Vila, just in terms of just housekeeping, just in timing this morning, we suspect that we may not get through all of the Council 42A reports before the lunch break, but the panel's preference is to not disrupt the submitters. So if it's okay with you, to the extent that we haven't managed to get through your 42A by lunch, we'll return to them at the end of the scheduled submitters today. We've got a bit of extra time in the schedule, if that works okay for you.
Yes, I think the only thing I should just point out, is that Mr McLennan's only available. I mentioned that in my legal submission, mediation in Dunedin for the rest of the week. So I know that you said today, but just to signal availability.
We'll do our best to get through him today.
We could always bump him forward.
And we can bump him forward.
And the other thing just to mention, and this will flick Mr Boyes to the end probably, but Mr Henry has unexpectedly been called to the High Court for the Ngāi Tahu freshwater case. So he's been sort of released by his legal team to come today because it's important to him, but he is only available today as well. Otherwise we had intended to have him here for the whole thing.
It's absolutely fine, and it may be, and it's up to Mr Henry and Ms White, really, we'd be happy to hear Mr Henry before Ms White if that works better, just to make sure that he has got through if that's...
Yep, I think my suggestion would be let's move to Ms White and Mr Henry next, and then see how we're going for timing, and then we can move Mr McLennan forward, and Mr Boyes can come back if necessary tomorrow.
Thank you for that. Right, so we had a couple of questions to answer before we move to Ms White.
Thank you, Madam Chair. I mean, what I noted down was that there were 3 questions around WSP's report for stormwater, and a question for Mr Collins around Clandeboye, so we could do that. Although Mr Collins has popped up on the screen, maybe we could do his one first, because I think it's an easy answer, and then we'll move on to stormwater.
Thank you.
So Mr Collins, I think it was a question around whether or not you'd been to the Clandeboye site. I believe that was the question.
Good morning, panel. Just confirming you can hear me.
Very quietly.
Very quietly,
Yes.
if we can increase the...
I'll speak up then. No, I haven't been to the Clandeboye site as part of my review of the Fonterra submission.
Okay, thank you, Ms Collins. Right, with no further questions on that, we'll move to Ms Dudson to respond to those 3 questions around stormwater, and I made a note of those. Did you make a note of those, Ms Dudson?
I've got 2. Maybe the second question might be in 2 parts, so just
Sure.
bring out if I've missed anything.
Yep, so the first one was around what is
The tailwater?
the tailwater condition. The second one was around 30 metres squared versus 500 metres squared on page 9 of the WSP report, and the third one was around impervious surfaces versus traffic hardstanding.
Oh, yes, sorry.
Yes.
Yes, yep.
Thank you.
Absolutely. All right. For tailwater, I guess the easiest way to explain that is if you imagine water flowing out of the end of a pipe that's open to the air versus, say, if a tide comes in or there's a high water level in a stream or something like that. So the pipe has a tailwater condition. So the level of the water at the end of the pipe is higher than the top of the pipe.
Thank you for that. I understand perfectly now.
Great. In terms of the 30 to 500 square metres and the trafficked hardstand, they're sort of combined. I'll talk about those together. When we're talking about, so this particular response in relation to SWS4, it's around the stormwater treatment and treatment of stormwater runoff. We're mainly concerned about the types of contaminants that build up on the surfaces, and the main contributors to that in a stormwater sense are come from trafficked hardstand. We sort of, I guess, in the terms of, we deal with roofs slightly separately because there's a separate, there was a separate rule around building materials, particularly for roofing. So in terms of impervious surfaces, it's the trafficked hardstand that is a higher generating contaminant. So it's things like wear and tear from tyres, brake pads, exhausts and things like that. That's the predominant source of contaminants on impervious surfaces, and so that was where the distinction comes between trafficked hardstand versus all hardstand, and where you would want to focus the stormwater treatment. And in terms of the treatment, the reason for suggesting that a lower standard of treatment might be more sensible for smaller areas is it was specifically in response to the standards, which set quite a high threshold for what you can achieve, and a lot of the sort of best practice proprietary devices on the market will be less effective on small areas. They're kind of designed for larger areas. They're not really designed for small sort of 30 square metre type catchment areas, and because of the nature of the way they work, they won't be effective at removing contaminants to the level in the standards. Potentially, some of that goes away if we're considering not having the standards specifically in the plan, and it's more dealt with on a risk-based approach.
Thank you for that.
Does that make sense?
Yes, it does. Thank you.
Good. Thank you, Commissioners.
Very much.
Just to confirm, Madam Chair, are we able to now release Mr Lester, Ms Ratahi, Mr Collins and Ms Dudson? Thank you. In that case, we can move to Ms White. Would you prefer to hear first from Ms White, and then we can move to Mr Henry after that?
Hands.
I think Ms White first, because she covers sort of broader.
The whole scene. And then,
that's right.
Yeah, thank you.
And I'll just bring Mr Hackart up to the front table too, in case it's for him. Thank you.
Good morning, everyone. So I'll just run briefly, I think, through my summary statement. So I'll start just by highlighting that in paragraph 3, I've just outlined there the key matters raised in submissions. So that is essentially just those that were identified in the 42A report. So moving to paragraph 4, the following are those that I guess appear to remain outstanding, or at least in part, having looked at the evidence lodged. And so they relate to the justification for the extent of SASM's changes to the changes requested to mapping, particularly the size of SASMs which relate to Māori rock art. Concerns still expressed obviously about the consultation process, clarity on the values of each SASM and the threats to those values, I guess continued concerns about relationship and engagement between landowners and Runanga around the sites and areas of significance. Concerns about the impacts of rules, but I note with respect to the evidence, it appears to mostly be about future potential rules. I think most of the submitters, not all, but most of the submitters seem reasonably confident, at least with the recommended changes. There's still some concerns about the provisional expectation for access across private land, and finally, just in terms of the Māori purpose zone, the extension of provisions to all Māori landowners is still an outstanding matter. Then in paragraph 5, I've just identified issues that were not key issues but are still outstanding and have been raised in evidence. So just inclusion of existing use rights, specific changes to the quarrying rules and the forestry related rules to exclude additional matters, including policy direction relating to subdivisions, cross-referencing to the SASM chapter and other chapters, adding matters of control or discretion to allow consideration of Ngāi Tahu values to specific activities regardless of being located in an SASM or not. adding reference to Rakatirataka and Kaitiakitaka in SASM 01, so the objective, specific drafting of one of the policies, and lastly, in terms of the Māori purpose zone, just about that requirement for the size of water tanks. So corrections in paragraph 6, I've just noted there was an error in my report. That's simply, the recommendation is correct, it was just simply the Section 32A assessment, I incorrectly referred to something. And then at paragraph 9, I have just outlined there, having read through the evidence, some things that where I would recommend changes. So in terms of the accidental discovery protocol, Ms. Beard for Heritage New Zealand had expressed some residual concerns about that. I've since been in contact with her and we've agreed some wording. So in terms of the reply, there'll be some slight amendments made to that that she's agreed, that we've agreed. In terms of SASM P5 and also SASM P7, just an update to refer to the National Grid policy that has been recommended through the EI chapter. So again, that's just ensuring integration across the plan. It's referring to both policies. Adding reference to the benefits of regionally significant infrastructure to the matters of discretion. So I've just agreed with the evidence there around the reason for that. In D there, I have recommended that a note regarding public access is added to the introduction to the SASM chapter. I've indicated that I don't think that such a note is necessary. It is what it is. But I therefore don't see any harm in including it. And I also had quite a think about, well, this will apply across the plan generally, so does it need to actually sit in this chapter? But I note that there was quite a lot of angst in the submissions around this, and also this chapter does refer to and talk about access. So I think on balance that just having a note essentially in the introductory section around the fact that it, that private property rights still exist and the access isn't guaranteed along those lines, I think might just assist with being very clear that the particularly in terms of maintaining and enhancing access, that's not overriding anything else. Para E, I've talked about adding matters of control or discretion to activities identified by Ms. Poole. So I would just note this morning you obviously had a discussion with Mr. Willis around that as well. I think it's probably fair to say that I looked at those without looking too in depth at the rule when I said, yeah, that seems about right. And I think having heard from Mr. Willis, I probably need to have a discussion with him, and I think we'll do that in the reply. But I think in principle, I'm comfortable in principle with where there is a rule where that might be an appropriate thing to consider and it's not otherwise addressed, then that would be okay. I think what Mr. Willis raised is actually these might not be the right rules though. So just in paragraph F, another matter that I've agreed with Ms. Poole on, so it's just reverting to the original wording in SASM P5. The wording I'd previously recommended that it be changed, but that was in response to a submission from Transpower, and in the way that policy has been redrafted, those clauses wouldn't actually apply to infrastructure. So that's why I've agreed with Ms. Poole that it can revert back, essentially, because the concern raised by the submitter in terms of infrastructure is otherwise addressed by referring to the infrastructure policies more specifically. And G, just talking about adding a further matter of discretion, so similar sort of thing about adding matter of discretion. So that specific standard is about the depth of earthworks, and I agree with Ms. Poole that Mr. Henry's evidence was when you go deeper than you have before type thing. So I agree that that's an appropriate matter, regardless of whether it's in an SASM or not. And just in paragraph H, that's a minor amendment, so just amending the rule that relates to forestry to refer to commercial forestry. That just reflects that the NES for plantation forestry is now the NES for commercial forestry, and so therefore it would manage all aspects of forestry that are managed under that, which the concern of the submitter was around the non-exotic, the stuff that's basically planted for carbon purposes, because the issue is with the planting, so it just covers that. And lastly, just on the evidence around the water supply for the Māori purpose zone, I'm now comfortable with reducing that to the volume sought by the submitter on the basis that they provided some evidence as to, one, that being a suitable amount, and two, the concerns about the impact that it would have having to provide a higher amount.
Thank you, Ms White. Interested in paragraph 8.226 of section 42A, where you're talking about the rationale and justification for the size of the SASM rock art buffer. And you've referenced the McKenzie process in terms of the reduction of that to 250 as opposed to 300. And I understand that that was in terms of the matters controlled by that district plan in McKenzie rather than the regional plan. So in the context of this district plan, what are the matters controlled in this context that may trigger the consent?
Yeah. So they are different, and I think that is important. So I think my recommendation has been, I guess, around consistency across the two districts. But I also recognise that the plans are managing different things, and there's reasons for that. I think that, if I'm not mistaken, where the recommendations have got to in terms of the rules in the SASM chapter, the key one is that woodlots and plantation forestry, which will become commercial forestry, in the Māori rock art overlays, that's a non-complying activity. So that's where the size of that area really kicks in terms of the rules. What it will also mean is where a consent is triggered in other chapters, where I've recommended that a matter of discretion is added, it will also kick in there. So, for example, in the earthworks chapter, if a consent was triggered because a rule in the earthworks chapter was breached, then that would result in consideration of the impact in that wider area, so in the entire mapped area, not in a smaller area. So it would have an impact on where you would consider the values of the SASM in that consent process. Yep.
Thank you. And when you say consideration of, you mean a consent required and then an assessment of the impact of those effects?
Yes. So I've recommended quite a lot of changes, I guess, to the earthworks rule in this chapter, and for many reasons, but one of the reasons being where you have the district-wide earthworks rule appropriately, I suppose, act as a trigger point. It's okay to rely on that at a rule level, so rather than duplicate rules or have slightly different standards, it's essentially saying when you otherwise require a resource consent, you can consider the effects on the values of the SASMs. Yep.
Thank you. And I'm aware in the McKenzie situation, and you've obviously, because you're relying on, to a certain extent, have been informed through the McKenzie process. I'm just kind of testing some of that here. In relation to the Rama mapping and the sub-regions in the Canterbury Regional Policy Statement, how does that mapping apply here, and is there any duplication that we need to be aware of in terms of that consenting framework?
Yeah, so firstly, apologies, because in the 42A report, I think it would have been useful if I'd referred to the regional plan and I omitted it. So I have since looked at that. So there's a distinction, I think, between the McKenzie plan and this plan, in that, as I understand it, there are Māori rock art sites identified and mapped in the regional plan, And I believe, but I'd like to double check, that they are based on that 300. So what was notified in the proposed plan, as I understand it, but I would like to double check, it is effectively the same mapping as contained in the regional plan for those Māori rock art protection areas. The rules in the regional plan manage irrigation in the area, so in effect irrigation within 300 metres of those sites. In the Mackenzie area, those sites were not identified in the regional plan, and therefore there wasn't a rule. And so the Mackenzie plan, a similar sort of vein of thought, it had a rule that was targeted. It did have a plantation forestry one too, but it also had an irrigation rule because in effect there was a gap because that wasn't in the regional plan. So that is a difference here in that we don't have that gap with irrigation, and there isn't a rule in the proposed Timaru plan around irrigation because that is addressed through the regional plan. Yeah. So in my opinion, I think that it's the plantation forestry, which is related again to the kind of the impact that forestry has on the water environment in those areas and the impact that can then have on the rock art. And then I think it's also about the wider recognition that the tangible thing that is there is the rock art, but actually the fact that the rock art is there is actually a symbol of the importance of these areas to mana whenua. So it's almost like I described it to someone as you're having a sign, and the sign describes kind of what you can see in the landscape around you, but the rock art itself is just the sign, it's not the landscape. So I think that's the other thing that the wider mapping does, is it says it's not just the rock art itself, but it's the fact that that expresses the historical association and the fact that these were part of the area that mana whenua traversed and lived in and travelled through and gathered kai and all those sorts of things. So it's not just the rock art, it's actually that association, the relationship with that area as a whole.
Thank you, that's been really helpful, just to understand the relationship of that with the Mackenzie, but also the regional regulations. In relation to the submission from Lisa Swartz, the submitter makes mention of a QE2 open space covenant in place to protect the exact location of rock art. Could you describe to me your understanding of a QE2, the purpose of that instrument, and as compared to a district plan regulation?
I'm not very familiar with them, but at a high level, my understanding is that they are more based on conservation values. So the only thing I guess I would say about that is I can see with a QE2 covenant the relationship that you might have with the like SNAs, the identification of SNAs. I think that's a different thing, I think, to what makes those areas significant to mana whenua. And so I don't think you can assume that just because that is the area that is effectively left in protection, that that's the only area that is therefore significant that iwi have a relationship with.
Thank you. That's my understanding. I just wanted to kind of clarify that there's quite a different instrument through different legislation and have a different purpose. Thank you. With the RDRML submission and the legal subs by Ms Ham, I'm not I didn't see it covered in your summary, but I may have missed it. They submit that it would be impractical to apply ADP that applies to a rock weir related to earthworks in a riverbed, just in terms of the actual practical constraints about trying to follow an ADR on a riverbed. Have you considered that?
The short answer is no, I haven't specifically thought about that. So my summary was prepared, I'd looked at the evidence but not any legal submissions. I think they were lodged about the same time. I am conscious as well that the 42A report was released before the hearing D interim reply, and I think as a result of that, the way that the plan deals with activities in riverbeds, I had come to a conclusion that in respect to the chapters dealt with in hearing D, that it might be appropriate to exclude their application. I suspect that I might come to a similar conclusion here with respect to these rules, for the same reasons that I need to have a specific look at how so exactly like I did for hearing D, have a look at the controls in the regional plan and whether or not they sufficiently manage essentially the effects on the values to mana whenua through that process, such that you don't need to have a double dipping. So again, it wouldn't, and I think this is the same for that submitter with that hearing. I don't agree with removing the overlay from the riverbed because I think it provides a helpful signal of the importance, but more that the rule framework may not need to be applied.
Thank you very much. No further questions.
Kia ora. I do have quite a few questions, but one has really been answered in part about the relevance of the Mackenzie hearing and the rock art buffer area. But I say in part because I wasn't actually aware that there were already some restrictions here in terms of the regional plan restricting irrigation and water extraction already in SESMs. And so I think it would be really helpful to better understand what restrictions already apply. Excuse me. Because then that means we can really focus here, and it's more for Mr. Henry's evidence to go, well, what are the cultural values and the impacts of what's proposed here, which is earthworks and mining and quarrying and plantation forestry? What are the impacts of those activities? So thank you for providing that, but it would be helpful to know a little bit more about the irrigation and water bore, as potentially as a reply matter.
Yeah. So I mean, I can answer that now, but I can also, I wonder if it's more use if I actually set it out in the interim reply, just so that you have the real references and things like that.
Yeah, I think there'll be a similar sort of gap analysis that when we've had conversations around the ONL.
Yeah, so I think that possibly the difference in this instance is that, as I understand it, this plan as notified didn't actually seek to duplicate those matters. So it has it's mapped them in the same manner, and it manages activities in effectively that 300 metre area, which are irrigation, the impounding of water, and there are also some requirements in farm environment plans that if you have the rock art protection site, if you're within that area, that you have to essentially include in your farm environment plan what actions you're taking basically to assist in the protection of that. So it doesn't, again, from my read of it, it doesn't deal with that forestry question, and it I don't think it has the same level of control around earthworks, so it does where it's earthworks for impounding water, but I think not for earthworks more generally. But I can provide that in more detail.
And would that mean that if we're going with 10 or 250 or whatever it is for earthworks and forestry, then, but the irrigation and the water extraction is 300, then there's going to be, different measures for different activities?
Yes, that's right. So, there's obviously some consistency with the mapping as it was notified and as is contained in the regional plan. So you would have that level of consistency in terms of having the same areas identified. And that's probably, to be honest, that's my preference. I think that just makes life a little bit simpler. I think there are, in terms of then, I think what is actually important then is what are the effects that you're seeking to manage in order to protect those values and that ongoing relationship with those areas. And if I've understood correctly from the submitters, I think they're comfortable with the recommendations in relation to this plan that have been made around that. There are you're right, you could alternatively reduce the mapped area in this plan and have specific rules that, for example, say within 300 metres plantation forestry. And the effect of the rules wouldn't change. What would change is the actual mapped area. And it might be something that Mr. Henry wants to talk about further, but I think my understanding of that is that the thing about mapping the wider area is it tells more of that story about the association, not just with that site that you can see, but with that area as a whole, and the fact that mana whenua in this district, moved through the district, weren't sort of more sedentary. That's not the right word. And it, I guess, it tells that story. But yeah, certainly, I think you can skin the cat two ways in terms of map differently, have a different rule framework, but essentially have the same effect. But then you wouldn't have, I think if you did it that way, you wouldn't have that consistency with the regional plan about what is mapped. And you probably, I think there's potential that you'd lose the actual significance of the wider area, not just where the actual writing on the wall is. Yeah.
Yep, that makes sense. And there may also be a gap where the regional plan identifies sites that might be different sites, because I was aware that at paragraph 37 of Mr. Henry's evidence, he says that there were some Māori rock art sites missing and that there's going to be some type of agreement on how they are to be mapped moving forward.
Now, Mr. Henry can correct me if I'm wrong, but I think that they are also missing from the regional plan. So I think that through I wasn't involved in that, but my understanding that I've heard from other people through that, it was a Plan Change 7 to the regional plan process. My understanding is that didn't incorporate all of the Māori rock art sites. So that process would probably have to be a dual process in terms of if they were added to the... So it's not a gap, sorry, it is a gap, but it's a gap that currently exists with respect to the regional plan as well. So the two plans currently line up, but obviously there's a gap therefore in both.
And how's that proposed to be addressed for here?
So it's not, as my understanding. So it hasn't been proposed through this plan to add those additional sites. And I wasn't involved in the background to it, so I'm not sure of the rationale for that. So what has been notified is essentially the same as the regional plan currently.
Right, okay, thank you. So my next question is around the objective 1, where Te Rūnanga Ngāi Tahu evidence is to include rangatiratanga and kaitiakitanga. I'm using two different, kaitiakitanga and rangatiratanga for this area. And she actually mapped through why both are important, like why one gives effect to Section 6 and why some actually then gives effect to the policies. So given that evidence, would you consider including both in that objective 1?
I would need to give it some more thought. I'd also need to consider if those terms are defined in the plan as well. I think it's important to remember that this is the objective which sets out kind of what is sought, but it has to be essentially implemented through the rest of the provisions in the plan. And I know that some other plans have therefore steered away from using the term rangatiratanga because that is usually something that can't actually be implemented through the district plan where the decision maker is ultimately the council. So I think I'd want to think about that some more. The other thing is I think in the original submission it hadn't been clear to me what change was sought, because I think the submission sought retention of notified. So I've only had a short window of time, I guess, to try and think about that. So yeah, I haven't, yeah, my initial response is that I'd like to think about it a little bit further, and I'd just be cautious, I think, about is that actually what is given effect to through the plan?
Yep. Okay, thank you. Oh, it is. Okay, great. Glossary. Right. So my next question's about the earthworks rule, Rule 1, and I was just finding it a little bit challenging to understand the difference. So you've got subclause 1 that deals with wahi tupuna and wahi tauka, and then subclause 2 is now removed, and subclause 3 is for wahi tapu. And it seems to me that subclause 1, or subclause 3 that relates to wahi tapu is now a lot more permissive of earthworks than subclause 1, yet it's wahi tapu sites which are considered sacred. So why would earthworks be more permitted in those sites?
So if you look at per 2 of subclause 3, then within the rural-based wahi tapu sites, the only things that are permitted are maintenance, repair, replacement type activities. So all other earthworks in those rural-based wahi tapu sites would be automatically require consent. So that's more restrictive than in the other areas where there's a I think my recollection is there's a threshold for the volume of earthworks. So what you don't get in those ones is that is the benefit of a volume. It essentially says if you're not maintaining something that's already there, then it's a consent process. In the urban areas, you're right, it's slightly more permissive, and the rationale for that is that those are areas where you've already obviously had earthworks and disturbance of land, and the volumes in the zone, in the earthworks chapter, but per zone, particularly in the residential area, are, for example, quite low. So there isn't a consent requirement in this chapter, but larger scale earthworks in those areas. So if someone's so it wouldn't capture someone, for example, that's doing foundations for a house, but if someone was doing a subdivision of 4 lots or something, then it would likely trigger the requirement. And there's a matter of discretion that's recommended to be added that specifically allows for consideration of the SASM. So that's the kind of the rationale. I appreciate that it looks more permissive on the surface, but I think when you dig in there, you're either not because you are in the rural area, or you're in an urban area where you're subject to tighter controls on earthworks, irrespective.
Yes, and I think your evidence, Mr Henry's evidence, was to make that concession for the urban environment together. Yep, okay, that's helpful. Then when I looked at the earthworks rule, those rules to really see, well, what's more permissive or what's really being restricted. And when you do a side-by-side of earthworks rules to the SASM rules, there doesn't seem to be a lot more restrictions for SASM. Like, what are the main restrictions comparatively?
So I think it's that the key one is that volume control, and this is so bearing in mind two things. One is the recommended approach is essentially that you rely on the rules in the earthworks chapter in those urban zones. So in effect, you don't have a lesser standard or another rule in the SASM chapter. So you're relying on those to set your permitted activity level, and then if you require a consent, there's a consideration of the impact on SASM values. Then in the rural areas, the key thing is that the volume comes down, and that in the earthworks chapter, if I recall correctly, there isn't a volume for particular types of earthworks, and I think there's a definition that it's related to, which I think is, I'm going to find it, but I think it was ancillary.
Ancillary, but limited to 2,000 square metres.
Yes, so but other earthworks, Yeah, so for any, so earthworks for any primary production activity, there's no limit. And for ancillary rural earthworks, as that's defined, there is no limit. So you have that 2,000 square metre limit, but that's only for other activities. So the key restriction, therefore, the restriction that is then applied through the SASM chapter is to say, no, actually, in these areas, we do want a volume applying to those types of activities as well. We want a general 2,000 square metre threshold. So that's essentially, it's the lowering the volume, sorry, it's not a volume, it's a square metre, an area, lowering the area that's permitted where it's within an SASM.
That's really helpful because I think the questions that will be asked of the submitters is how this actually impacts on them, like how will this impact on their day-to-day use of their properties? I did get a little bit confused as I was trying to look at each of the submitters' property and go, well, what applies here? And in some cases, they're actually both. They could be wahitapu and wahitoka. So that would be a little bit confusing to be able to manage, but I guess it's very, very, at that point, site-specific. My other question for Rule 1 was around why has it, within the definition of, like, cultivation is exempt from earthworks, so that means that within SASMs there's no restrictions on cultivation. Why is that the case? Like, why is cultivation fine but earthworks not? What's the difference?
So I haven't considered that specifically because that's, in effect, the rule is notified that was the case, and I don't think anyone has sought for it to be extended so that it does apply to cultivation. I didn't draft this chapter, so I'm not sure if when it was drafted specific thought was given to that. I know that when I've discussed these rules with the AEC planners, they had indicated to me that there was less concern about things like cultivation because that's usually, in essence, disturbing earth that's already been disturbed. So it's the earthworks where the ground hasn't been dug up before, it's deeper, it's not just that surface level that are of greater concern.
Okay, great, thank you. Some of my other questions are quite technical, so they could just be asked later. But I do have just a couple of questions on the Māori purpose zone. And the first one, well, actually I only have one now because you've come back on the 30 litre, so that's fine. This is about Rule 22, and I wanted to kind of understand the genesis of Rule 22, which expressly excludes brothels and licensed premises. And I wanted to know, was that, because it's not mentioned in any other zone, so was that incorporated at the request of the working group?
You're really stretching my memory. So I seem to recall that in the operative plan, there were some rules around that, and that was in other zones. So obviously the Māori purpose zone isn't in the operative plan, but there were some rules around that. I do think that there was a discussion that I was part of where the rule framework was kind of discussed with the working group. And I think it was, and it might be a question that Mr. Henry can answer too, but my vague recollection is that these were the type of activities that were seen as effectively not being appropriate in any instance, given the significance of those areas, and so that's why they were specifically listed out. But I think that did stem from the fact that the operative plan, in some cases, did signal those, single out those activities.
Yeah, it just sticks out a little bit when it's been removed from every other zone, but specific to the zone, made it just stick out. But there's no submission on this?
No, I don't.
No. So that's my questions, thank you.
I just have a couple of technical questions that I'll put in a...
Thank you. I've just got a couple of questions I was hoping you can help me sort through, just around the justifications of the extent of some of the SASMs. I acknowledge and accept that Timaru District Council has probably, the lack of consultation has caused angst or anxiety, which is some of the wording that is used. And I think that Timaru District Council has acknowledged that, and I think lessons can be learned. I'm a big fan of consultation and collaboration. But my question is just around some of the submissions is talking about that the proposed plan is out of step with some of the other regulatory approaches. For example, your Canterbury Land and Water Regional Plan, where the base is that has that 50-metre buffer areas. And then in some of the reports I've read that basically the 250 metre or 300 metre setback is basically been a desktop calculation. And so my question is, in your experience or the work that you've carried out, can we have different setbacks across the district that reflect the particular area in question where the rock art is presented, or is it just one map for all, which is what obviously this approach is? So is there any other examples where, an actual land-based consultation has occurred and appropriate setbacks have been carried out for that particular zone or area?
Sorry, I'm not sure that I quite understood the question, because I think this
question is, I'll reframe, is we've got one rule for all currently.
Got one what, sorry?
One rule for all. Our overlay is the same across all areas.
Is this to do with rock art?
Yes.
Okay, yeah.
So in your experience, have other district plans actually consulted with landowners and done appropriate mapping for that particular area?
So the only other plan that I've been involved with is the Mackenzie District Plan, which, as notified, had the same basically as Timaru, the same approach, the 300 metre buffer, which was reduced through that decision to essentially 250 metres. I haven't been involved in other plans, but I would also probably stress that in this instance we do have that essentially those areas identified, or some of the areas identified and mapped through the Canterbury Regional Plan already. So there is that kind of, consistency there. That I'm not sure if Mr. Henry has other examples that he could provide either.
No, just that some of the consents that have come in, there has been consultation, and they have been reduced by the rock art people and the farmers. Yeah. So there is that leeway of doing things. Just depends on what the actually activity is. And
that's actually probably a really good point. Is that the maps essentially act as a trigger to the activities that the rules apply to. It's not a prohibition, and that's probably a good example of where that actually allows Runanga to input into it, and for some technical advice to be received on a specific area and wind conditions and climate to say, and I think that is probably a good point, that there is a difference between a setback that might be applied as a hard and fast, as a condition of a consent, as opposed to what area is mapped in a district plan and a consent is triggered within.
Yes, morning Ms White. Does the District Council control water conveyance, drainage and those types of activities, like the shallow ripping of wet areas to enable water to dissipate into topsoil layer, the contouring to enable flows, avoid ponding, backfilling? Does the Council control any of those?
I'd probably have to potentially check the earthworks chapter, but not where it's a discharge, essentially, which is managed under the regional council.
Yeah, no, it was really around the matters of drainage and water conveyance. I know what the regional council controls. I just want to know what the district council controls, what activities they control that occur around the rock art sites.
So it would only be to the extent that those fall within the definition of earthworks. So essentially, if they don't fall within the definition of earthworks, then they wouldn't be managed in.
So things like installing culverts and ponding and filtering and buffer areas is all a council activity.
No, so if it involves the take and use of water or discharge, then that would be regional. If it's within the definition of earthworks, which I think would cover some of the stuff that you're talking about in terms of cutting a drainage channel, then it would also be managed under the district council.
Great, thank you. Going back to the cross-referencing. Ms Pull advises at paragraph 37 of her evidence that the Section 42 Officer for Historic Heritage chapter recommends a cross-reference to be included, informing plan users of the SASM chapter that both historic heritage and SASM chapters are relevant consideration. What is the protocol or rationale for when to use cross-referencing, and has it been used in a consistent way across the plan?
I probably can't answer that without looking across the plan in depth. My understanding of that recommendation was it was quite specific because of the particular way that those chapters interrelate, and I think that that's different to what some submitters have sought in terms of a more general cross-reference just across the plan more generally. I think that's probably a good example of where those two chapters do need to be read in conjunction with each other in terms of how they give effect to Section 6E of the RMA. I probably can't give you a definitive answer as to...
a question really to answer. Okay, I'll just go on to my next one. So again, this is again another question about cross-referencing. Would you agree that the ordinary layperson would clearly understand a cross-reference that says has the potential to impact on cultural values can be better understood by lay people, some of whom are the sources of the socialised concern identified in her paragraph 43, is more helpful than relying on the explanation contained in the relationship between different spatial layers that does not explicitly say has the potential to affect cultural values?
Sorry, I didn't...
So sorry, that was a long, convoluted question. What I'm asking is, would it be easier, would it be better for plan users who are ordinary lay people to have something simple to cross-reference to, as opposed to reading the explanation in the relationship between different spatial layers? Because I've read that explanation and it didn't tell me, I'm not a planner though, but it doesn't tell me to refer to anything about cultural.
I think it's hard for me to answer that question because it's kind of an abstract question, and I think in terms of if there was a specific example of where I could potentially answer a question about where a specific cross-reference might be useful, but I think at a high level my response would be that the how the plan works section is generally setting out the way that the the plan is to be read in terms of how the zone chapters relate to the district-wide chapters and how the district-wide chapters relate to each other and that sort of thing. And as a general principle, I don't think there's a need throughout the rest of the chapters to refer across to other chapters where that is the case. I think there are some examples where there might be specific ways that two chapters interrelate, where having some more explanation in that chapter would be useful, but that would have to be considered really, I think, on a case-by-case basis. But certainly my preference would be that not to have those sort of generic ones, and certainly not to have a reference to particular chapters just across the whole plan. The other thing, I guess, to remember is that when a plan user would also be consulting the planning maps, and so the planning maps would identify for a particular site that they're interested in all of the, the zone as well as the overlays. So I think that provides a trigger to say, oh, this is a rural zone, but it also has an SASM and there's a bit of an ONL here too. That provides a sort of a signpost, I think, to look at those chapters that each of those overlays or zones relate to as well.
That makes sense, thank you. Just on your summary statement, where to replace the Trespass Act, and you've recommended to place it in the SASMs. Would not the public access chapter be more appropriate?
So I haven't considered it with respect to the public access chapter, and it could be that a note might be appropriate. I think I was particularly thinking about the fact that this chapter does talk about access, that does talk about maintaining existing access and encouraging additional access basically to these areas. And a lot of the submitters, I guess, have raised concerns about that. And my understanding is that in the 42A I've said this, this doesn't override the laws around access. And so the provisions don't change in terms of they don't override that. But I think that in this chapter, because of that concern, having a note around that will assist in people coming to the chapter who, for example, haven't read this section in future, who aren't part of this process and haven't read the 42A report. It's a sort of a clear indication there that in reading those provisions, that they don't override, I guess, that general legal framework. So that was my rationale for having it in this chapter. It's entirely possible that could be appropriate for the public access chapter too, but I think from my perspective it was because of the concerns that have been raised around the provisions in this chapter.
Okay, thank you. Just my last one. This is about practicable versus possible. Have you considered where else practicable has been used throughout the plan to see if it weakens those provisions?
No, I haven't. And that would probably be a question for the authors or the 42A officers for those chapters. But I think that the concern that was raised by Ms. Poole in her evidence was that it had weakened those provisions, but I think the point she was making is that those provisions wouldn't apply to infrastructure, which is what that change had responded to, and therefore her view was you were potentially providing a less stringent pathway, I guess, to non-infrastructure activities, which she felt was inappropriate. So I was persuaded by that. Yeah.
Oh, great. Thank you for clarifying that for me. Thank you, that's all.
Ms. White, my question was just in relation to your Appendix 5A and 5B of your 42A report, where you've appended some reports relating to one is guideline for implementing a land-based taonga risk and vulnerability assessment, and specifically 5B for Māori roka and associated freshwater taonga protection. Could you just give me a little bit of context to the when and why those reports were prepared, and I think I picked up, it may have been in your report, that they were considered in the context of the regional plan, land and water plan development, how those reports were treated, whether the findings of those reports were accepted by the commissioners in the regional planning context.
Is there one that I can come back to you on?
Yeah.
I mean, I think I know the answer, but I'd prefer to check.
Yeah, if you could, if I'm correct in my understanding that they may have come up in the regional or been prepared in the context of the land and water plan, I think maybe plan change 7 perhaps. Just if you can provide any extracts from the Commissioner's decision or the 42A reports so that we can just get a little bit of a sense of how they were used and relied upon in that process.
Yeah, I think you're right. I think that is the answer, but I'd just like to check.
Yeah, and added to that, if that is correct and that's how they were used, how you then apply them in the context of the Timaru District Plan, what particular parts of those reports are you drawing on to support your recommendations to us in this process? They were the only questions I had for you at this time. So,
Sorry,
that's right.
just one more. At paragraph 8.5.0, you've got Kāti hui rapas. When staff check the te reo, could they check the use of the letter S in that context? Well, in any context, because there is no letter S in te reo. Could they check to see if, could they comment on the use of S's in te reo for this plan?
So I think there's a submission point from Ngāi Tahu that have sought basically a review of all the te reo that's used across that plan for that exact reason, to fix it.
Yeah, thank you.
Yeah.
Just one more question from me, which in part may have already been answered by Mr. Willis in a response that he gave to some questions, but I'd quite like to sense your take on it. So DOC in their legal subs have, in response to Mr. Willis's recommendations in the EI chapter in terms of recommending the effects hierarchy, in DOC's legal subs, they've used that as an example of there being scope within the plan to include the effects hierarchy approach. And the inference is, well, my interpretation of that, there's an inference there that would be inconsistent with your earlier recommendations in hearing D regarding the NPS-IB. So we've heard from Mr. Willis today that he employed that as a tool as opposed to a specific response to the NPS-IB. What I'm interested in from your perspective is, have you considered that context within this hearing? Does that alter your opinions from hearing D? But does it present an inconsistency in the drafting approach if in one section of the plan you've got an effects hierarchy and then in other sections of the plan that's not a tool that's been employed? Could be a tricky question for you given this is not hearing D, but while we're here.
I think that is a tricky question. And I did have a discussion with Mr. Willis because when he was preparing his hearing E report, he had regard to where I'd got to in hearing D, and he wanted to basically check that he wasn't going down something that was going to be inconsistent with what I said. And I don't think that it's inconsistent because I think what was being specifically asked for in the context of hearing D was giving effect to the specific requirements in the NPS-IB around the effects management hierarchy in that chapter. And I expressed some concerns with that in terms of I didn't think that you could just pick that up and sort of put it in the chapter and fully give effect to it. It was more nuanced than that. I think that that's different to the question that, and I understand Mr. Willis's kind of responding to, which is in managing the effects of infrastructure, is it appropriate to apply an effects management hierarchy? And to which I think he's said yes. I don't think there's a conflict there because I think there's two different questions being asked. And I also don't think it stops that effects management hierarchy being applied with respect to effects on Indigenous biodiversity from infrastructure. It's just what we're not trying to do is to fully give effect to the NPS IB in a way that would kind of just untie how the plan's structured. Yeah.
That's clear. Thanks.
Kia ora koutou. John Arthur Henry is my name. I've got notes of stuff that I've written down here and just going through it. What have we got here? I whakapapa to numerous kaitahu hapu, and today I speak on behalf of Kachi Huirapa o Arowhenua and with the unconditional support of Te Runanga o Ngāi Tahu. Just referring to the SASM and Maori Purpose Zone chapters have come about from central government and what I call as part of the National Planning Standards process, not Kachi Huirapa o Arowhenua. However, and this is important to us, this is the first opportunity that Kachi Huirapa o Arowhenua have had to have these sites recognised, and we're quite happy about this. Arowhenua understands that landowners will bear some costs in some consents, but this is not an Arowhenua process. We are part of it. And we'll go on with all rock art are significant in their own right. For Kachi Huirapa o Arowhenua, the Maori rock art is also part of the wider landscape and needs to be protected and respected. It is not just the art on the rock surface, but the tangible and intangible values located near ancient major trails, freshwater sources and drinking and gathering kai and shelter. Just to put that in context further, the three hapu that travelled up to Lake Pukaki and their hikoi to gather manu, or birds from that lake when they were flappers, they would travel from their hometown or from us, from Waiteroachi in Temuka, and travel up through the whole valley through there, and they'd do the rock art on their travels, and Moiraki would do it the same from there up the Waitaki River, where that's where the rock art is also along their trails. They would travel through to, and each day that they travelled, they'd rest, and where they've rested, that's where the rock art is. And that's why it's significant, is that they would travel to areas where there is food, where they can gather the stuff that they needed on their travels. Weka and other food sources that were in that area. So there is they travel in different areas as well, so that, 1 year so our trails are wide and varied. There's no set thing as has been sort of put forward by Limestone Group or something that, we travel in one way. We travel right across this land. And it's just one of the things, depending on the weather, everything else. They travel up there, they gather their manu, they prepare them in their own fat, and then they'll float them down the Waitaki River on mokahi, or the reed boats, which they'd also gather that stuff from up there in that area, which is, there's not a lot of it left up there as far as the stuff goes, the reeds. Kachi Huirapa whānau are not against farming or development, but we are, through this process, hoping the landowners understand that our people have walked over their lands, we have gathered kai, made clothing, fought battles, painted rock drawings, built paths, named these lands, and washed and prepared bodies for burial and buried our people on these lands, long before Europeans arrived. Our tupuna arrived in the Timaru district about 1,000 years ago. Much of our historic places have been destroyed or now lost. i.e. rock art, has been destroyed with graffiti and also bulldozed by developers who are developing land, and we found out about later that they'd taken pieces of their rock art. What have we got here? Graffiti. Our power sites have been built over in Timaru District. We've got a couple of power sites that have gone now, they're under buildings. Our leaders have had to remove uninvited archaeologists from excavating our power site near the Opihi River. Because of this, and this is important, because of this, our people do not say where the exact sites are, in fear that these sites will be damaged or destroyed, whether by people who are deliberately doing it or by mistake. But anyway, farming practices and building development for housing or factories has possibly destroyed a large amount of our history already. For what Kachihui Rapa or Arowhenua is hoping to achieve from this process is for landowners to understand that these sites are important to our culture and people. We do not want to stop people from farming or developing a site unless it is a burial site. We just ask that Kachihui Rapa or Arowhenua, through Aoraki Environmental Consultancy, becomes part of the solution. So, yeah, that's it from me as far as my statement goes. Cheers.
Good on, Mr. Henry.
Thank you.
I'll see if there are any questions.
Yep. Thank you.
Tēnā koe, Mr. Henry. Thank you for your evidence, which is very helpful, and thank you for sharing your knowledge. I do have two questions. I was interested before when you were talking about your experience in the consent implementation side of the planning regulatory response. Could you tell me a little bit more about that in terms of the consenting processes that you've been aware of and the proposed activity, and how the Rock Art Trust worked together with the landowner and the outcome of that process?
Yes. When we get a consent, we generally send it straight through to the Rock Art people, because they are the experts on it, namely Amanda Simons. She's the curator of, and has also mapped all of the sites and gone around and done all the work with it. We get hold of her and she will write up a report as to, you know, what that activity is too close or whatever. She will write up a report that we respond to. It doesn't always, it's not set in stone, as you say, the different activities that they have or do. It's just a starting point to talk through. So yeah, we have done that. Yep.
And so based on that report and the proposed activity, you'll then be able to see the magnitude of the effect.
Yes.
And how that could be mitigated, and in some occurrences that buffer area can be reduced? Okay.
Yes, it has been.
Yeah,
yes,
okay.
It has already been done. So yeah.
Great, thank you. The question is, in terms of the significance of these sites within this region and this district, are you, in terms of across the Motu nationwide, am I correct that the remaining rock art sites are confined to only a few regions?
I don't know how wide, I'm no expert on it, I don't know how wide rock art is throughout New Zealand at all, but I do know that we are concentrated in this area here, and we've got a large amount of rock art, which is unusual, I suppose.
Yes, I guess that's a good word. There's a high concentration of them, which I guess informs the regulatory response because of that significance of the concentration. Yeah.
Yes, just to elaborate on that, the hikois that used to travel, they ended in around the 1880s when Europeans arrived and fences went up and they weren't allowed to cross the lands. So the practices just died out, and sad to say, of course, because they used to touch up the rock art, and when they journeyed and they seen the site, they would touch it up and then they'd carry on. So yeah, there's that, and the process at the moment is we know that the rock art will deteriorate and will disappear in time, but we want to try and keep it as long as possible. It is significant to us, or should be to everybody else as well. So, yeah.
Kia ora, thank you.
Kia ora, Mr Henry. I have a few questions. My first one is just a follow-up question, which is around engagement and how engagement currently occurs. And in the SASM chapter, there's a policy 2 in here that talks about consultation and engagement with Kati Hurapa. And it's encouraging consultation between the landowner and Kati Hurapa. And what I've seen previously in how engagement ordinarily occurs, it's often between the decision maker, which is the council, and Aoraki Consulting Limited, or one of those regional entities. So how would this policy here, which encourages direct engagement, be implemented, and is that welcomed and encouraged, or what is preferred from a mana whenua perspective?
Mana whenua's perspective, it is, for us, the best practice is to come to AEC because we are the environmental entity that is adjudicated by Arawhenua to deal with the consent processes. The sad part for us is that a lot of this in this plan will go unheeded or unthinly because some of the stuff here doesn't need a consent. So farmers will go ahead and they may destroy an area anyway without consulting us. Because it's one of those things that, and I'm not saying, because there are very good farmers and they like to know what's on their land. But in the first place, the farm implementation plans that used to, was the first thing that was put out. In that, part of that process, they had written in there all of the hapu and areas of Maori, you know what I mean, to go to the maraes and talk about what's on their land. They never did it. They've never come to us, they've never got anything, because they don't want to pay. So the idea of it was that ECAN wanted them to get this process done, so they had a plan. The farm implementation plan was done. So they've got it fast road, and what it was is that they could get a farm implementation plan, and they still do today, by having a consultant, and he signs it. Sometimes they just say there's no what do you call it, any interest at all in Maori on our land. Without coming to us, how do they know? And this is the sad part. That's why I put in here that is the first opportunity we've had to put our mark on the land, which is, we're now in 2025. But still, farming practices will continue and development will continue. Unless it sparks something in the consent process, we'll miss it. And things
it's really helpful because I wasn't sure about if you were encouraging direct landowner engagement, and it seems that you are saying yes, yep. we are welcome.
Understand there will be a cost, obviously, because we are a company, but the fact of the matter is if they come to us early, we can work something out and be, you know.
Yeah, and that's really interesting that you've brought out in evidence that there still seems to be this concern about paying for cultural advice, but less concern probably paying for other types of advice.
They'll pay a consultant to put a farm implementation plan and things like that. And, yeah.
Okay, that's helpful. Now, my next question is about private property rights and the updated summary statement by Ms White, where she says, look, it might be probably cause no harm to point out that people do have private property rights and that people can't enter, you don't have free access everywhere. And I know she was kind of considering whether it should be in the general provisions, because that applies to the entire proposed plans, or whether it should be stated in the SASM chapter directly. And my question to you is, what would be your preference? Because would it be offensive to just say in the SASM chapter, by the way, mana whenua, be mindful that you can't access areas? Or should it be in a general chapter or a general provision so as not to point out mana whenua specifically?
It's a difficult one. The sad part is that we, in a lot of cases, we can't access those particular lands or areas. We still, well, I'll just talk on behalf of myself. If you ever go across private lands, you always ask that person whether you can get there or not. In today's world, and we know that this is a fact of life, even when we're going out getting eels and stuff in certain areas we've got across farmers' land, we always ask for permission, because there is the health and safety issue which farmers have to deal with, and it is a real thing, and if we get hurt, carrying out what we do on their lands, then they are liable. And so we are understanding that there are rules that that govern us whether we like it or not, and it's just part and parcel of it. We can't go to certain places at all.
Well,
Yeah.
that's really helpful, because
Yeah.
what you're saying is Māori understand
Yes.
private property rights.
Yes.
Yep.
Yeah.
My other question is the same that I asked Ms White about the missing rock art sites, and I just wanted to know why was there no submission come forward to put them into this plan?
I can't answer that. I don't know. I found out retrospectively that it was left out, and we're trying to get that established or put in. I don't know how we go about it, but we're going to try.
Okay.
Yeah.
Great, thank you.
Yeah.
And we've talked at length about the two expert pieces of evidence, which I call the tipper evidence, but recognising that it was a group of people that came up with that. And when I read both of those expert reports, they talk a little bit about Mataranga Māori, but they don't go into a lot of detail. So and it is primarily about irrigation and water extraction. And so what I thought was really important was to understand, in this particular plan, the three main activities that have got restrictions in SESM, like what is the cultural values that are attached to those so that they are restricted. So I'm going to ask some questions firstly about earthworks, and then mining and woodlots and plantation forestry. So when it comes to earthworks, it's set out not in a wahitapu area, and I wanted to know, when it comes to wahitapu, what is the impact of earthworks on the rock art sites and then in the non-rock art wahitapu sites?
Well, I'll try and answer that if I can. The rock art areas, and I just pointed out when I made my statement, that what's happened in the past is they never consulted, and they destroyed a prominent rock art site. So that's why they've got it in there that, if there's any earthworks going on within that area, that it might alter the moisture content of the area. That's why forestry's in there as well, because it alters it. But to really get an expert view of that there, you'd need to go to Amanda, because they've done the scientific studies on it. They have reports that they have done on, the effects of that. So yeah, I'm no expert in that area. So. And
the Rock Art Trust, these two reports, I understand, have been, they are utilised by the Rock Art Trust, and that they prefer the 300-metre buffer for these types of activities. Okay, thank you. And you've answered about plantation forestry to say, look, forestry has an impact on the water.
Yes.
And water has an impact on rock art.
Yes. It can speed up the flaking on the limestone by quite a considerable amount.
Right, great, thank you. And is the same for mining and quarrying?
Yes.
Okay, thank you. So Ms White has also proposed to remove Rule 6.
Sorry,
Yes.
I'll just go a little bit further on that.
Oh, yes, sure.
In the rock art areas, with mining in that there, what I mentioned earlier on about the food gathering sites, where they slept, what they done, by mining it, they could be taking away historic evidence of what's gone on in the past. So that's the other reason for that. Sorry.
Great, thank you. So Rule 6 is about intensively farmed stock.
Yes.
So I have trouble with English and Te Reo Māori.
Yeah.
So that has been proposed to be removed, and my understanding is that you agree with the removal of Rule 6?
I don't know. I have no knowledge of that.
Okay, so it is proposed that previously it was a restricted discretionary activity, in particular overlays, and was actually only in the Waitoka overlay, and it's now since been proposed to be removed, but you're not familiar with that? No. Okay, thank you. And my last question is about the Māori purpose zone. And so we've got submission from Tūmo Paeroa that seeks to apply the Māori purpose zone to all Māori that are living in the zone and not just mana whenua. And I wanted to know, well, how extensive is that? Is there a lot of Māori living in the zones that aren't mana whenua?
No, I don't think so. I think this refers to lands that they control. All right, the Maori Land Court and the what do they call them? I've forgotten what they call themselves. But they administer on behalf of landowners, whether it be farming or whatever on those lands, and they report back to the landowners. The landowners could be living in another area,
Yes.
but unreservedly, mana whenua hold that. I mean, there is no question about that. We don't succeed or exceed to anybody else. Mana whenua hold their role, that's it.
And from my understanding of the Tūmo Paeroa evidence, they were really saying their concern was for mana whenua who weren't directly involved in, runanga day-to-day activities.
Yes.
And so probably it's not going to be much nuisance to include Māori.
No. Mana whenua who aren't present on the marae or in the day-to-day activities need to be involved. They need to be involved on their marae, because if they're not involved on their marae, they will be left out, because that's just part and parcel of how it goes.
Right,
Yeah.
That's your position. Yeah. Okay, thank you for clarifying that. That's really helpful. Thank you.
I do. Morning, Mr Henry. I think it's still morning. No, it's afternoon. Good afternoon, Mr Henry. You talked about some developers going in and destroying a part of a rock art site. Was that due to a lack of appropriate provisions in the earthworks chapter?
Yes.
Okay.
They didn't ask for a consent. They didn't do anything. They needed a consent, but they just went and done it. And, so, and on some farms they do that. They'll just go and do whatever they want to. They'll remove streams or alter streams and stuff like that. Then we hear about it afterwards. That has happened in our takiwā quite a lot. So, yeah.
That's all the questions I have. Thank you.
Tēnā koe, Mr Henry. I wondered if you could just help with my understanding. In terms of the sites and areas of significance 8 and 9, which refer to the Māori rock art sites, you've described in your evidence that those buffer areas respond to the fact that it's not just the significance of the art themselves, but to the wider story and historical events that may have occurred in the general area and the possibility of other discoveries being made. Is that part of the concept of wahi tupuna, or is that quite different? I'm having a little bit of...
It's all in the same. It really is the same, because it's what our tupuna done or carried out in that area. In a lot of cases, farmers have already excavated or ploughed the area up, or done other activities in that area, and it may well all be lost, like what I mean. But in our the big site of our Eagle, if you like, that's part of Kachiuirapa, there's been scientific work done on what activities were around and what was in the fires, what was taken, and everything else. So that we've done a little bit of history and stuff in that. But the other areas that, in a lot of cases, farmers either did know or didn't know that they had rock art in the area, and they've just continued to do what they're doing and may well have destroyed anyway what was around that area. So it may only be the rock art that's left.
Right. And so do you think then perhaps that there is some greater education that needs to go on in terms of what the presence of the rock art might signify to the wider area, rather than just a focus on the rock art itself? Do you think that would be useful?
Definitely.
And could that be addressed with some further descriptions in the Schedule 6, do you think, of the plan, without disclosing specific
Yeah,
detail, but to give a better understanding of what
yes.
might occur?
I'm quite sure Amanda would love to do that.
Thank you. And I'm just curious that the Rock Art Trust aren't appearing at these hearings. Have you had any discussion with them specifically about the Timaru District Plan?
No, I haven't. I'm quite sure that if they were asked to attend, they would. Yeah.
Thank you very much, Mr. Henry. Ms. Wheeler, I don't think there is any other questions from the panel. We just, I should note, and we have issued a minute, that the panel have asked to do some site visits of the farms where SASMs 8 and 9 appear. It's not that we're going to undertake any independent cultural values analysis of the sites, but what we really want to understand is the context within what the farming activities are occurring within those general locations.
Thank you, Madam Chair. We might do some seat shuffling and bring, or unless it's lunchtime, of course. Oh, it might be lunchtime. Well, my intention was not necessarily to have him say anything in particular. He's here because he's filed some evidence, but of course, if there's some questions, it might be the right time to do that now.
If you wouldn't mind, I just had a question. There's been some comment in the submissions about concern about charges in relation to cultural evaluation, either directly from Aureki Consulting or the council. I wondered if you could clarify how the council addresses charging for resource consents, particularly in the context of where there may need to be a cultural assessment. I'm familiar with the Environment Canterbury charging schedule, which is prepared through the annual planning process, but I'm not clear at all what the Timaru District Council does in relation to those matters.
Thank you, Madam Chair. It may be one of those tasks that I asked for a bit of time to go away and investigate further. My role doesn't encompass the consenting side, so my understanding is that it's an at-cost basis like we treat other consultants, but I would benefit from the opportunity to just go away and talk to my colleague who manages the resource consent aspect and report back on that.
Thank you.
Just a couple of questions for you, Mr. Hackart. So, at paragraph 16 of your evidence, the first sentence there says the ability to resolve concerns about previous engagement is limited. Can you explain or elaborate what you mean there?
So the evidence received as part of this process, a number of the submissions really criticised the engagement that was carried out, and I guess once the plan's been notified, there's not an ability to go back necessarily and fully engage and redo the process, so the sentence was trying to allude to that, but maybe not that successfully. Apologies for that.
That's okay. I was trying to ascertain whether at these meetings you were attempting at the meeting to resolve those concerns, but the ability to do so was limited, and I was wondering what the extra context might have been at those meetings, but I think I may have misinterpreted.
So I definitely saw the meetings as an opportunity to start forming relationships and, for lack of a better term, building bridges with some of the affected landowners, but it was not there to, I guess, relitigate the process that had occurred prior to that. It was trying to bridge some of the gap that had been identified through the submissions.
Thank you. I see now. Thank you. Oh no, this is not your one. I guess I was interested in Ms. White's Section 42A report. She made a comment that in her view that the council had met the statutory requirement for consultation. So I guess your evidence was more around the additional things that could be undertaken in this type of process, which may assist and massage things along a bit further. Is that have I interpreted that correctly? Do you agree with Ms White that the council met the statutory requirements?
Yes, I do, and I guess my evidence dated 20th of June last year took a desktop look and back at the engagement that occurred during the development of the plan, which due to timing I wasn't involved in because I wasn't in my current role. So I guess the intent with my next tranche of evidence was to show what discussions I'd had during the 42A development process that I was able to feed back to Ms White and via AECL as well.
Thank you very much. Thanks.
I have one follow-up. So the meetings that you've had since June with the affected landowners, through that process, has that we've heard today that it's resulted in a lot more of the landowners being comfortable with the SASMs now and they're no longer appearing. And is that because you went through and you said, this is how this rule is going to impact on your land? Was there that level of discussion to understand the actual impact of the activities on their land with the landowners?
Yes, so I don't think I'd go as far as saying that the landowners are happy to have the overlays still, but my focus of the conversations were really to look to understand the implications of the rule and objectives and policy package on their day-to-day use, to understand how we could respond through the 42A to that element, recognising that these areas have been identified, have values important to mana whenua, but as council's role in meeting the requirements of section 6E and then creating and then implementing a district plan, understanding our response to that and how that would impact them moving forward. And I guess through the furthest evidence lodged, I think council has gone some way to addressing those concerns through the recommendations suggested by Ms White.
That's really helpful, and just also to help potentially the questions that I asked the submitters that are appearing, of those that are appearing to talk about the SASM chapter, were they taken through the same exercise to go, this is the impact of these rules, or are there some that are appearing that didn't take that opportunity?
Yes, so there are, from recollection, 3 appearing in front of you that I haven't had a discussion with, but I have met with the Limestone Group and their representatives. I did meet with Federated Farmers representatives, and I did meet with a group from the wider Rangitata area as well. So met with those representatives where the discussion has expanded, but there are a couple of landowners still appearing in front of you that I haven't met with.
I have one question. Retrospect is a fine thing, but it's always too late. In retrospect, would the council do the same thing again?
I think planning, when you look back at any process that you complete, you can always find ways to improve, and I don't think you can find that just to this specific topic. I wasn't involved in the development of this plan, and I think anybody looking back at any development process would take the opportunity to make tweaks to their process. So not tying council into that, but I think that's any process, and no different to looking at other councils and what works and what doesn't, and trying to adopt what's best practice at the time. I think the development of this plan probably occurred as the national planning standards were being developed, and so timing, I guess within planning and RMA, the only constant is change, so I guess there's always opportunities to make tweaks and look to do things better, but at the same time I think based on information that council had available at the time, they followed what was at best practice and sought to engage with the community through the release of a full draft plan, which definitely has its benefits, so that it fully exposes the plan, but at the same time things can be lost when you get such a large amount of information at once. So yeah, there's always going to be opportunities to improve, but I think council did meet its obligations.
Yeah. Okay, thank you.
Mr Haka.
And Ms Veta, we'll take our lunch.
Break now and return at 1:15. We have scheduled, and when we will hear from them and then return perhaps to Mr McLennan as soon as we can in the afternoon and get through.
Thank you, Madam Chair.
Good afternoon, everyone. We'll resume hearings on the proposed Timaru District Plan. This afternoon, we're only partway through the council presentations, but we're going to continue with the schedule as notified and invite submitters to speak. Firstly, Te Runanga o Ngāi Tahu, Ms Paul. Thank you.
Kia ora. Tēnā koutou, ko Rachel Paul tōku ingoa, and I am providing an oral summary of my planning on behalf of Ngāi Tahu for the Infrastructure, Subdivision and Cultural Values hearing for the proposed Timaru District Plan. Overall, I acknowledge the Ngāi Tahu submissions generally support the notified plan, and for these chapters, I generally support the direction of the provisions proposed by the Section 42A reporting officers. The amendments I have proposed are to improve the effectiveness of the plan to provide for the values and future of Kati Hui Rapa in accordance with the RMA and national direction. One way to achieve this effectiveness, which has been a focus of my evidence for this hearing and for hearing one, has been to consider how the sites and areas of significance to Māori overlay and the Maori purpose zone are read together with the other provisions in the plan. This has taken the form of considering that plan users are directed to consider all relevant parts of the plan by use of features such as cross-references, and ensuring other chapters and their provisions do not override the SASM or MPZ provisions unless there is adequate consideration of the purpose of those chapters and the relevant provisions have been incorporated into those chapters. The other aim with this evidence has been to support mana whenua integration throughout the plan in line with the national planning standards. The association Council has built with Runanga for this process has directly improved the direction of the plan and will see more robust decisions being issued should this use of experts continue. To provide more clarity and efficiency to considering Ngāi Tahu values, I have, at the invitation of the Section 42A report, attached to my evidence a table reviewing the controlled and restricted discretionary rules relating to this hearing, to see if they considered mana whenua values and if inclusion of them would lead to better environmental outcomes. The conclusion I came to was that many of these matters of control or discretion were broad enough to consider mana whenua values in a general sense outside the SASM, if appropriate, but only the large permanent landscaping modifying or wastewater activities had a high enough potential adverse effect, in my opinion, to warrant Ngāi Tahu values being added as a matter of control or discretion. If the panel and reporting officers find this assessment useful to the decision-making process, I'm happy to repeat it for the other chapters of the plan, as the submission asking for consideration of Ngāi Tahu values as a matter of control or discretion applied across the plan for all controlled and restricted discretionary activities. Lastly, I would like to note that my evidence also references the joint statement between the Office of the Maori Trustee and Te Runanga o Ngāi Tahu. After further submissions closed, both parties have worked together for months to prepare statements of position for the Te Taipotini Plan and the Timaru District Plan to clarify to the respective panels that what is sought by each party does not need to contradict the other, and that both goals can coexist if the plan provides for it. The recognition of Ngāi Tahu rangatiratanga and the enablement of Maori land can be considered within the plan as two separate goals, which can also improve the clarity and efficiency of those provisions. I note that the 42A officers were not involved in the statement recommendations, and I am available if they wish to discuss the draft provisions put forward. And I'm happy to take any questions.
Kia ora. Thank you very much for your summary statement then. At paragraph 48 of your evidence in chief, you address an alternative process with the runanga to clarify when they might seek expert advice on cultural values, and you've drawn on a similar method proposed. I understand that's in the West Coast District, the combined plan over there. Could you tell me a little bit more about that process, please?
So the panel had some general concerns there about whether or not the plan provided enough information. So one of the things the reporting office recommended to help address that issue was 3 methods, which I'll just bring up. Because they directed the council as opposed to somebody who is putting together a resource consent, so they knew it wasn't things that the applicant would need to consider. Here we go. So 3 methods. First was to develop in partnership with Potini Ngāi Tahu, which information in what form shall be available to the public about identified SASM sites and their values, written protocols on how to engage with Potini Ngāi Tahu, and guidance for the public in how to apply for a resource consent. So that was method 1. Method 2 was for the plan committee, because it's multiple councils, to consider the merits of including additional sites as part of their regular plan monitoring, because similar to the rock art, we didn't quite get them all. And the third method was to develop in partnership with Potini Ngāi Tahu information on the cultural certification process. So that was about a very specific type of rule process for their SASMs.
Thank you. And are you suggesting that if that was an alternative pathway explored in the Timaru district, that those methods might be included within the proposed plan, or are you discussing a kind of broader corporate process that a council might adopt?
Well, I haven't made a recommendation for this particular one. I'm mostly just putting the idea out there.
Thank you. I did have a question around, in paragraph 74, this is in relation to the phrase associational.
Mm-hmm.
And while I've understood the evidence and why you're seeking the inclusion of that word, is that a phrase that is commonly used in district plans? And do you think that it's a clear terminology for plan users to be able to interpret?
So associational values come up mostly in case law regarding outstanding natural landscape. It's kind of a combined term that allows you to consider all those social values that you can't always physically see and measure. So since SASM is also about the cultural landscape, I felt it was a sort of an appropriate term to try and make sure that the objective considered the values that you couldn't always see, but connected people to the landscape.
Thank you. So you've drawn from the landscape vernacular, if you like, and applied that within the context of SASMs, given I see where that's come from. Thank you.
I now only have a few questions because I've either asked them of Mr Henry and got an answer from him directly as Mana Whenua representative, or they've actually been attended to in the summary statements of the Section 42A authors. Have you read those summary statements to see their updated recommendations?
Yes.
Okay, great. Well, I have a question just on the matters of control and discretion, and Ms White's terminology that she uses, and just to test to see whether or not that would be acceptable, regardless of whether or not they will apply to those 3 EI rules and the 1 stormwater rule. But she's written the potential of adverse effects on the spiritual and cultural values and beliefs of Kati Huriapa and any measures to avoid, remedy, mitigate adverse effects. So does that capture what you're trying to achieve? Is that a good statement for a matter of discretion?
I think that's a fairly good one for restricted discretionary because it gives a sort of clear direction on what to consider and how to consider it.
Great, thank you. And my next question relates to the subdivision rules and the updated summary statement from there. So this is your paragraph 71 to 81 of your evidence, and there the reporting officer has accepted your relief sought, and when it comes to now the words have been changed from protect significant natural and cultural values, because you took issue with the word significant and how that would be assessed, to protect identified natural and cultural values. So does that provide the relief that you seek?
Yes.
Okay, thank you. And last questions are on the Māori purpose zone. So we heard from Mana Whenua this morning about how many Māori are living in the Māori purpose zone that do not have whakapapa to part of the Mana Whenua group, and it was relatively limited, but Mana Whenua wanted to maintain for it to be exclusive to Mana Whenua because they felt that people needed to be actively involved in the rūnanga. So can you explain, is that still a point of difference between your evidence and Tumu Paeroa, and what is Te Rūranga Ngāi position on it?
So the Māori trustee is online as well right now.
Right.
And the joint statement and the wording in my evidence is what the Māori trustee and Tront have agreed with, and we've used this also same approach on the West Coast, where enabling Māori land should be something that's sought in this plan, regardless of whether or not that Māori land is Mana Whenua owned. The Mana Whenua provisions are different from Māori land provisions. A good example of that you'll see is in the MPS for Indigenous biodiversity. They have specific provisions relating to specified Māori land and specific provisions relating to tangata whenua recognition and values.
Right, so how does it then work? What is your joint statement for Māori purpose zone? It's all Māori would be appropriate, or all Māori land?
Enable all Māori land, but then, provisions relating specific to Mana Whenua remain just for Mana Whenua.
Right, so your position remains not to change the definition of papakāinga? Because I think that's my understanding was that was the point of difference between your evidence and Tumu Paeroa's evidence.
Sorry, I'm going to look it up to make sure. I'm just double checking. I believe, our joint statement has us both agreeing to not change it. But I'll just double check because it is on the website. Should be. Right. Right. Okay, so our joint statement was for Mana Whenua or on Māori land. Yes, so ours was to amend to say Māori land, but not include Māori landowners.
Right, okay.
It's the wording, because that's just too hard to enforce.
Yeah, okay, so I see. So in that case, Te Rūranga Ngāi agreed with the Māori trustee.
We came to a joint agreement, not with the Māori trustees' words, though.
Right, got it. Thank you. And then I also wanted to know, is there also engagement with the trustees of the Waipopo Trust? Like, how are they incorporated? Because they're still part of Ngāi Tahu. They might not be a rūnanga, but they're still part of the tribal structure, right? Is there any engagement with Waipopo Trust?
I know they've put in their own submissions, I have not directly engaged with them.
Okay. Right, thank you.
Yes, good afternoon, Ms Poll. I've just got one question for you. It's around your paragraph 95 where you want rakatirataka and kaitiakitanga included. So I understand you talk about a hierarchy, and I understand what you're talking about when you talk about the RMA hierarchy, but what is your reasons for including rakatirataka and kaitiakitanga from a hierarchical cultural perspective?
They are identified in the mana whenua section as Ngāi Tahu values, and to make sure those values get recognised, particularly in the SASM chapter, I want to see them reflected in the objectives and policies as how these decisions are made and what the goals are. So that is part of the reason why I want it in there. And the objectives and policies seek that mana whenua are involved in the decisions regarding these ones, should they feel that there's a need. And so that, rather than just sort of tiptoe around that, why not just flat out say it and say rangatiratanga, kaitiakitanga, as recognised in the treaty settlement and the RMA. Does that help answer your question?
No, it doesn't.
No?
I'm
Okay.
really talking about from a cultural perspective. Like, how's rakatirataka regarded culturally as opposed to anybody else? So in other words, it would be up there, wouldn't it? Like, it's high.
It is. It's page 1 of the Settlement Act.
That was the point I was trying to make, sorry.
No.
Thank you. No more questions.
So I asked a similar question to that this morning of the reporting officer about whether or not to expressly acknowledge kaitiakitanga and rangatiratanga in Objective 1, and there was response to the effect that it really does depend if those terms are defined, and what you've just pointed me to was in the mana whenua chapter 2.1.5 and 2.1.6 actually really details what that means for mana whenua. Is it usual for planning to define those terms, and why have they been defined here? Were you involved in, I know you provided submissions on this, but why were they expressly supported for this plan? Are you aware of that background?
I have not had anything to do with the plan process. That's why I put in the submission to keep that distance. But kaitiakitanga is an RMA defined term, so having it in the plan is just logical.
Ms Paul, thank you for your evidence. Look, I have a question for you that doesn't really arise directly out of your evidence in this hearing, but it's a follow-up question to the memorandum that you filed in response to our Minute 7 back in May. So this just relates to the definition of sensitive activities. And I just wanted to clarify with you what you were seeking. The issue that you had identified was that the council's proposed definition of sensitive activity included reference to marae buildings in bracket, and you pointed out the problem with that definition and also the fact that the plan defines marae complex as well. And you propose an alternative where you point out that it is often the case that, marae are not going to go anywhere in any great hurry in the context of this planning window, and also that they do already coexist with a number of the activities that have the potential for the reverse sensitivity effect to arise. And you propose an amendment to the definition which provides a carve-out or an exemption from sensitive activities for papakainga. And I note that that is also defined in the plan to be quite a long list of activities, including marae complexes. And I just wasn't clear in my mind whether you were seeking to broaden the issue to exclude a wider range of activities, or simply trying to remedy the drafting defect that you identified by referring to marae buildings. Or have I missed the point?
No, I'm just trying to make sure I find the right one.
Yeah, so this is your memo. It's dated 31st of May 2024.
So that was hearing A.
It may have been a follow-on from hearing A, that's right.
It's May, which means it's this one. Sorry, I didn't come prepped for this one. Land. Right, found it. Sorry, I tend to waffle a bit, don't I? Okay, so the current definition refers to marae only, building only as a sensitive activity, and Kiwi Rail sought to extend it, and Tront opposed it. So marae being a courtyard in front of a meeting house was not likely to require protection, I thought. So, yeah, so I wanted to find a better definition.
Yes.
So I went for marae complex according to that. So yeah, I was trying to use our existing definitions to try and retrospectively sort of fit the definition to try and get a definition that would make more sense.
So if the panel considered that marae complexes were sensitive activities, would that be the definition that we should use? Or if we accepted your evidence, should the exemption only be for marae complexes? Why papakainga? Whereas you recommend papakainga, which seems to be a broader term and captures a whole range of activities, some of which are already in the list of sensitive activities.
So the advantage of marae complex is that while they don't move, they don't often have permanent occupation. So in terms of particularly like long-term noise effects and such, it's potentially a better word in terms of exempting a particular activities.
But you've gone with papakainga, that's my question really, is which includes whare, home business, marae complexes, manuhiri noho.
So yeah, I've limited to Papakainga on Māori land though, just
Right.
for those particular sites, so that it wouldn't happen anywhere. It's a limited exemption in those two particular areas, weighing the balance more towards enabling Māori land over a full buffer protection for the infrastructure in that area. So yeah, that I thought was a good balance, and then the rest of the district.
Right. So it really serves a couple of purposes then, doesn't it? Rather than just addressing that specific issue, I think we found ourselves troubled by the use of marae buildings. But
Yeah.
that definition, when we look to the Māori, the special purpose zones, we should also have in mind that definition and how that might fit within that zone also. Would that be
Yes,
right?
So the national planning standards, you know, when they talk about the special purpose zone, Māori land, they say its purpose is specifically to enable development on there. And the regional policy statement, you know, talk about enabling infrastructure, but also enabling development on Māori land within the same objective. So, yeah, that was an option I wanted to put forward to you, where you enabled it on Māori land, but the rest of the district, you weighed the balance more the other way.
Okay. I think that's a helpful explanation. I just found myself...
Well, that's good, because it took a while to find.
troubled as to how we got from that very narrow issue to a broader concept. So thank you for that, and thank you for your evidence today.
It's okay. Do you want me to stay out while you talk to the Māori trustee, or?
Yeah, you can. You don't have to leave the table. You can. Thank you. So we've got joining us on video link. Is that? Kia ora. Can you hear us?
Yeah, we can hear you.
Okay, we can hear you, Claire. So we're in your hands.
Okay.
Thank you.
Perfect. Tēnā koutou, I'm Ngā Hoia Huirama, and with me online is Vanessa Griffiths, and we're appearing on behalf of the Māori trustee, Dr. Charlotte Severn. The Māori trustee thanks the hearing panel for the opportunity to speak to her submission on the proposed plan and outline on the role of the Māori trustee and the land shed ministers was provided in the Māori trustee's original submission. Before turning to our position on the Section 42A officer's recommendations and changes, the Māori trustee first wishes to acknowledge Ngāi Tahu as the tangata whenua of the Storohe. Secondly, since the Section 42A officer's report was released, the Māori trustee and Ngāi Tahu have provided the hearing panel with a joint statement dated the 18th of December 2024 outlining our agreed recommendations. For this hearing topic, agreement was reached on a definition for Papakainga, changes to the introduction of the Māori Purpose Zone Chapter, Objectives 1 and 2, and Policy 6 of the MPZ, and submissions the Māori trustee withdrew from. The joint statement of the Māori trustee and Ngāi Tahu seeks to ensure that Māori landowners are not disadvantaged in the use and development of their Māori land while appropriately recognising Ngāi Tahu rangatiratanga. The Māori trustee agrees with Ngāi Tahu's position on the recommended changes to the Energy, Infrastructure and Transport Chapter that the MPZ should be read in conjunction with the EIT provisions where relevant. She supports the provisions remaining as notified so that both the EIT and the MPZ provisions are considered when infrastructure activities within the MPZ are assessed. While the Māori trustee did not submit on the infrastructure chapter, subsequent changes recommended in the Section 42A report would enable more infrastructure activities that have the potential to limit the use and development of Māori land within the MPZ. The EIT chapters state that provisions within the EIT chapter takes precedence over the objectives and policies in any zone chapter of Part 3 area-specific matters. The MPZ chapter is a zone chapter of Part 3, therefore the recommended changes have the effect that the provisions within the EIT chapter will now take precedent over the MPZ objectives and policies. This is notwithstanding that under the National Planning Standards, the MPZ is classified as a special purpose zone. the national planning standards require that special purpose chapters include cross-references to EIT chapters and vice versa. Given the unique nature of the special purpose zone, the Māori trustee supports Ngāi Tahu's position that a specific assessment should be undertaken to determine if the proposed EIT provisions are suitable for the intended purpose of the zone. The Māori purpose zone contains existing infrastructure which restricts use and development of Māori land. It is unlikely that infrastructure will be relocated, however, upgrades and maintenance could create further restrictions on the use and development of Māori land. Therefore, the relationship between EIT rules and MPZ is important, and the Māori trustee respectfully requests that the panel undertakes the assessment of compatibility between the two chapters as recommended by Ngāi Tahu. And we're happy to take any questions you may have.
Commissioner Solomon, do you have questions? No, thank you. Stacey, no questions?
Kia ora. I have, really it's just boiled down to one question now, and that is, look, it's really good to see that the Māori trustee has engaged with the iwi and been able to find some common ground. To what extent has the Māori trustee also engaged with Waipopo Trust that have put in submissions for the Māori purpose zone?
We haven't had any engagement with them.
What is the relationship between the Māori trustee and Waipopo Trust? Given it's a trust under the Act.
We only administer Māori freehold land on behalf of the owners that we represent. Those trusts are individual blocks, and yeah, we don't engage with them in that sense, I guess.
Right, so if we're still talking about, there's areas of land where the Māori trustee is the trustee on behalf, and then there's others that are actually in trust ownership now, but if we're still talking about areas that are adjacent or together and collective, then would you want to also engage with those Māori landowners to understand their position? Would you ordinarily do that to see if you're consistent or opposing?
Sorry, kia ora koutou, Vanessa Griffiths. We would if we saw that there was benefit, but in this case we haven't. So the land that the Māori trustee administers is set up in a Ahu Whenua trust through the Māori Land Court, and we're appointed as the trustee. Those other trusts have been through a similar appointment process and have their own responsible trustees. Just because of the shared size of our portfolio, we don't engage with every single Māori land trust. We've engaged in this instance with Ngāi Tahu. We've reached out and engaged with them in this instance, but not every individual Māori land trust.
Mm-hmm. Okay, thank you.
And I have no questions, thank you. Thank you for the work that you've done with Tangata Whenua to resolve as many of the issues that arose. That's very helpful. Thank you.
Thank you.
We have a Heritage New Zealand by video link as well, Ms. Beard.
Yes, kia ora.
Can you hear us fine?
Yes, I can, loud and clear.
Thank you. We're in your hands.
Great, thank you. Kia ora koutou, and thank you so much for the opportunity to speak this afternoon. I believe that the issues raised in my evidence are all fairly minor and quite clear, and many of them have actually been resolved over the past couple of weeks. But I would still like to just take the opportunity to provide a little bit of a summary, either to reiterate my points or just to provide a bit of an update. So just to give you some background to start with, Heritage New Zealand was consulted really early in the plan review process. Team members were involved in the Heritage Working Group meetings and provided guidance in terms of heritage issues and information on items included in the New Zealand Heritage List. The Heritage New Zealand submission was really very supportive of the proposed plan, and that is partly because we had so much prior involvement. And it certainly acknowledged the efforts that have been made to strengthen the identification and the protection of historic heritage within the district. The small number of opposing points related really to areas of the plan where stronger provisions would result in either a better understanding of heritage or better outcomes in its management and protection. Prior to the Section 42A report being prepared, I had the opportunity to answer a number of questions for the Senior Policy Planner, Mr. Rond, and to clarify a number of the Heritage New Zealand submission points. Subsequent to that, it appears that the majority of the Heritage New Zealand submission points have been satisfactorily addressed and resolved through the Section 42A recommendations. So that means that I can keep this brief and just touch on 4 points. The first one of those is ensuring accuracy when discussing archaeological sites. So in my experience, archaeology can be quite a confusing topic, and many people do not fully understand what an archaeological site is or what responsibilities they may have. So I consider that having clear and accurate definitions, explanations and advice notes within the plan regarding archaeology is an absolute essential in assisting owners to better understand their obligations. Heritage New Zealand made a number of submission points on this topic, and it was discussed at our pre-hearing meeting as well. And I'm really pleased to see that this is followed through in the Section 42A report. And I just want to take the opportunity to strongly support those recommendations for clear definitions and advisory notes regarding archaeology. Secondly, and still sticking with the topic of archaeology, I would like to just touch on the proposed Accidental Discovery Protocol, or ADP. Heritage New Zealand supports the principle of including an ADP in Appendix 4 of the proposed plan, but had submitted that the proposed wording did not quite cover all requirements and requested that the Heritage New Zealand ADP, which obviously has been tried and tested, should be used instead. The Section 42A report stated that the two protocols were sufficiently similar not to warrant alteration. But I disagreed with that in my evidence because I felt that there were still some sections that were either slightly inaccurate or a little bit ambiguous. And so just over this past week, actually, Ms. White and I have worked through the reasoning for the necessary amendments to her proposed wording and have come to an agreement on appropriate revisions. So although I would still be very happy to see the Heritage New Zealand ADP used, I do consider that the agreed amendments will result in a sufficiently robust and user-friendly protocol. My third summary point is in relation to the schedule of historic heritage items. The New Zealand Heritage List, which is maintained by Heritage New Zealand, is really an identification and information tool and does not actually provide protection. Therefore, the heritage schedule within a district plan is what I consider to be one of the most significant tools for protection of heritage items. For a schedule to be both comprehensive and defendable, you need assessments to identify each item's significance and to justify its inclusion within the schedule. And Timaru have been very fortunate to have Dr. McEwen undertake this work for them. The record forms that Dr. McEwen has prepared are very beneficial for the processing planner to understand how proposals must mitigate adverse effects on the item's heritage values. But very importantly, they are also incredibly beneficial for the heritage property owner to understand why their property is scheduled and what important features must be retained. So Heritage New Zealand made 2 submission points on this, requesting that the building record forms for both the historic heritage items and the historic heritage areas, which have been prepared by Dr. McEwen, should be hyperlinked to Schedule 3 and Schedule 4 to promote greater understanding and accessibility for owners and plan users. Instead of accepting this recommendation, the Section 42A report has recommended that an advisory note be placed on the schedules instead, stating that the heritage record forms are available on the Council District Plan website. Now, although I do acknowledge that this does make the building record forms available to the plan user, but it just does not seem to be a user-friendly way of providing this information. The hyperlink, in my view, is a simpler and a more effective way of taking the plan user directly from the schedule straight to the correct report. Otherwise, they have to visit another site and then search for the relevant property. Other recently reviewed district plans have used this hyperlink really successfully, and that includes Waimakariri District Council and Selwyn District Council as well, and Christchurch City also uses a hyperlink in their district plan. So again, I'm just supporting Heritage New Zealand's submission point, and I would recommend the reconsideration of this hyperlink. The bottom line is that the hard work has already been done in preparing these assessments, so why not make them as easy as possible for the public to access? And my final point that I would just like to touch on is in relation to the term compatibility. So the Heritage New Zealand submission and my evidence point regarding compatibility is sort of what I would call a wish list point rather than an essential. The use of the word compatibility is not wrong in this context. It does provide a good level of protection, and I completely concur with the Section 42A report that part of the matters of discretion should involve comparing the new structure or the alterations to what is already there. I guess my query is whether it's necessary to use this word when removing it has the potential to avoid any ambiguity of people perhaps thinking compatible means it needs to be similar to, which is not the case, and also opens the rule to allow the processing planner to take into account other considerations and maybe potential benefits. I can think of examples where, you know, the scale and materials of strengthening measures perhaps may not be considered compatible, but are critical to the longevity of the building, or where functional structures may not be comparable, but might provide climate change resilience, for example. So I would have to say that this is not a deal breaker for me, but in my opinion, the removal of the word might allow you to consider other aspects of a proposal that may also be of benefit to the heritage item. And I think that covers everything that I would like to draw your attention to at this stage, and I'm happy to take any questions. Ngā mihi.
Thank you, Ms. Beard. That's helpful. I'll just see if the panel has any questions. I'll start at the far end.
Good afternoon, Ms. Beard. I had a question about the compatibility, but you've answered that now. My question's around your paragraph 13. Can an accidental discovery avoid an adverse effect?
Sorry, can you repeat that? The sound is just a little bit fuzzy there.
Can an accidental discovery protocol avoid an adverse effect?
Oh, absolutely. So, I mean, if you have a look at the proposed accidental discovery protocol, it basically it sets it sets a very clear process that you need to follow if you do accidentally find an artefact or any sort of archaeological material. And what this does, it prevents any further damage to or deterioration of the archaeology. So it's very important for anybody that is working in these areas to understand what an ADP is, and also for that ADP to be a user-friendly one and to be very, very clear in what it's trying to achieve. And that's the conversation that that Ms. White and I have been having over this past week, tweaking the words so that it's really crystal clear and user-friendly, and also that it actually delivers on what it needs to, which is providing protection for any as yet undiscovered archaeological elements that may be there.
So if it was
so yes, so the short answer is yes, absolutely, it can avoid potential adverse effects.
So, but if it's been accidentally discovered, hasn't the effect already occurred?
Potentially, you've scratched the surface of it, literally.
So you can't really avoid it, can you?
Sorry?
You can't really avoid it if you accidentally discover it, the effect's already been created.
Well, the start of an effect might have been created. You might have found one small part of a huge previously unknown archaeological site that, if you continued with the development, you may disturb and damage something that's incredibly important. But if you have an ADP in place and it is noted and the process is followed as soon as anything is found, then that gives you the potential to prevent damage to potentially really important archaeology.
Okay, so does the accidental discovery protocol rely on the observer being able to identify archaeological values or wahitapu values?
It requires them to be aware that there is potential, and for them to be aware that if anything is found, then they should look into it.
But would that give them the skills, just being aware, would that give them the skills to identify, for instance, koiwi tangata, blackened charcoal, to identify that there could be human remains? Does that being alert, does that provide those skills?
It doesn't necessarily provide those skills, but if people are aware of potential and there is an ADP in place, then they would know that if they find anything, then the ADP kicks in and you follow the process that is listed on that ADP, and that has the potential to prevent further adverse effects on that site.
So I understand the further adverse effects. I'm just a bit not sure about avoiding adverse effects. I'm not sure whether I understand how an accidental discovery can avoid an adverse effect.
It can avoid further adverse effects. I think that the problem is if people are working on an unrecorded archaeological site, then the ADP really is the best that we can do, because if it's unrecorded and there's no information on that, often until some work is started, you do not know, and that's the whole purpose of an ADP. Yeah. If the site is known, or if there is known potential on the site, that is when people may be required to actually have an archaeological authority before they undertake the work. And the archaeological authority will look at all the potential for adverse effects to that site, and also it may provide a number of conditions that the developer or the owner needs to work towards. But unfortunately, every archaeological site is not known. And so the whole purpose of an ADP is for those unknown sites where there is potential for archaeology, and it provides the best possible way to deal with it if something is accidentally discovered.
So would you consider EWP3 accurate where it says require an ADP to ensure land disturbance avoids adverse effects?
So I see where you're going with this, in that until you break the ground, you are not aware that that there is something to avoid. I understand that, but it is the best possible option for these unrecorded sites.
Yeah, that wasn't actually my question. So my question was, do you consider EWP3 to be accurate where it says require an ADP to avoid adverse effects?
I think the intent of it is completely accurate.
So I take it that you don't think it's accurate. The intent is, but the actual isn't.
I think it is perfectly understandable what it is meaning and what it is trying to achieve. I'm not sure how else that would be worded because of the nature of an ADP.
Would mitigate be a better word?
Mitigate. Potentially. I mean, it will avoid further adverse effects.
But it won't avoid the initial adverse effect. Is that right? It won't avoid the initial adverse effect.
I think that we're kind of going round in circles. That if there is no known archaeology there, I don't know how you avoid that initial impact. The intent of an ADP is, once there is any knowledge or any evidence, that all work stops and any future adverse effects are prevented.
All right then, thank you.
I think that probably does.
We've threshed that point.
Yeah, no, I do think that is probably, it's the way it's written in the plan. I think that to avoid any misunderstanding as to what the consequence of the accidental discovery protocol is, probably introducing that word further is going to be of provide greater clarity on that.
Okay. I've just got a few more questions. Sorry, Ms. Beard. Do you know of any occasions where archaeological or wahitapu material has been accidentally discovered in a heavily modified area?
I'm not sure. I am not personally an archaeologist. We have archaeologists in our team, so I can't answer that, I'm afraid.
Okay. You perhaps might not be able to answer my other questions because they are archaeological questions. I'm sorry.
Okay. I'm more than happy to take those questions and to source answers for you, if that would help.
Yes, please. So my questions are. So the same question applies to, do you know of any occasions where archaeological or wahitapu material has been accidentally discovered in modified areas, in the rural areas and in coastal areas? And how often do they get reported?
Yep.
And then my last question is, can an archaeological authority cover numerous earthwork activities in a confined area? Like a global authority?
Yes, I'm happy to source answers to those questions for you.
Thank you. And just one more question. When an archaeological assessment is being prepared, are they informed by cultural information or cultural assessment, especially when they're triggered by, say, for instance, by SASM? And could you also ask the archaeologist about whether an accidental discovery protocol can avoid an adverse effect? Thank you.
That question that we just discussed?
Yes.
Yes, yeah.
Thank you. I have no further questions. Thank you.
Thank you.
Sorry, I just have just one question, and it's around your paragraph 12.5 in your evidence, and it relates to what you've called it's the recommendation to include the definitional terms in the introduction of the heritage chapter.
Sorry, which paragraph again?
12.5, I think.
Yes.
Yep.
About the definitions?
Yes. So I just want to,
Yep.
I haven't had a chance to ask the officer this question, but I just want to be clear what your intent was with these, because you've used the word in your paragraph that the definitions be provided in the introduction, and then the officer has used the terms, this is an explanation. So I just want to be clear from you, is your intent that the information, explanations, definitions, what's your intent?
A little bit of everything, I suppose. Really, it's the fact that when you have a title of significance, whatever the significance may be it architectural, cultural, historical, that doesn't mean an awful lot to a lay person. And so for me, it's the educational value of it, and so that it is clearly understandable to any plan user exactly what those criteria for significance actually are. So it's not that important where they lie, as long as they are somewhere within the heritage chapter. So in other district plans, I have seen them either at the introduction or in the policy itself, or some of them actually just have them listed just at the start of the schedule. So I don't believe it's that important where they are, but it's an information tool as much as anything to make the plan user completely aware of what the criteria for significance actually is. So I am quite happy for them to be provided within the introduction.
Right, so your intent, the last words you used there were information. So, because it's just if and it's probably give a heads up for the officer, in terms of the planning standards, if it's a definition, then there are places where definition should be. And I just want to be very clear, because you used the word definition in your paragraph 12.5, and I just wanted to be very clear whether you were seeking that these be applied as definitions or be it information, that's all.
Yes, sorry, okay, yes. So no, not definitions then. No, I wouldn't expect these to be located within the definitions chapter. These definitely are an explanation or further information as to what the criteria significance actually is.
Okay, thank you.
Thank you, Ms Beers. One follow-up question at the start of your presentation. You mentioned that you had reached agreement with Ms White around appropriate revisions to the ADP.
Yes.
Do you have a copy of that available for us to see now? Is that something that exists, or have you just had verbal discussions to date?
I have a slightly messy version, which has a lot of track changes in it. It may be better for me to provide you with a copy of that afterwards, if that works.
Yes, thank you. That would be appreciated. Thank you. It would be, in terms of, there were a number of points in your evidence where you've compared your desired version and the proposed version. It would be useful just to see how that was resolved and what those final track changes have been.
Okay. Yes. Okay. I can just briefly tell you that if that's of interest.
Thank you.
Right at this point in time. So let me just find that part in my evidence, and then I can just talk you through it. I think it's right at the end. Oh, yeah. Okay, so I looked for an amendment to point 1. And what we have agreed at for point 1 is that the final wording would be all work at the place of discovery and within 20 metres of the discovery will cease immediately. The contractor, work supervisor, landowner will shut down all equipment and activity. So that is the resolved wording for point 1. Point 5, which I had said was a bit misleading because the material could be confirmed by Heritage New Zealand or by a consultant archaeologist, and that has been changed to... yes, so it now reads, if the material is confirmed by Heritage New Zealand or an appropriately qualified and experienced archaeologist as being archaeological under the terms of the Heritage New Zealand Act, an archaeological assessment may need to be carried out by a qualified archaeologist. I'm just trying to read through my track changes. And an archaeological authority, and if required, an archaeological authority must be obtained from Heritage New Zealand before work resumes. Okay, and then point 7, I had said was inaccurate, as in archaeological assessment may not always be required. And the final wording of that. Yes, so basically just the words an archaeological assessment have been taken out. So the rest of the wording of that point stays the same, but it just takes out the reference to an archaeological assessment. And the last point, yes, I'd asked for that wording to be incorporated at the end of the ADP, and let me just check, I believe that has been added as a note at the end, which basically states that it's an offence under Section 87 of the Heritage New Zealand Paeretāonga Act 2024 to modify or destroy an archaeological site without an authority from Heritage New Zealand, irrespective of whether the works are permitted or a consent has been issued under the Resource Management Act. And those were all of my requests, and they have all been resolved in one way or another.
Thank you for talking through that, particularly given the track changes versions you've been navigating there. But I appreciate that. It was useful just to see.
Sorry.
It was useful to see how they have been specifically resolved. Thank you.
I can also provide you with a clean copy of that.
Thank you.
I have no further questions, Ms. Baird. Thank you very much for your evidence today. and submission.
Thank you.
Now I have Federated Farmers, Rachel Thomas and Mr Anderson. I think Ms Thomas is joining us online and Mr Anderson's here. Okay, who's taking the lead on? Thank you.
First of all, I'd like to thank the panel for once again hearing from Federated Farmers. Myself and Rachel will speak to our evidence. As last time when I spoke to the commissioners, I'd like to remind the panel that today's hearings affects the agricultural community immensely. Most of these district plans do not affect other people in the community, especially this one affects the rural area. And it is a stressful time for a lot of the farming community. And we've been talking today about cultural values. Well, one of the strongest cultural values in the farming community is a family-owned farm and operated by families. And these plans are causing a real strain on that family-owned operated operation, mainly around reasons around succession planning and economic viability. And I'd like the panel to remember that when they make their decisions today. Also, I'd like to remind the panel that there's a lot of uncertainty around where the RMA is going to end up, and that causes a lot of concern around this plan, because this plan is based around the RMA, and it's making it difficult at times to understand where we're heading with a lot of these district plans until we get some certainty on where the RMA is going to end up. And I know that's not your job to do. You're here to listen to about the district plan, but it is a concern. And I'm sure you guys have got these same concerns. So what we'll do now is we'll just maybe hop through our three major areas of concern. Rachel can hop in any time she wants to clarify the technical stuff. And obviously the first one, our first major concern is the overreach of the mapping. We believe it's just gone far too wide in the district, and it's taken up far too much land has been identified in that under the plan. We have real concerns around that the district plan doesn't clarify the access issues. Once again, they're hiding, well, not hiding, they're using higher legislation saying that we're protected under the Trespass Act, but as an organisation we can't understand why this can't be put into the plan and save ambiguity. Maybe the planners would like to comment on that. And the same with the RMA around existing use rights. We're continually told that we're protected under the RMA for existing use rights, but it's not prepared to be put in the plan. Rachel, would you like to comment on that?
Thank you, Greg, and thank you for the opportunity to present this afternoon. So just in terms of the mapping, I'm sure that you've all seen the stats within our submission. We've compiled some pretty interesting information there where 315 farms are covered by at least one SASM, and of those 97 farms have 100% coverage. So in our view, the identification of sites can be mutually beneficial for both landowners and mana whenua, but when entire farms are captured, it tends to undermine the process of mapping specific sites, and it becomes difficult for farmers to know which areas of their farm they're supposed to protect. So we would like to see a revision of the mapping and a reduction of it, particularly those 97 farms that are fully covered by SASM. We've also identified one farm that has 210% coverage, so multiple SASMs existing within that one farm. The impact of these overlays, as Greg mentioned, is felt within succession planning. It's also capital value. Some of our farmers now, when they're going to the banks, they're being asked about specific overlays that are applied to their farms. So the flow-on effect for farmers is huge. And in terms of the landowner consent issue that Greg mentioned, we do thank Ms White because she has addressed that within her 42A response, and I think has noted that she is comfortable with including something within the SASM chapter to the effect that specifies our protections under the Trespass Act. We strongly support this approach and hope that that is something that the panel agrees with us upon. I think the SASM chapter has caused so much anxiety within the district that any attempts that can be made to try and alleviate that within this chapter need to be thoroughly considered.
And did you have any other points you wanted to make, or can we go to the panel for questions?
I think probably the best way to take it now is just questions. Yep.
Thank you.
Thank you. My first question is directed to perhaps both of you. So we've heard from Mr. Hackart this morning with regard to the process the council has followed pre and post the Section 42A report being released. And I was wondering if you had met with Mr. Hackart or the planning team since you've made your submission to discuss your concerns.
Myself personally, no.
I have, yes, I have met with him and did raise my concerns, but I did come into the process with this district plan following the resignation of one of my colleagues. So I wasn't the one who wrote the initial submission, but I certainly stand by the concerns that were identified within it and do have significant concerns about the process followed for the consultation.
Thank you. So I'm interested in, a lot of the submission, to my mind, reads as quite generalised statements. And so for our purposes, I'm interested in what specific concern do you have with, for example, the SASM, and what specific conversation you may have had with the planning team about how that applies specifically on the ground?
So the specific concerns are in relation to the overreach of the mapping. And I appreciate that is quite broad. However, specifically, we're concerned that nearly 100 farms are entirely covered by a SASM. So that is very concerning for us. It's also, I guess, the way in which the mapping was undertaken has led to these feelings within the community. And I appreciate that that's maybe something that's outside of the ability of the plan to dictate now, but it's useful to understand why farmers and landowners are feeling this way.
Thank you. And so when you say that you're concerned about the SASM overlays over farms, what is the specific concern about the presence of the SASM overlay? What is it you're articulating?
Yeah, so I guess it's both in relation to the two other concerns that we raised about access, which is potentially just an anxiety issue for landowners, but also within SASM 02, there's I think some wording around access being enhanced, and we can't really see how that would be possible when there's an entire farm covered as a SASM, how access to that SASM would be enhanced. And I actually did find limited narrative on that particular point that we made within Ms. White's response that was recently released.
Okay, thank you. In terms of access issues, health and safety issues, access issues, existing use rights, what is the role of Federated Farmers in discussing and with their membership about how the RMA applies and the different statutory sections that applies and how that plays out in practice across New Zealand? What is Federated Farmers' roles in helping to alleviate some of those anxieties? We have evidence in front of us that, for example, that existing use rights are not going to be trumped by the SASMs. We also have evidence in front of us that access is not a broad brush free right access that don't override property rights. So, and that's something I'm sure that you're aware of because I know that you've got policy and planning experience. What is the Federated Farmers' role in helping to alleviate those concerns with its membership?
I guess we do try and make attempts to explain plan provisions to our members where they're not sure. Personally, I take a lot of phone calls from members who are wanting explanations on things within certain plans within Canterbury, but there needs to be something in the plan that we can refer people back to as opposed to just relying on something within the RMA, which is subject to change, as we all know. Our members want to see something in the plan that affects them. So I absolutely acknowledge that we have a role, and I have no doubt that Mr. Anderson also has similar conversations with other farmers in the district, but I think it's important that the council acknowledges that within their plan in order for Federated Farmers to be able to communicate that to its members.
I mean, it's easy. You're reading through your plan, and a lot of you people understand planning talk. The general public don't understand a lot of planning discussion, and you read things like, oh, we need to have access for enhancement. You try and explain that to a member that, oh, they're going to be able to come on and enhance their site or whatever. I mean, the thing about that I see from a personal point of view, and probably a lot of farmers, is for this to work well, it's about cooperation between mana whenua and the farm landowners. And if you haven't got goodwill and cooperation, it doesn't matter what you write in this plan, it ain't going to work. The archaeologist was talking about discovering, you know, when you're asking the questions about discovery, when you're disturbing land, for those things to work, you've got to have a really good relationship, because people are just going to bury it and let no one know. I mean, it's all about having good relationships and making it user-friendly.
Thank you. Is that something that your members have voiced, that's the approach that they would take?
That goes on, that gets in my...
Okay. All right, I think I'll leave that there. Thank you.
Yep.
Kia ora kōrua. I have a number of questions. So at paragraph 11 of your evidence, and I think this really is directed towards you as a planning expert, and here your statement is that council's being irresponsible by proceeding with the SASMs when there's been political statements that they might be reformed in the future. And as you will know as a planner, that the RMA is always in a state of reform. We just had 10 years that we went through to get to a point where the new government came in and said we're going to start afresh. And we're always in a state of flux. And we've had evidence this morning, that legal evidence that said that political statements aren't law and we need to actually operate in the existing law. So given that the existing law does require for sites and areas of significance to Māori to be identified and for a management regime to be put in place to give effect to the RMA, why would it therefore be irresponsible for council to do that?
I fully appreciate the difficult situation that the panel is in, and many other panels across New Zealand that already have these plans in process and are awaiting further government direction. It's not as clear-cut as significant natural areas where there has been a specific direction not to map any further SNAs. However, I think the direction from government is that the RMA will have a further emphasis on protecting private property rights. And this, in our opinion, with this type of overreach, is an erosion of private property rights. So perhaps if the mapping was more refined and less widespread, we wouldn't hold this view. Federated Farmers has also written to the Minister to ask for any further district plan overlays to be put on hold. And that is because we find ourselves in this situation where it's very difficult for us and for you as well to continue with this work when we're awaiting the new RMA. So yeah, fully appreciate the difficulty with this.
And so there's an extension to have this plan change in place by March next year. And if we were to so I guess what you're asking us to do is to take account of a political statement rather than the law as it exists right now. Is that correct?
We are asking councils to pause on the mapping of overlays related to Section 6. And that's a national approach that we've taken within Federated Farmers.
Okay, thank you. And now at paragraph 11, you talk about objective 1, and in that you're asking for codification of existing use rights, and it will be very challenging to write into every chapter where a person or group does have existing use rights. So why would it be written in specifically for this chapter and this group and not other chapters? Is your request is very specific to the sites and areas of significance to Māori?
Yes, sorry, can I just clarify, you're referring to paragraph 14? Where I make
13,
the suggestion?
Yeah, 13, 14, 15, yes.
Yes, yeah. So we have asked throughout our submission for existing use rights to be considered, I believe throughout other chapters as well. But in particular, this chapter, with the level of anxiety it has caused for our members, we believe that it would be particularly useful to include this statement within this particular chapter.
Okay, thank you. Moving on to Objective 2, where you talk about that in paragraphs 17 through to 24. This morning, and I'm asking specifically about your request to insert reference to the Trespass Act. This morning we had cultural evidence that said that Māori and mana whenua do know private property rights, and that they, when they're practising mahinga kai, for example, they won't enter onto private property without either landowner and occupier consent. So my question is, why is it for this particular chapter, for this sites and areas of significance to Māori chapter, to use that language of trespass? Is it so significant in this district that it's an issue that it requires that level of intervention?
I think it comes back to the matter of providing certainty for landowners. And when reading this plan, there's so much animosity because they believe their private property rights have been given up by the widespread mapping. And then reading an objective like SASM 02, which is about access, it makes them feel as though anybody can come onto their land because it is a SASM. So it's perhaps something that could have been alleviated through a more involved consultation process when the plan was being developed, or in the early stages of engagement on the plan. But at this point, what we see as a good solution is to include that statement. I've also heard reports from our members where there hasn't been permission asked for before entering land for mahinga kai purposes. So it's anecdotes, but it is happening out there in the community.
In this district?
Yes, in this district.
Can I just add to that? So I can categorically say that I've been involved in conversations like the Friday night pub with people saying they can come onto our land. I'm saying that's not correct. You try and human nature. It's human nature that people sometimes they get frightened by a rule, and you try and explain it to them. That's not what they believe. But if it's written in black and white, it's pretty simple. Go to the plan, have a look. It's written in black and white there. And you try and explain it to someone that there's no right of access to anyone's property. Now, I can't come into your house and use your toilet without your permission. I don't think it's over the top to ask for something as simple as that in the plan.
And so if we look at this is an objective that enables, that is intended to enable mana whenua to have a relationship with the whenua, but it's not one of the rules. The only rules that currently exist in this plan relate to the activities of, for example, earthworks and mining and forestry. They're the rules that say these are the activities that can or cannot occur in certain areas or under certain restrictions. So I'm finding it hard to understand why it's being an objective is being interpreted as a rule.
We're not interpreting it as a rule. We actually were largely supportive of a lot of the changes proposed to the rules by Ms. White. However, this particular objective we just believe could be worded differently to better meet the needs of our members.
Okay, I'll move on to Policy 1, and that's your paragraph 29. And this is where you talk to landowners being involved in identifying the sites and areas of significance for Māori. And this morning we tested with the legal expert here, well, what's the law that applies? And there is actually a difference between identifying sites that Māori would, and mana whenua are appropriate to identify sites, but there's a difference, therefore, in how those sites are managed And so I wanted to clarify that paragraph where you're saying that landowners should be more involved in the site identification. Is that what you really mean, or is it in the management of those sites? Or would you say landowners should be involved in identifying cultural significant sites?
I think landowners should be consulted in the identification of sites because, there are farms in the district that have been held by the same family for several generations, and those families will actually know the history attached to the farm and may be able to provide mana whenua with some information that they didn't have previously. But where I was probably coming from with the amendment in consultation with landowners at paragraph 31 was that landowners need to be consulted in regarding to access. So we would see it working not in partnership, but landowners being aware of potential identification occurring.
Right, okay, whereas I was trying to link that through to the rule framework to go, well, how then would the landowners be able to give cultural value advice on, for example, the impacts of mining? Because that's quite specific type of technical advice. But you didn't mean it in that respect, you're saying, but it's limited only to access.
I was meaning it in respect to access, yes.
Okay, thank you.
But I could just add to that, we can give advice on intensive farming around rock art sites. There's lots of areas that the landowner can give technical advice around, maybe not mining. I mean, there's nothing in the rules that say you can't have intensive farming still, but I mean, because as you keep saying, you're protected under existing use rights. But as we all know in future, things will change.
Well, and actually, the rules did actually put restrictions on intensively farmed stock, and it's Ms White who, in consultation with the cultural advisor, has recommended that that's now been removed from the plan.
Which is good.
And so when I looked at your paragraph, I think it was paragraph 7, and it says that Federated Farmers notes that only minimal changes have been made to the SASM overlays through the Section 42A report, when in fact there's been substantial shifts. Rule 3 has been deleted, Rule 6 has been deleted, temporary activities has been more enabling, building structures above 900 metres has been more enabling. So I'm trying to reconcile the understanding of the actual rules that Federated Farmers has compared to that statement. Like, were you aware that there had been amendments to the rule structure?
When I refer to SASM overlays, I was meaning the actual mapping that had been carried out. That's why I only referred to the boundaries of SASM 8 and 9 in the rock sites.
Right, okay. Whereas what's really important is once those areas are mapped, they might mean nothing. It really comes down to what rules apply, what restrictions apply, rather than them actually being mapped themselves. Yes. And then my very last question was a technical question around SASM Rule 5, and this is mining and quarrying, and sought an increase of quarrying activity from 750 square metres to 1,500 square metres, and I wanted to know what is the basis of that request?
So our preference was actually to exclude farm quarrying in general, and I think we provided a definition for farm quarries that is at paragraph 55. So that's our preferred relief. And then if that's not supported, we just sought an increase to 1,500. And I believe that that figure may have been taken from another district plan, but I would have to come back to you on that.
Okay, thank you.
Thank you. I've just got one question. It's probably going to be directed towards Ms Thomas, and it's really around paragraph 8 and your statistical analysis. And I'll be honest, I'm a bit of a math geek, and so I'd really like to understand how you actually did this, or what the facts and assumptions and the basis were. Because it's it's one paragraph and one table. It doesn't really give a lot to understand how you went about it. So
yes, I appreciate that. So this mapping data was compiled by our GIS specialist who works within our team, but across the whole country for Federated Farmers. And the data was taken from Agribase based on the number of farms that are within, registered within Agribase. So she obtained the data by contacting the council, actually, who provided the layers for her.
Right.
I'm sorry, I can't give you any information on the assumptions within those, but the data has come from the council via our GIS expert.
Okay, thank you.
Yes. Your paragraph 51, I'm a bit hung up on the words perceived automatic right, and I want to know what the basis for that was.
So this is probably back to the access issue, which we've discussed in detail already, that farmers feel that there's an automatic right to hold a temporary event because there hadn't been that clarification included in the plan about access. So I think Mr. Anderson's explained some of the feelings that farmers have had about that.
Was this targeted at, who was it targeted towards? Was it targeted towards the council or Kati Huirapa?
The perceived automatic, it's targeted against anyone who feels that they can access a SASM to hold a temporary event.
Okay, thank you.
That's right. Ms. Thomas, I wondered, you've made a number of statements and we've canvassed this already, a number of statements about impact on property values. Has Federated Farmers sought and obtained any valuation evidence on the impact of the mapped SASMs or the rules that underpin or would apply within those mapped areas on farming properties?
Federated Farmers has not conducted this work, but it is something that would have been useful for the council to have conducted alongside this chapter, I think.
Can I make a comment there? So it's going to be difficult to see the reduction in values because very little of this land has been sold since the SASMs have been, come on the district plan. The test will be, and when properties, if you go to a farm and there's 100% SASM on the farm, are you going to buy that or the next door neighbour's place? That will be the test on valuations. I know that's all in hindsight, all in theory, but the test will be in the future.
Would you agree that so it's more of a perceived concern about the impact on property values rather than an actual impact that's been assessed by anyone?
I haven't got hard empirical evidence, but you could be correct.
We have done some work at a national level on the impact of overlays, and that work is continuing. And what we are seeing and where that stat has come from is at a national level, some of the impacts on capital values. And I mean, anecdotally as well, when you've got farmers going to the bank and they're asking what overlays they have on their property, that's a clear indication that there's going to be an impact.
Do they not ask what rules apply within those overlays?
Not sure that their expertise is quite that developed, unfortunately, but yes, they should ask that.
It's interesting that you keep, and I mean, I understand when you're saying that the rules under the overlays aren't onerous. I mean, there's some there that are going to cause some problems, but they're not going to, and I know this is not your job, but you can understand human nature, and history has proven it, in my lifetime it's proven, that once something's there, rules change. And usually they get harder. That's a fact. It's not something I've just made up. Usually rules change. So if you've got a farm that's got 100% coverage of an overlay on their farm, you know in the future that there's going to be more rules go on that property.
And as you point out, we're making our decisions within the context of the information that's in front of us and the legal framework that currently exists.
I understand that, but I've got to try and voice the opinion of how we're being affected.
I appreciate and respect the fact that you are advocating on behalf of a community who have some concerns. So thank you very much, both of you, for your presentation today.
Thanks very much, and thanks for the time.
Thank you.
Templeton here to present.
Good afternoon, panel. Please excuse any procedural errors. I'm a historian. This is my first time, and I have no legal training. I'm more nervous than a cat in a room full of rocking chairs. My name's Christopher Templeton. By trade, I'm an organ builder and also a historian. One of my areas of focus being the Timaru residential built history. I've been a long-term committee member on the South Canterbury Museum, South Canterbury Historical Society. I'm also on the Timaru Civic Trust Board and the South Canterbury representative on Historic Places Aotearoa Executive. So I've seen the assessments done on the two buildings I propose to go onto the schedule by Dr. McEwen. And I'll just address an argument that was brought forward up in both reviews of 9A Sarah Street and 32 Bidwell Street, which was also echoed by Precision Securities Limited in their submission. That is the argument that in the case of Wharenana, Bidwell Street, the building's use as a private hospital was relatively short-lived. And in the case of Elton House School, the building's period of use as a private school was very brief, which was also echoed in the submission by Precision Securities. However, that argument is not in keeping with the Timaru District Council Historic Heritage Assessment criteria, and that none of the criteria mention the length of time that a structure was used for its built purpose. The only mention is in Category A under Historical and Societal Values. Historical and societal values that demonstrate or are associated with a particular person, group, organisation, institution, event, phase or activity, the continuity or change of a phase of activity, social, historical, traditional, economic, political or other patterns. So that's the only mention of any sort of duration of time. The argument saying that because it was only used as a short period of time, it's not relevant, goes against existing and proposed entries in the district plan schedule, where there are buildings and structures that are no longer used for the original built purpose, or in one case, has never been used for its original purpose. For example, the original water race tunnels, they're no longer used. They haven't been used for longer than they actually were used. The Heathcliff Craighead School, which was originally a residence for 36 years, but it's been a school for 114. And indeed, it's on the schedule because its use changed from a residence to a school. This building here itself, it was scheduled in part because it was a library down the other end. It's no longer a library. In fact, the whole inside was gutted. In fact, the air raid shelters were never used for their intended purpose, thankfully, but they're still on the schedule. So the argument that because it was only used for a short amount of time actually goes against existing standards in the schedule. Now on to the submission on 9 Sarah Street. We'll just wake that up. As both, let's see, oh yes, there we go. There's an early photo of it, and does this work? I was told it would. No, you can... Sorry, I was told there was a pointer on this there, but it's not. You can just see, half obscured by the tree up there, in the background, the house. There it is. Ah, there we go. We are. So, the review of 16 Sefton Street, as you can see from the following images, since most of you I understand are from out of town, I thought the best way of doing it would be actually showing you the building. The following images show the external staircase and modern annex. The review of 16 Sefton Street seems to underestimate the historical and societal significance of the building. There we go, your review. One of the limited number of occupations available to single women in the late 19th century was that of teaching. As of those women that were teaching, those in the private sector mostly taught from a family home or worked in private schools. As far as I could trace, there were only two previous single women that commissioned and financed their own private boarding schools. Mary Ann Swainson in Wellington in 1878, and Bramer House Boarding School in Dunedin, which was built for Miss Jessie Dick in 1887. Alton House School, being built in 1895, seemed to be the third. So if we just scroll through, there's the building now, and that's the new annex, well, new, 1960s, and a privately run boarding schools built in New Zealand. This appears to be the oldest surviving building, both for girls' boarding schools and, as far as I can trace, boys' boarding schools as well. There were a lot built about the turn of the century or just after, but this one seems to be the oldest surviving. Well, apart from one nail that is traditionally passed down from headmaster to headmaster from Marsden School in Huntly. The submission for the inclusion of Alton House School on district plan schedule seems in one sense dependent on its historical and societal values of the building outweighing the shortcomings of the external building modifications. So here you can see, if I can work that out, there's a later addition of a window and the staircase when it's been divided into flats, and you can see the new wing out the front there. The societal values of the buildings include that it was built to fit a perceived societal and educational need, that of a girls' boarding school. The economic value of it was that a single woman was able to commission and finance the building of a two-storied boarding school well before any other private boarding school in Timaru. And indeed, Craighead didn't build its own boarding facilities till well after the Second World War. They recycled buildings that were gifted to them. The institutional value is that despite the Education Act over a decade before Helen Leeseman arrived in Timaru, she was still able to found and run a girls' boarding school amongst competition from other private day schools and evening classes. The Precision Security submission asked for evidence to provide a negative with a statement in the original submission, but where I stated that it's possibly the earliest remaining example of a privately built boarding school. In terms of assessing the evidence available, papers passed, existing private school websites, archivists, street directories, school history publications, and an article in Historic Places Aotearoa quarterly publication, Heritage Voices. I found that there were only two other girls' boarding schools and 3 boys' boarding schools that were earlier, and none of those buildings survived. However, there are buildings and boarding schools well into the 20th century that do survive. So this would appear to be the oldest surviving boarding school in New Zealand. I would love to be proved wrong if somebody wanted to spend another 3 months researching and going through to find an early one. I wouldn't mind being proved wrong, but as far as I could tell, it was. Coming to the Wharainana Maternity Hospital, Regarding the historical and society significance, the report by Dr McEwing seems to have missed the significance of Whare-Nana Maternity Hospital in relation to women's health and employment in the early 20th century. In 1901, the Nurses Registration Act was passed and came into force in January 1902. This was followed in 1904 by the Midwife Act, which was enacted on the 1st of January 1906, with the latter providing professional training in various hospitals, which were called the St Helens hospitals, and later registration for midwives. This brought about a change in midwifery, and that formerly the domain of married midwives with mostly informal training, it now became a professional career that was open to single women. The comment in the report under historical and social significance, quote, "The building represents a period in the history of midwifery in New Zealand wherein those who could afford to pay for private care had their babies in hospital settings rather than at home." Unfortunately, that remark could be seen as rather disparaging. What the building of Whare-Nana represents is both a society change and a cultural change, of which Nurse King and White were amongst the first wave. Up till the 1904 Midwifery Act, midwifery care in New Zealand was literally a cottage industry. There were a small number of midwives who had some medical training before migrating to New Zealand, or were some nurses that moonlighted or retired and became that. However, midwives often had no formal training and were usually married women who had given birth to children of their own. And the expected mother was either visited at the home or would go to the midwife's home and stay until the birth and recovery. And with the midwife being married, there was another form of income from the husband's job. Numbers for 1920, I haven't got early numbers, show that 65% of mothers still had their babies at home or in the small single-bed homes that did not require registering as a private hospital. 26% of births occurred in private hospitals, 5% in hospital board and charitable hospitals, and a small percentage, only about 4%, occurred in the St Helens training hospitals. Although the training midwives students also attended home births. Just 7 years later, by 1927, 58% of births took place in maternity hospitals, and in 1936 that figure was almost 82%. Excuse me. This is rather nervous work. With both Nurse King and Nurse White being early graduates of the new system and registration, the moves to commission and have built a maternity hospital in Timaru showed an early effect of the change of societal thinking to midwifery and childbirth, rather than just representing a period in history of midwifery in New Zealand, wherein those who could afford to pay for private care had their babies in hospital settings. It's a fact that after the Midwives Act, such a hospital as Whare-Nana could be built and run by a single woman, independent of a husband's income, and run as a business. And that is the social significance of the building. A whole new professional occupation opened up for a single woman, and the building of Whare-Nana is a very early surviving example of it. The Heritage Review mentions the claim in 1943 at Timaru Herald that it was the first purpose-built maternity hospital in the country. That claim is very difficult to verify. Well, actually, it's very tiresome to verify, especially, this is her quote, the claim is very difficult to verify, especially as maternity homes could also function and be described as private hospitals. By way of comparison, Dunedin architect Basil Hooper published a photograph and a floor plan of a private hospital that was extant in the city by June 2007. So Dr McEwing showed an example of another private hospital being built that was even earlier than Whare-Nana. And the Timaru Herald article makes the claim in 1943 that it was the first maternity hospital in New Zealand. This claim, although time-consuming to verify or disprove, was a lot easier than trying to prove an early boarding school. The Heritage Review mentions, along with the statement, maternity homes could also function and be described as private hospitals. Dr McEwing is correct in that a maternity home could be described as a private hospital. However, not all private hospitals were maternity homes. the Private Hospitals Act of 1906. They were really into medicine in the early 20th century when it came to Parliament. States the licence shall state whether it is in respect of a lying-in private hospital, that's a maternity hospital, or a surgical and medical private hospital, and no lying-in patients shall be received in a private hospital unless it is licensed for such cases, and no patient other than a lying-in patient shall be received in a private hospital licensed for lying-in cases only, provided that where the Minister is satisfied that the accommodation is both suitable, he may specially license a private hospital for both purposes. Therefore, and except for a few ministerial exceptions, a maternity home could be called a private hospital. However, a private surgical hospital could not be a maternity home. The home that Dr. McEwen mentions in 1907 was a surgical hospital in Dunedin, not a maternity hospital. And the stats for the House of Representatives for the year 1910-11, and I made a mistake on that date there. There were 218 licensed private hospitals, 52 were medical and surgical, 133 were maternity, and 31 were both. And you can see the example below where it was outlined that basically never the twain should meet, except in small towns where you couldn't have both. In collaboration with Lisa Trutchman, who had been researching the history of private maternity care in New Zealand for well over a decade, we were able to determine from available sources that the first purpose-built private maternity hospital was Melbourne Maternity Home in Ashburton, which had its first birth there on the 16th of September 1907. Wharainana was the second privately built maternity home in New Zealand, not the first as stated in the 1943 article, and it was opened on the 21st of January. And the first home still exists in Ashburton, although it is no longer a maternity hospital as a hall. There's an aerial view in 1939. The Heritage Report states that there was little contextual value left around the building. However, from that 1939, there's the hospital there. That I went through the 1914 street map, and all those houses were there. There were 5 houses on that cul-de-sac on Bidwell Street, 5 along Elizabeth Street, and 4 down Lacrene Street. So at that stage, and the latest one here, it hasn't been apart from some infill there, the site's basically as it was in 1911. It had a sunny north-facing view and a quiet cul-de-sac, and indeed when Wharainana moved out of that premises, they literally jumped over the fence and went into that house with a blue roof there when they downsized in 1929. The only thing that's been lost in context of the surrounds is the lawn and flower beds that were landscaped in front of the building. And there was also another private hospital where the big Bidwell complex is over the road there, which is a surgical hospital. There was a smaller version of that on the corner concurrently with Wharainana. So in the major sense, the contextual significance has not been altered that much, just with some residential infill in the hollow, this thing's buzzing at me, in the hollow there, which is the lower ground below the hospital. The building, as noted in Dr. McEwen's report, has been altered. The verandas have been enclosed. However, the original design features have not been removed, only covered up. For example, there's the earliest photograph I've got of the hospital from 1961, where you can see the west wing, half the verandas have been enclosed. Those are still open. That was enclosed about 65, 67. The original doors, there you can see where it's been enclosed on the east wing. And still the original balustrades from there. The original doors from the patient's room leading out to the verandas. There's part of the closed veranda. The original doors from the patient's room leading out have either been retained or the doors boarded up, leaving the original transom windows above. This is not the case in the isolation wing. Oops, that's a photograph of showing some rather interesting pyramid foundations, which are quite unusual for there. And as we head round the side of the building here, there's the big old wash house at the back. You'll notice there that the original, we've got some older style sash windows there, whereas all the rest of the windows in the building were casement windows, which indicates that could have been part of the kitchen facility. That's the biggest modification there, where you've got two doors actually bricked up. The design values are still recognisable even with infill, a wide wraparound veranda, two main wings and a separate wing at the back. This was a building built to catch the sun and natural ventilation. Dr. McEwen's report summary states that the form is a bit unclear with all the infill. I'd say that you look at the building and you can say, well, that wasn't a house. That was never a house. That was a hospital building built when the days of sanatoriums where they were after sunlight and plenty of fresh air. That can be no other thing. So although the building used as a private maternity hospital was relatively short-lived, only 18 years, as mentioned, that should not have a bearing on the submission, as it is the fact that it was built as a maternity hospital that is what makes it historically significant, not only to the district, as the birthplace of thousands of its residents, but also in a wider national context as an early surviving example of a building built for a new occupation, that of a professional self-employed midwife. As to the architectural criteria and significance regarding the building alterations, the question is, even with the subsequent changes to the exterior of the building, is the building still recognisable as to what purpose it was originally built for, that of a hospital? To that, the answer is yes. For these reasons, I would consider that the building does meet the heritage assessment criteria for scheduling on the district plan. Both Elton House School and Wharenana Private Hospital were conceived for by women, funded by women, run by women, solely for the benefit of women in South Canterbury. Since the odious felling of the champagne tree, which was an early tree planted by a European pioneer, Elizabeth Rhodes, was over 150-year-old, and a landmark in Timaru, was felled before it was able to be on protected status. Since that was felled, there is no publicly recognised site or structure acknowledging the contribution of women to the early history of Timaru within Timaru itself. The only scheduled building, that being of the Eleanor Tripp Memorial Library. Now is the opportunity to recognise and acknowledge these buildings' importance, not only to South Canterbury history, but to that of the country. I would say these buildings need to be protected as much as the champagne tree, and being on the schedule is the only way to do that. Thank you. Ka mihi. Any questions?
Kia ora. Thank you so much for a very enlightening presentation, very fascinating and incredible to hear that detailed account of contribution of women. It's something that you don't often necessarily get the depth of understanding about, so thank you for that. I've learnt a lot. I've understood your presentation and your submission. It's very clear. One thing I did want to check with you, I didn't, at the very beginning of your presentation today, I didn't quite catch your experience. You mentioned you're an historian.
Yes.
Could you just talk a little bit about your background and what you do presently?
I have been a part-time museum worker for 25 years, well, actually 25 years, weekends at the museum. I've also researched various, I've done one book for the Organ Preservation Trust, Organ Historical Society of Australia. I authored their conference book for New Zealand in 2016, I think it was, gosh, that long ago. And I've also been doing research for very other topics mentioned in at least 3 other people's thesis and about half a dozen books. So yeah, I've only written 1 book myself, but yeah, it's just time. Yeah.
Very active in this space.
Oh yeah, can't you tell?
Well, thank you very much.
Thank you.
Yeah, kia ora. We might have some more questions.
Oh, sorry.
I have a couple.
Yeah.
But first, it's an observation. So you were here for the afternoon, so you would have heard us talking about sites and areas of significance to Māori. And when I look at the schedule of, there's 221 historical heritage items in this district, and then I pick up the SESM chapter, and there's very few, SESMs here listed.
You'll have to translate that acronym.
SESM is Sites and Areas of Significance to Māori.
Thank you.
So 221 historic heritage items, very few of those sites. And I think it's because we're talking different timeframes, right? And over time, things are lost.
Well, there's also, I think Andrew Coleman in one of his speeches mentioned, most of the Maori history is underground.
Right, that's really interesting.
Yeah. The Europeans built heritage, especially in the South Island, where the weather's a bit more atrocious. Takata Whenua history is underground.
Underground, yes. And, well, why I'm pointing out those numbers is really to focus that you've put forward 2. You've said in this district there's 2 particular ones that are missing, and so...
I could have put forward a lot more earlier built history in Timaru. It was just those were 2 that I felt were the most important, especially once the Champagne tree had been felled. There was actually literally nothing that recognised the contribution of women left in Timaru.
Great, thank you. That was my question, why these 2? So that's really helpful. And then the other... So we haven't had the benefit yet where ordinarily we would have talked to the reporting officer and Dr. McEwen as the expert to talk through these 2 properties from her perspective, but we haven't done that yet, and so we're meeting with you first. When it comes to the former Elton House Girls Boarding School, part of her assessment was that it's been substantially modified, and that's why it hasn't retained a high level of authenticity. So what's your view on that?
That is the most difficult one, but you've got to weigh up. Yes, it has been altered. You can't see the north front has been severely altered. It's got a new, very out of style annex on the front. So that's one. Fortunately, it's up to the 6 of you to weigh up. Does the societal value of it make up for the difference, the lack with the originality on the front, especially with the staircases down the side and some of the casement windows. You can see, oh yes, they're later additions. We can see what it was like beforehand if you just imagine it without those. But that whole front, you can't imagine what the ground floor looks like. So that's one where you have to weigh up, does the societal influence and the cultural influence of it being a girls' boarding school make up for that loss of heritage? Yeah.
That's a very helpful answer, thank you. And I have a similar question for do you call it whare nana?
Yes.
Whare nana, okay,
yeah.
Right.
It was apparently, whare was the Maori term, but nana was, as far as the legend goes, it was actually one of the languages from India that they combined the 2 to became a house of comfort. I think it was the name.
Comfort. Okay, yeah. Thank you. So Dr. McEwen, she has said that in her assessment, although she acknowledges it has historical interest, but its integrity is now such that it no longer embodies significant architectural and craftsmanship. So would you agree with that statement, and is it a weighing up again, or do you disagree with that statement?
I would say yes, there has been changes, but not enough that you can't see what architecture was like beforehand. If the verandas were all completely covered in, and you couldn't see inside that first veranda, inside the first door, and if the balustrades, if that whole side was enclosed and to make one long facade, I would say that yes, you couldn't recognise it as a hospital. Even if the verandas were fully enclosed, you could still see from the front door and the steps going up, you've got verandas either side, that yes, it was a medical facility built for open air and sunshine.
Correct.
So she is right, it has been changed, but I can say you can see through those changes, still through those changes to what it was like originally.
That's really helpful. Thank you very much.
Thank you very much, Mr. Templeton, for your journey on the history of these buildings. I'm concerned about the natural justice here and what impact this would have on the building owners. My question to you is, have you had any interaction with the landowners with regards to listing them on Schedule 3?
No, the only interaction, I didn't know who the owners were until I got the reply back for the reports. Being a historian, I would say, who buys a building without first investigating what the history of the building was like? So, although there would be restrictions put on the building owners, then that would also, you've got the Council Heritage Fund, which is set up specifically to alleviate such restrictions as may be if they want to do work on the building.
Do you know the value of that fund?
$5,000.
Yeah.
Plus, once they're listed on the schedule, they'd open themselves up for other funding available. I can't say they get any funding from HNZPT at the moment because they were strapped this year, but there would be funding available from them. There's funding available from other sources, such as the Civic Trust, Heritage Fund. So yes, it does put restrictions on the building owners, but there are funds to ameliorate that. And as the buildings now are residential flats, I can't imagine that they're wanting to make that much drastic changes to affect their income anyway.
Questions, but I just want to thank you for your really helpful and informative submission. It was a nice respite from reading rules and policies and objectives. Thank you.
Yeah, thank you.
No, I have no questions for you, Mr. Templeton, but thank you very much for your presentation today.
Thank you.
Thank you. The panel will take a 15-minute break now and return for submissions. Sorry for the delay to Mr. Harford, but we'll be back very shortly. Thank you.
house, and I'm sorry, I just have to look here. She started using it as a boarding house and private hotel instead. So obviously the school did not meet her requirements as far as finance, etc. probably went. And in 1904 she sold it and went back to England. The house has been owned by various people, including 2 doctors who ran their private practices there. And in my time, there was a doctor next door. That house is gone. It was just a common thing in those days that houses were used for doctors' practices. It was then sold on to my in-laws at the time. I have spoken to my sister-in-law, who actually resided in one of the flats in 1964, and she confirms that a lot of the alterations have been done since then with consent of the council. There have been the addition of the front office block, the addition of a large area at the back, and also an addition on the eastern side, which does cover a considerable amount of the original facade of the building. Yes. Other than that, there was another private school in the area, Ashton School out at Temuka, and I have here, it was from 1895 to 1898, same sort of time, and in the Timaru Herald of 95, they were advertising for boarders, and it was recorded as being in 1896 at the breakup of Miss Withy's school. So that sort of activity, and of course there was the Fitzherbert Terrace School in Wellington, it was all that sort of thing was going on around the whole country at that time. As we know, schools like Christ College, Rangiruru, St Margaret's, and then Craighead, of course, they were all private schools that have actually developed from that early time. Yes, I can confirm there has been a fire in one of the flats, and of course it is quite markedly altered. There is no central staircase because the front door and all the entrance and everything is gone. There are 5 entrances to the place now. It is quite different to its original facade and actual building. Some of the materials used, even on the original roof, rib roof, there are aluminium windows in the building. There are all sorts of modifications that would not be part of the original building as such. Other than that, I can't think of anything else that really relates to the building as such. Thank you for allowing me to speak.
Thank you. Was there anything further, Mr. Harford, you wanted to say, or I'll throw it to panel members to ask some questions? Okay, thank you.
Kia ora koutou. I do have a few questions. The first question is for you, Mr. Harford. In terms of the process that's been followed here and Mr. Templeman putting in a submission, and I've heard from your client that there could have been other ways to contact them, including looking at doing a company director search. Would you agree that Mr. Templeman has followed the correct process as far as a planning expectations are concerned for a district plan review?
If I'm not mistaken, I don't think. If I'm not mistaken, I don't think Mr. Templeman is under any obligation to contact us at all. It's probably more of a courtesy thing to do that, to just drop those papers on us to make, because this is where we got caught on the hop. But if I know that my understanding is right, I don't think he's under obligation to do that.
Right. Thank you. The next question is around like with this particular building, and trying to understand how these rules will impact on the building if it was a heritage item, then, and I look at the rules and you've got restrictions on external strengthening, demolition, and external alterations, and relocation, I think, as well. So if we look at these rules, what's the plans at this stage for this building? Are there renovations planned or changes intended?
My understanding is no, there's not. You might like to elaborate. You've got
no. There are no immediate. There are no immediate plans. At the end of the day, my father has only passed away within the last year. When we have taken over as part of the trust, we are currently considering what we do in that regard with the trust and the financial implications of what we do. And we will probably make some decisions over the next, let's say, 3 to 8 years around it, but in the immediate term, no. But it will have a significant impact on us if it becomes a heritage building going forward, and what we will be required to do.
Right, and because I'm trying to get my head around, there's no requirement to maintain, there's no requirement to do things, but there's an additional cost for how you do activities once it's listed. So I'm trying to get the difference between, like, there's no requirement to maintain, but there is a requirement that if you're going to do external works, that it's consented.
I would suggest that extra works will come out of the maintenance process. I mean, that is just a reality. I mean, I would suggest that over time you may have to change the facade because you will need to replace boards, etc. I mean, it's weatherboard. There could well be, it's the same situation with windows and that type of thing, as my mother has spoken to. There is already examples where things have changed in there over time because of what would now be considered the maintenance, i.e. roof cladding, window sashes, all that type of thing, and that will become more restrictive.
Yeah, to keep to the original.
Yeah.
Got it, thank you. And my last question is, we asked Mr. Templeman why these two? Out of everything that he could have submitted on, why these two? And he talked about being examples of, I guess, women pioneers and honouring women. And he said you really do have to weigh up whether that cultural value and social value is just as important as, or more important than the changes that have been made. And so how much value do you place on that in particular, the cultural significance from his perspective of honouring women, pioneering women?
It's certainly a consideration. We're not because that's part of the heritage considerations is that historical fact. We're not denying that. In terms of what sort of weight we'd give it, it's only it's part of the bigger circle. It really is. In my view, I think just my own opinion here, had this been some heritage significance, possibly 20, 30 years ago, council may have decided to put that on the register then, as opposed to now. That's my opinion only.
Great, thank you.
Excuse me, could I just say something? In regards to that, I am actually quite interested in history in Timaru, and it had never been mentioned to me at all, and yet I have been in that building when it was a doctor's surgery, when I was about this high at primary school, never knew anything about the fact that it had been a school or anything else. It was just a residence. I've also been in buildings like Agantai, where I visited with old Mrs. Grant when I was so high. I do know a lot about the history of Timaru, and this particular building has never come up as being significant, where Agantai and other such buildings are important in the town. Yes.
Great, thank you.
Thank you.
And that probably goes back to one of my original statements. I mean, I'm not demeaning in any way what women have contributed to this society or what occurred back then. I am not in any way. But when you weigh it up, maybe my challenge back to you is my first statement of how many people will actually, if you went around Timaru and asked them to stand in that site and said, what was the significance of this site, what is the social value of it, how many of them would be able to answer it with Mr. Templeton's answer?
Thank you. No questions as such. I was interested in teasing out the kind of the implications from the rule framework if it was going to be listed. However, that's been well traversed, and I'm quite clear on your key concerns and why you have those concerns. So thank you for your time. Really useful for us to hear about your first-hand knowledge of the property, yeah, we'll take everything that you've said into consideration. Thank you.
Thank you very much.
And just no further questions for me. Also, Mr. Harford, I note that you do place some reliance on Dr. McEwen's evaluation of the heritage. We haven't yet heard from her, and we will do so shortly if she's managed to hold on for the day. So you may want to stay around and listen to that. We'll ask her some questions whether she has altered any of her views, having now heard from Mr. Templeton and yourselves. So thank you. Thank you very much for your time today. To you all, who's taking the lead? Mr. Anderson?
Yes, it'll be me. So kia ora, I'm Tom Anderson. I'm the consultant planner engaged for the telecommunication companies. With me today we have Graham McCarrison from Spark on my right, Andrew Cantor from Chorus on my left, and Fiona Matthews from Connexa online. Colin Clune from 40 South/One New Zealand, formerly Vodafone, can't make it. I'll provide a very brief summary of my evidence, or happy to skip straight to questions. Take your lead on that.
Just so that we have our head back in the game on these technical issues, if you could just give us a very broad overview of the issues, please.
Certainly. As a result of the recommendations in the 42A report and also the summary statement, particularly of Mr. Willis, that's been published, I think the telecommunication companies are in a very good place with regard to the PDP. However, there are some matters highlighted in my evidence where alternate relief is sought. There's one definitions matter, which is concerning the definition of tower, to make that definition solely relevant to electricity infrastructure, and that is to allow the NESTF, which is reliant on district plans, and the definition of pole and that to be able to work in with the definition of tower in the PDP. Turning to the energy and infrastructure chapter, I seek an amendment to Objective 2 regarding the avoiding remediation or mitigation of adverse effects to the extent practicable, while considering the functional and operational need for infrastructure rather than considering the underlying zone objectives. I also seek an amendment to Rule 14 regarding how telecommunication kiosks should be set back from road boundaries and ensuring that that's aligned with the underlying zone provisions for buildings, and an amendment to Rule 17 concerning the footprint of utility buildings so that a limit of 20 square metres is only applicable in residential zones, as well as clarity that the rule does not apply to structures within existing buildings. Turning to the heritage chapter, I seek controlled activity status for customer connections that are not permitted activities, and the purpose of that is to ensure that heritage buildings can be appropriately serviced by infrastructure, while also ensuring that council has control to manage any potential adverse effects on that heritage building. And with regard to the tree chapter, in a similar vein, seek amendments to Rule Tree R3A that was put forward in the 42A report by Mr McLennan to provide for new customer connections within a root protection area of a notable tree as a permitted activity where strict measures are met and controlled activity where they are not. And again, this is to provide certainty that people can connect to infrastructure while also providing certainty to council that adverse effects on trees are provided for. That's my brief summary, and happy to take any questions. Thank you.
Thank you. We've jumped around a little bit from plan chapters, and so I had the heritage chapter in front, so I'm going to start there. I hope that's okay.
Absolutely.
In regard to the customer connection to heritage item, it's the proposed rule HHRX.
Right.
Can you please talk me through what you're pursuing and the point of difference with the Section 42A recommendation there? Is it purely an activity status?
Purely the activity status on when you're not complying with the permitted provision in that rule. So it's controlled activity is what we're seeking as opposed to restricted discretionary, which was what was put forward in the 42A.
And that's essentially just reflecting, in your view, a less onerous pathway for activities that you will encounter?
In a way, I think I look at it more as providing the certainty to the owner of that heritage building or the occupier of that heritage building that they can have a customer connection to use it for purposes, while also providing that surety through the matters of control to the council that those effects on the heritage building can be controlled.
Right, so in that sense, you're seeking that certainty. So if it was in any discretionary pathway, there's a risk that it could be declined.
That's right.
Yeah,
and
okay.
I fundamentally don't agree with that because I think there's a need for these buildings to be repurposed and reused for modern purposes, and therefore infrastructure, service or customer connections are important.
Yeah, great. Okay, thank you for clarifying that. And I don't think this was directly something that you submitted on, but I'd be interested in your perspective. We do have, there has been some level of disagreement as to whether the interpretation of primary feature or front facade within that rule could be confusing or difficult to interpret. In your experience, or from your view of that from a planning sense, is that relatively straightforward to you to be able to understand what that would mean?
Yes, and it's the street frontage of the building in my view, but I will hand over to Mr Cantor from Chorus who deals with these regularly, and maybe I'll provide some further insight.
That's correct. Our experience of this is traditionally that would be the sort of street facing part of the heritage building. Obviously if it's on a corner that becomes two sides of that building. If there was by some quirk that the road came after the building and the primary feature were at the rear of the building, then it would be that. And it's usually my experience of these buildings where there's a primary facade is it'll be that street facing side. It's a lot more ornate. You get to the side of the building or the back of the building and it's a lot plainer, if you like.
Right. So on the face of it, that the rule as drafted on the face of it, from your perspective, is easily interpretable?
Correct, and we've had the same rule in other parts of the country, and we're in discussions with MB and getting the NES updated, including similar wordage to that.
Thank you. That's all my questions for now, but I might come back if others have some more.
Well, kia ora koutou. I have a few questions, but I think I'll just pick up my question that's still related to heritage. And this was a question for Mr Cantor from Chorus, which is in the joint statement. It says that Chorus has developed in partnership with Heritage New Zealand guidelines for designing connections to scheduled heritage buildings. And I wanted to know, given that you've done that, why did you not present that evidence to us? Because that might have been helpful today.
I'm certainly happy to provide it subsequently. I guess this rule is a part of that guideline, whereas those guidelines go into a lot more detail around, I guess, scenarios where you can't avoid that front facade, and then you move into the, your controlled activity status and the options you would do following that path?
No, that's helpful to understand. Thank you. Jumping around all the chapters, I might as well go to tree now. So, tree provisions. So, and this is paragraph 56 to 62 of your evidence. And what I'm understanding here is that what you've asked for is, well, certainly what the council parks manager has said is that there does need to be an assessment on a case-by-case basis for with the advice of an arborist. Therefore, a permitted activity status wouldn't be appropriate for that rule, for Rule 3A. And my question, and my understanding of your submission and your evidence is, well, the works would be undertaken by an arborist in any event, so there's no need to have a resource consent process. But isn't there a difference between an assessment being done by an arborist as to whether or not it would impact, as opposed to being engaged to complete the works?
No, I don't think there necessarily is. I think that point 6 of what we've sought to be permitted activity 1 under trees 3A, so I'm working backwards there.
Yep.
But that the works are under the direction of a qualified arborist provides that same rigour and testing to ensure that the tree is protected. So there's an arborist on site supervising the works, and again I'll pass to Mr. Cantor, who regularly undertakes these works with lines that often are in a constrained environment and have nowhere else to go. And it's certainly a rule that in other district plans we've worked with, that requiring an arborist supervision for the work is what, as a permitted activity, does not impact on the health of the tree.
Okay, right, got it.
Yeah, if I would just add that in the instances where we have obtained a resource consent, it's essentially those permitted activity conditions are what ends up getting put on that consent, is that you need to undertake that work under the direction of an arborist. It doesn't necessarily change how the work will be done.
Yeah,
if we could avoid going within the drip line of the tree, we would be doing that anyway, because then we don't need to engage the arborist. And also it's just hard to dig through tree roots. You'd rather avoid it if you can. It's only in those instances where we can't, we would engage an arborist. But a resource consent, I don't believe, would change the approach.
Yeah, that's my thought as well. I think the assessment would just ultimately end up in the requirement for that supervision. So why don't we have that requirement for supervision?
Yep. That makes sense.
Yeah.
Yep. Thank you.
Can I just jump in and just ask, just on that, is there a place though within that framework for some kind of record keeping or information to be provided to the local authority if that work has occurred? Or do you think that's unnecessary?
I don't think it is necessary. It certainly isn't necessary in other parts of the country. If Chorus or whoever it is undertake the work without supervision of an arborist, then they're up for prosecution. I don't know why they would want to take that risk. And in terms of record keeping, again, I'm not sure what record would necessarily be kept. It's not something that gets built on for another project, or it's specific to those works.
In your experience, is it work that's so innocuous basically that as long as it's done properly at the time, there's no need for any ongoing?
That's correct, and as the permitted activity conditions require, it's done by hand tools.
Yeah.
Or hydrovac, it's not done by an excavator sort of trenching through the drip line of the protected trees. And if something were to happen to that tree, the property owner knows that we were there because they asked for the connection. So if that became, in terms of a record keeping what happened to that tree, that's where your record will be.
Okay. I only have one more question on the tree, but then I've got a couple more on the EI chapter. But there's 169 notified trees in the district, which isn't a lot for the size of this district. Like, how often would you anticipate having to actually do the works in the drip line?
I would suggest it would be pretty rare within Timaru, but we seek these conditions, standard conditions across the country.
Okay, great, thank you. My next question is on EI Objective 2, which is paragraphs 30 to 37 of your evidence. And you've asked for an amendment to subclause 2 there. And when I read what the reporting officer has agreed to, which is to include and other infrastructure in the heading, then I really couldn't see a difference of the relief that you're seeking would already be covered by clause 1.
Just bear with me while I reread it in that context, thank you. I think it's the reference to the effects management hierarchy in EIP2 or the National Grid, but I see exactly what you mean. I've read effects management hierarchy there without having strict regard to EIP2, which we haven't got on the table. There is significant crossover between the two, and the essential point that I'm trying to make here is I don't think there should be recourse to the relevant objectives and policies for the underlying zone, given there can be an incongruity between a piece of infrastructure and the amenity values of a zone, yet there's a necessity, so that's why it's reduced to the amount practicable while considering the need for the infrastructure, as opposed to consider how you might screen, say, a cell phone tower when it's in a residential zone, and that could fundamentally remove the reason why it's there in the first place, or undermine the reason why it's there in the first place. So trying to achieve that balance, that there are instances where infrastructure is in more sensitive zones, but it's there for a reason, and it's got to be limited to the extent possible and practicable.
Right, okay. Well, thank you for that. My next question is in regards to EI Rule 14 for telecommunication kiosks, which is 38 to 44 of your evidence, and note that you've raised issues of inconsistency across the plan, which we'll have to kind of address in integration. But if we put that aside, then I'm finding it really difficult to understand why a setback is not a good idea, because you get a traffic management assessment and safety issues would be considered if the kiosk is located in the road reserve, but not if it's like 10 centimetres outside of it. So given that, wouldn't a setback outside of the road reserve be a good idea from a safety and traffic perspective?
Yeah, I think fundamentally though, when you walk around, particularly these zones that I've listed here, a setback from road for buildings, like for instance this building, doesn't occur. You can't tell whether the threshold between a building and the public realm or the road is the facade of the building. It's not a 2 metre setback. So while that in itself probably has a degree of traffic safety issue, I don't think it leads to the best urban design outcomes, and therefore I think if there is if there was to be a setback on traffic safety matters, then yeah, absolutely the telecommunication kiosk should be aligned with that. But it'd be very unusual in my experience that the zones I've listed would require setbacks from the road.
Okay, thank you. It's helpful. Final question. This one's on EI Rule 17, which is paragraphs 45 to 50 of your evidence. And I'm trying to reconcile what you've said in paragraph 46, which is the relief sought there is rather than have a footprint or site coverage requirements, then you have to meet the restrictions within the zone. But then at paragraph 50, you seek the amendment so that there's 20 square metres in a residential zone and no limits in other zones. So what have I misunderstood here?
That's right, and I think 47 might provide some clarity, but my thoughts there where I understand where Mr. Willis is coming from in terms of character and amenity of a building in a residential, a utility building in a residential zone that might be at 50% site coverage and 8 metres high or whatever the height limit is, could have an amenity or a character effect. So I take the point for that zone, but in other zones where there's different building typologies, I think the underlying site coverage or footprint rule should be aligned with that zone. So apologies if that wasn't clear, but that was my thought process.
No, that's helpful. I understand that now. Thank you.
So I've got kind of one question that covers multiple provisions, and it's really around section 32.
Yes.
So you've sought objective 2, the change you've suggested does quite alter how that provision was notified. And so I'm wondering whether I have missed your section 32, and similar for the changes in the rule status. It was just so that I know how you've gone through your evaluation, that the approach you're recommending is the most effective and efficient.
Yeah, the whole purpose of my approach was to provide better efficiency within the planning framework. I haven't provided a 32 AA analysis, but I certainly think that, and as we've talked about in terms of the trees and the heritage buildings, for instance, requiring resource consents where the matters can be otherwise controlled, I think is a more efficient process than the alternative of requiring the resource consent, and more cost effective for everybody involved as well. And again, with the changes to EIO2, I don't think it fundamentally changes the direction of that objective. It's still seeking to minimise effects as far as practicable, not in the context of the infrastructure, but without having that regard to the zone provisions, which I don't think add any value.
I guess, as you will understand, there's an onus on us to do a section 32 AA.
Yes.
So
Yes.
is it more efficient for you for us to do it than you provide it to us?
Can I say much more efficient?
Well, from a personal perspective, but it was an honest error that I didn't do the 32 As.
Is that something that could be rectified?
I can rectify it if the panel so wish. Happy to do so.
Thank you. I think I would definitely wish that.
Sure, no problem. I thought that might be the case.
So my only other question is around the definition of tower.
Yes.
And I just want to make sure that I'm really clear. I'm very clear on what you're seeking to do, which is to make the definition of tower would only apply in an electricity context.
Yes.
I just want to make sure, have you considered it from the context of radio communications, TV, weather, all of those things, that changing that definition of tower to only deal with electricity does not impact any other utilities?
Well, I took my cue from that, from what a tower was in terms of the rules within the plan and where it applied, and then looked at the NESTF definition of pole, which by definition includes tower. So we've got this NES which is being designed to instead, in many cases NES has almost replaced district plan rules, but the telecommunications NES is up to work alongside the rules, so that the language in plans needs to be quite specific to ensure that that meshing of the two documents works from both perspectives. So I certainly looked at it from a telecommunications lens, and then took the cues for what a tower was from the rules. I think I've got it in my evidence, it's EI 27, where it's referred to in context of only of electricity infrastructure.
It's all right, because I must confess I was flicking back between the definition of pole to tower to see, and I think there was a height. I think there was potentially a height difference that could trigger. I may be wrong on that, but
it's used in relation to the National Grid Yard in EI 27 and 28, as well as its standards. Yeah. So therefore I said, I think in paragraph 28 here, I consider that tower is clearly meant as a term associated with electricity infrastructure.
Cool, thank you. Yep, that's my questions. Thanks.
Telephone kiosks. I thought they'd gone by the way. Are they still in play?
To Mr. McCarrison, who installs these.
Yeah, So if you look out in your streets, not too far from here, they're still very much in existence.
I'm not very observant in Timaru, am I?
Which is normal with our infrastructure. Once it's in place, people tend not to see it until we talk about it. So yes, Spark has 2,500 telephone kiosks.
Wow.
And as I said, we are in a process of looking to deliver a new product and remove a number of the existing, quite a few of the existing telephone kiosks, partly because the technology is changing. So with the phase out of copper lines, then all the phone boxes currently are, generally are all connected by copper.
Right.
So the new product will be connected by fibre or other digital means.
So in your in paragraph 4.1 under closing 3G networks,
yes,
it goes back to my previous questions around the pace of technology and how it evolves and how it changes and what costs all this is and how towers have to go that much higher to connect.
Yes.
When is that, like, as I understand it, 6G is due to come in? Well,
yes. Well,
so when is it going to peak, and when are we going to be at the point where we don't have to upgrade information technology anymore?
Maybe never. that is the form of our communication systems. What it will look like in 10, 15 years' time, we may not actually, any of us in this room, including me, know what that will look like. So the Chorus network is providing fibre, and that's directly connecting. Our Spark 1 and 2 degrees cell products over fibre and through our own networks, of which Connexa and 40 South own the poles and that physical infrastructure. And now we obviously have satellite technology beaming in from us in a whole different range of different ways of getting it. The Gs are about the speed of wireless technology.
Right.
And so we're in the process of closing down the 3G network, which the spectrum for that will be used in the 4 and 5G networks, particularly in the 5G networks, and more in the rural area because it's of a spectrum that goes for longer distances, so less poles, although there will be more poles. So, so there's it's not going to stop.
No.
The kiosks are just part of that, basically.
Thank you.
That's all right.
Thank you, gentlemen. I don't have any additional questions for you. Mr Anderson, I look forward to the Section 32AA report, support your provisions. So thank you very much for your time today and also to your colleagues who are online.
No problem. Thank you.
Thank you. Right, we're returning to Council 42A and Mr McLennan. And is Dr McEwen available online still? Yeah, thank you.
Yes.
We will sit for as long as it takes to get through your report.
Sure. Thank you. And I have a summary statement, but I wonder, there's no magic necessarily in that summary statement, but I guess I've had the benefit of listening to people, and I maybe can try and preempt the 3 questions I think are coming, and maybe just jump straight to that rather than taking you through my statement. I should probably first say thank you for accommodating me at the late hours of the first day, but yeah, it's helpful, otherwise environmental mediation wouldn't work. So firstly, I guess the three questions I am expecting to hear, or will try and preempt, is firstly the relationship between the SASM chapter and the Heritage chapter, and that the suggestion I've made. Second one relates to compatibility, and the third one relates to nations, which I'm expecting Commissioner White to ask me, so I'll preempt that. So starting with the relationship between the Heritage chapter and the SASMS chapter, it's my view that they are related chapters as they both protect historic heritage as defined in the RMA from inappropriate subdivision use and development. But in my view, they're standalone chapters that manage the different strands of the definition. They contain separate objectives, policies and rules managing the specific types of historic heritage. And I note that the objectives, policies and rules in the heritage chapter all refer to historic heritage items which are defined in the plan and refer to matters that are within Schedule 3, historic heritage. And so I guess based on the understanding that there is a definition that applies to these, while I agree it's helpful to explain to users the relationship between those two things, Ms. Poole and her Tront submission suggested that maybe the objectives could also apply within both, but given that relationship between the definition and what's in the objectives, I think that they sit separately, but that explanation, for want of a better term, sort of suggests, if you're looking at the heritage chapter, by the way, there's a SASM chapter that deals with the other parts of the heritage, and so that's kind of the way it was couched, as a bit of a flag to say if you're a plan user, you pick up the heritage chapter and say, oh, by the way, there's another chapter that also deals with historic heritage, and that's in the SASM chapter. So I guess that's kind of a backwards way of saying it's a cross-reference, but it was more of an explanation as to how those two chapters seek to work together. I'm not sure if you want me just to go through these three items or whether there's questions on that to start with. I'm in your hands as to... Okay, cool. So the second point was about the reference to compatibility within a number of the rules. And so this compatibility reference is consistent with the principles contained within the International Council of Monuments and Sites, the ICOMS, which is referred to in the Heritage Policy 5.3. So basically the risk of removing that compatibility term, in my view, means that the matter of discretion is very open. It would refer to simply the form and scale of materials without having any direction on what appropriate form and scale might be. As I understood the heritage evidence, it was seeking to enable things such as earthquake strengthening and other works. And I note that both strengthening of internal and external buildings are managed within Rule HHR1 as a permitted activity for internal stuff, and then HHR5 for external strengthening. And so there's already a separate process to I guess, manage those strengthening works. And those matters of discretion include things that you would consider when you're doing that assessment. So it's not about compatibility at that stage, it's about the necessary works to achieve seismic resilience and ongoing use and other bits and pieces. I guess the one thing which I have been thinking about maybe is, and the potential gap that might be there, is that if you were doing, I think the Heritage HPSNZ planner mentioned climate resilience, which might not be earthquake strengthening per se, and so then wouldn't be captured by Rule R HHR5, and so there might be room for an additional matter of discretion within HHR3 to, I guess, acknowledge the fact that there might be some works to achieve resilience or ongoing use, and that might be more beneficial than removing the term compatibility from the first matter of discretion. I haven't fully formed my view on that, but I guess that was just, again, with the benefit of sitting here for the first half of the day, thinking about what a matter of discretion might be to resolve the concern without removing the compatibility limb. I think that's probably one option I'm sort of toying with in my head. And then finally, with respect to the question from Commissioner White, I agree with the Heritage NZ's planner that they were intended to be additional explanations rather than a definition per se. And I note that some of those terms are used elsewhere in the plan for different things, and so I was cautious of including that as a definition because it didn't mean that in other parts of the plan, but I also sort of understood that that helped inform how the policy might be applied, so ended up with it sitting in the introduction, which I thought was probably the most appropriate place. So that's kind of my my 3 points that I'm hoping I cover off, or at least give you some more advice on, but happy to take any further questions.
Thank you, Mr. McLennan. I have a number of questions for you, so I'll just, I'll start with, I can't find it now. At some point in your Section 42A report, it goes from, the phraseology goes from I to the author. Now, I suspect that was because I understand Ms. Durand originally was the author of this section. But I think what I'm quite keen to understand is where it starts to say the author, it relates to all of the site visits in terms of the heritage items.
Yes.
So I'm unclear if you yourself have been on site visits and therefore those paragraphs are your view, or are they Ms. Durand's view, which you're now adopting?
So yes, you're right. I picked this up relatively late in the game, and so all of the site visits were undertaken by Ms. Durand, and I think I thought I thought I'd been careful with saying where I think of something and then where a council officer has then been to, blah, 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 and I can go back and check. I didn't attend any of the site visits, and so the recommendations where it's I as me, and then I thought I had said council officer, blah, where it wasn't me. So I can confirm that, because the other thing that the author, I'm wondering as to whether that was Mrs. McEwen or not. I'm just, I thought I'd been careful, but maybe I hadn't in terms of saying when it was me and when it wasn't me, but I can certainly confirm that and write a reply as to if I've slipped up there.
I'm not suggesting that you've slipped up. I was just interested to know whether I've understood what's your opinion and what was undertaken on the site visit and what was Ms. Durand's opinion.
Yes.
If you could just check that just for the record, it's just helpful to know
I can definitely
what
do
you're
that.
relying on
Yes,
when you've
sure.
reached your view. Thank you. So I'll let you take notes there.
Yep.
In relation to HHR3, where you have made a recommendation around other than official signs, I looked at the definitions for official sign and sign, and there appears to be some overlap, particularly relating to public safety aspects. And I was wondering if the addition of official signs creates an additional complexity in usability or interpretation. Does it matter that there's an overlap in the definition of those, of official sign and sign?
Sorry, I'm just reading through the official sign versus sign definition. So I had read official sign as, I guess, a subset of the sign definition. And so when making that recommendation, on my recommendation again, the intention was that official signs would have a controlled activity pathway through the new HHRX rule, as opposed to non-official signs, the wider group that required consent as R3, which I assume is either RDA or discretionary. So that was the intention, was to create, I guess, a slightly easier pathway for official signs as opposed to the broader sign definition.
I'll just bring up the definition of sign. I think when I was reading through, I looked at clause 1 of the definition of sign and saw that an official sign would meet the criteria of clause 1 because there was an aspect of public safety involved. And I just wondered if that was unnecessarily confusing, or I could be completely overthinking that, but I have noted it down to just run that past you.
Yes. I'm just checking my recommendations again. Yeah, so I guess the way I had thought of it is, as I say, it was that the official sign definition was a subset of the sign definition, so it had the controlled activity status, whereas the signs, and then included within my recommendation, I guess there was a consequential amendment to the rule R3, so that it said signs other than official signs to try and avoid you getting counted by one and then not being excluded by the other. So I was, I guess, trying to avoid it being captured by R3 and instead be captured by RX. So I think that works. In my mind that works, but yeah, I can certainly have another think about it without a hearing going on. But that was my mind and the intention.
Thank you. With regard to HHP6 and HHR8, I noticed that policy 6 focuses on within or beyond, whereas the rule focuses on within or outside. Does that matter, or is that just that? Is that a drafting consistency issue, or is there a deliberate difference there?
What was the rule reference? Sorry,
Rule 8.
Rule 8.
And policy 6.
I don't think there's any intention that they're different. No, I think that that's a drafting inconsistency probably between those two.
Thank you. So in relation to the tree, jump into the trees now. In terms of the different methods and rule frameworks in other district plans, have you looked to see how other district plans approach trenchless methods?
I looked at other district plans for something. I can't remember if that was I think I looked at that in the context of the customer connections to heritage sites, if I remember rightly. And I maybe even listed some that were consistent. I don't think I had the same look for trees.
It might be interesting to see how it's managed in other district plans, given the evidence of Mr. Anderson. I do know that the DCC does exempt, in the Dunedin City District Plan, there is an exemption for from the performance standards where certain criteria are met, so it could be a useful one to look at.
Yes, I've just found that where I had referred to the proposed Mackenzie District Plan, the Portuguese District Plan, and the Napier proposed District Plan, they were in relation to the heritage customer connections rather than trees. So no, I think it's a short answer. I haven't, but I will for the reply.
Thank you. And we also heard today from Mr Anderson for the telcos around HHRX. I'm back in the heritage roles now. Who was discussing the justification or the rationale for seeking controlled activity rather than a discretionary activity. Having heard that dialogue, have you reached, has that influence, has that had a bearing on your view on that activity status at all at this point?
I had thought about it before. I had heard Mr Anderson speak of, it's kind of, I guess it's in my mind now currently. The thing which I guess I'm still thinking about is how these activities align with their kind of parent policy in terms of giving me some direction for an activity status. And so there is, for example, in P3, a recognition of the social, cultural and economic benefits of ongoing protection, use and including adaptive reuse. So there is kind of, I guess, a tick for something more lenient there. But then there's also in HHP5 a direction to only allow external alterations where, and then there's a list of things. And so I'm just in my mind thinking, is there an ability to only allow something if it's a controlled activity or not? And so I guess those are the two things in my mind as to, there are policy directions which I guess I'm going to lean on as to whether that's a RDA or a controlled, and it's, I guess, where that balance sits for this particular infrastructure activity and whether they would comply with those two if it was to be reduced to controlled. That's kind of the inner workings of my mind at the moment.
Thank you. And the other matter was, we've heard from Mr Templeton today and also Mr Harding representing the landowners.
Mm-hmm.
And I wondered if this might be more a question for the expert online. Did you hear anything that may alter the conclusions that you drew on the potential for that being a heritage item?
If I may defer to the heritage expert for that, that would be my response. Yeah.
Thank you. Dr McEwen, are you able to comment on that? Were you present? Were you able to hear the presentations earlier this afternoon? Oh, we can't.
Yes, Tanakwe. I didn't hear all of the precision security submission because the live stream was, the sound was down, but I heard half of that. And no, I haven't changed my view, while acknowledging, obviously, the historical research efforts of Mr Templeton. I haven't changed my opinion, particularly when it relates to the assessment criteria for the other qualities that you need to find with heritage, including architectural and so on. And also what you'll find in some of the one of the very many attachments to my evidence that's been provided. Attachment 1 has the criteria for assessment of heritage items, which includes the explanations that Heritage New Zealand has been seeking to be included in the plan, which is what Christchurch does in their plan. And also on the last page, it's page 7 in attachment 1, there is a methodological threshold kind of template to determine that whether an item not only exhibits significance, but also whether it merits scheduling given essentially its authenticity and integrity. And so I'm not disputing that Mr Templeton has done a lot of research and can point to the historic narrative of both of those buildings. I don't think they meet the criteria, and particularly when it comes to the credible and truthful evidence, both documentary and physical fabric,
that needs to support scheduling a physical resource on the plan. So I'd just refer you to attachment 1 of my evidence, and no, there's nothing that has changed my mind. And in fact, while I've been waiting for you all, I have discovered a photograph of the Governor-General opening the Elizabeth Townley Maternity Home in Gisborne in 1910, which was erected by the County Cook Women's Guild. So there are other examples of maternity hospitals around New Zealand if one was to, launch an exhaustive research project on that topic.
Thank you very much.
Look, I might as well stay then with you, Dr. McEwen, just on because the question was, have you taken anything new into account, and has your position changed? And I had a question around the Whare Nana site, and what I was trying to understand there was your statement about it being short-lived, and that its level of integrity now no longer embodies significant architectural craftsmanship and textural values. And I wanted to better understand that, and in particular, in light of Mr. Templeton's evidence, whether relatively short-lived should be part of the assessment criteria.
Yes, thank you. Yes, and I did hear him discuss that. The heritage assessment involves measuring, if you will, a building, a structure, an object against that assessment criteria, and considering to the extent to which a level of significance is met. Because if you'll forgive me, just to take it really back a step, everything is historic. Everything happened before today. So even though the word significant is conspicuously absent in the definition of historic heritage resources in the RMA, nevertheless, that is the threshold that has to be passed in order to schedule a heritage item. In the case of Whare Nana, my point in making, in terms of its kind of relatively short-lived use as a maternity home, was to point to the fact, was to make a comparison implied that another building that has been continuously used as a place of Anglican Christian worship since 1892 is going to embody a deeper significance in terms of its history and social importance because of that period of use. So if something has been used very briefly, that doesn't necessarily mean that I wouldn't recommend it to be scheduled, but it is a consideration when you are working through those assessment criteria. Ernest Rutherford does not need to have spent 30 years in the Den, in the Arts Centre in Christchurch, in order, for that place to embody significant heritage value. The examples that Mr. Templeton gave that are recommended for scheduling in the proposed district plan included the water race tunnels that are around the district, and also the council chambers that, I'm sorry, I'm not in today. Those buildings, yes, have changed. There's no longer a library in the building in which you are located, but nevertheless the council is still there, which was part of the original purpose of the building. And the fabric of the facade, which is what is scheduled on the district plan, maintains a high level of authenticity and integrity. So there's two kind of sifting processes, if you will, going on. One is to do with, is a threshold of significance met? And then on the other hand, is the physical resource in such a state that it embodies that heritage value? So, and to my mind, sometimes that's a confusion that arises in these kind of situations, because people can bring a huge amount of very well researched historical information which really would lend itself more to interpreting a site rather than protecting the physical resource. So I'd never dispute that, because Mr. Templeton and I, both of our research supports this. I don't dispute that Wharenana was a maternity hospital. I don't dispute that Alton House was a girls' school and hostel. But in terms of scheduling, we're talking about natural and physical resources that embody New Zealand's history and cultures. There's got to be a physical resource there that embodies those values. And if you have a look at the methodology for ranking items, is that once an item has met a level of significance, then it's got to meet one at least of the criteria. So it could simply meet a historic and social criteria, but that would be very rare because you need that physical object in order to protect that resource. So there is that interrelationship. That's why I've said both of these buildings, that yes, they embody historic kind of narratives. They don't tick the box, in my opinion, in terms of the other assessment criteria, and they are of insufficient integrity and authenticity to merit protection under Section 6F. So I hope you'll forgive me for the lengthy reply, but reflecting on Mr. Templeton's presentation, I think that that's of some relevance.
No, that is helpful to understand, and I could understand your assessment for the Alton House. It was understanding for the Wharenana whether, because you're quite clear with Alton House that it was the alterations that also came into play, but with the Wharenana maternity hospital, there's still presence of the building of the historic site. It hasn't had the same level of alteration. So what is the difference there?
Well, it would appear, based on, and I hadn't seen that image before because it was only just provided by Mr. Templeton today, but he showed a photograph of Wharenana that was taken from the Timaru Herald in June 1961. I've been unable to find, and it would appear that Mr. Templeton doesn't have in his possession, any historic photographs, architectural drawings, anything of that nature that would help us determine what the building originally looked like. And that would be what you would measure the state of it today. It's difficult because those early maternity homes looked like houses. You can understand that might be something that would be a homely environment, but also that was where the nurses lived. So some of the maternity homes were essentially a house in which a woman went to give birth and the nurse lived there, the midwife lived there. So part of the difficulty with Wharenana is that there's insufficient evidence to establish what the building looked like. There's no architect involved, which is not a deal breaker, but it certainly helps if you can point to, that opens up another documentary evidence kind of pathway potentially. So without that evidence, the building doesn't look too different from 1961, but I don't think anybody can tell you what it looked like in the beginning of the 20th century.
Okay, thank you. I might return to Mr. McLennan for my questions. And you were right in anticipating questions, so well done. I only have, so when it came to the compatibility question, that was, for me, that's something that I think Ms. McEwen needs to also answer. So you've answered, but it'll be good to hear her view on that. But my only question left for you then comes down to the terrace, the Canterbury Club, and this is at paragraph 6.24.27 of your section 42A report, and in that, based on Ms. McEwen's evidence, you have agreed that, so it used to be the whole site that had the heritage setting, or heritage item, but it's now been reduced, and I wasn't quite clear. Does that mean that I think it's a tennis court is out, and there was a tennis court and there was a conservatory and another area, a cottage, and I wasn't sure what's in and what's out based on your recommendation.
That was 62425, is that right?
6.2427 was explaining the site visit to Canterbury Club, and the renewed evidence to say, conclusion was, in respect, agree to reduce the extent of the scheduled heritage item.
Mm.
And their evidence was they wanted those 3 areas excluded.
Yes, from memory, I think there was a plan in Mrs. McEwen's evidence that showed where that was going to be reduced to. Maybe I could refer, because I guess I'm picking up on the recommendation there from Dr. McEwen to say, yes, it can be reduced. In my recollection, I think there was a map within the evidence from Dr. McEwen to suggest where that could be reduced to. Is that right? Sorry to...
Yeah, so originally when it was proposed for scheduling, the South Canterbury Club, the extent of setting actually comprised 2 land parcels. So there is the larger one in which the majority of the club is located, and then there was a kind of thin rectangular parcel on the northern boundary of the main parcel. And as I recall, the South Canterbury Club said in their submission that first up, A, we don't want the building to be scheduled. B, if you are going to schedule it, we think you should reduce the setting. So the setting, this is attachment 11 to my evidence. So I conducted a site visit with Ms. Durand and came to the view that the setting could be reduced in terms of kind of option B for the club, which means that the setting now mapped is a kind of, it's a bit roughly triangular parcel on which the bulk of the club is located. It now excludes the squash court, some of the car park and so on. So that was the recommendation made to the council officer, which meant that I agreed in part, I believe, with the submission, not about taking the building off the schedule, but about, yes, that it was reasonable and defensible to reduce the setting. If that makes sense.
I've found the triangle now, so that is helpful to see what's in and what's out. So thank you for that.
Yep.
And my only last question, and it wasn't a question that I had at the beginning of the day, so it might just be that I don't understand now that it's the end of the day. But can you tell me the difference? So I'm talking about HH Rule 3 and HH Rule 6. And I'm trying to understand the difference there, because it's signs, and one's for signs in a heritage setting and the other's signs attached to a heritage item. So what's the main difference of those rules?
So that was HHR6, signs attached to a historic heritage item. What was the second rule, sorry?
I know I'm not a planner, but I could answer that question if that would help. So the difference here is that essentially R6 relates to an external alteration to a heritage item. R3 is kind of friends with R4. It's to do with managing the effects of potentially inappropriate subdivision use and development within the setting of a heritage item. So That's why R3 relates to new building structures and signs. So, because you could imagine that you might want to erect a sign beside a heritage item without touching it. So that wouldn't trigger R6, but nevertheless that sign could be a blot on the landscape that would have a significant negative impact on the heritage value.
Okay, great, I understand the difference now, thank you.
I've only got one question, and it is from the planning end of it, and it relates to the seafarers and the evidence of Miss Seaton, and it relates to and so I understand from a heritage perspective, you accepting Dr. McEwen's view. What I wanted to understand from you was, did the evidence that was provided in terms of the relative timing have any influence on your consideration of the efficiency and effectiveness of the provisions? And and I'd kind of like to understand a little bit about that and why you're saying it should still be on the list. And there's one other building that, but particularly that one with the timing. I wanted to understand what your thought process was.
Yes, so I guess the evidence for that submitter I found, from a planning perspective, I found very helpful, because the evidence was, by the way, we've got contractors removing the asbestos soon and it's going to be knocked down before the end of the hearing. And if that's the case, I'm really happy to include in my reply report, once I get that from them, obviously, we can strike through that and that's sort of a job done, because it doesn't have that value anymore. And so from a planning perspective, I thought that was a great solution, to be honest, because it meant that we didn't have to do a Clause 16 change, we didn't have to go through the legal requirements of what is an existing environment. It felt very practical to me. So I was happy to oblige if that was the case within my reply report. Right. For the Prime Port end of things, I guess the thing that complicates it slightly is the fact that there's another submission with a COC that haven't given us that same evidence to say, by the way, we're going to knock it down before the end of the hearing. And so there's a requirement, or there's the onus is on, I guess, me as a reporting officer first to determine whether the same should apply or not. And I guess I can reach out to that submitter to check whether they have demolished the building before the right of reply, because I guess that resolves the concern. But I guess the principal position still remains in my FOI2A report, and as Ms Vella kind of alluded to, if it hasn't been knocked down by the time of the reply report and it still has heritage value, my recommendation is still to include it. If it's removed after the fact, then it's probably a Clause 16 change to remove it because it no longer exists, both of which are kind of a relatively simple process in my mind.
So just a second point then on that, I'm really curious to understand whether that has either of those, but I mean, the port I understand, so then the other one, does it give no pause to the efficiency and effectiveness, the fact that there is a certificate of compliance from a planning perspective, not a legal or heritage perspective? That's what I'd really like to understand. So is there nothing anybody could do beyond knock it down that would make you, from a planning perspective, say, well, maybe this provision may not be as effective or efficient as other ones? Or is it, so I want to know, is it absolute that as long as it exists, then it should be there? Mm-hmm. And it's the same as every other building? Mm-hmm. Or is there a difference from considering efficiency and effectiveness with those that have permission to remove it?
Yeah, I understand where the question is coming from. I guess my view is that there is an objective and a policy seeking to protect particular things that have particular values. And so the first part of, I guess, that assessment is, does it have the value or not? And the answer to that, based on my heritage expert, is yes, it does have the value. And so what is the most efficient and effective way to ensure that that value, the protection required by the policy, is achieved? I think it is still to list it, because otherwise you're not achieving the protection that's required in the policy. So that's kind of my thought process, is that yes, it has value. Yes, the policies say protect from inappropriate subdivision use and development. The end result of that is it being listed and the rules applying, unless the COC process removes that value. So that's my current thought process.
That's helpful to understand what your process was for that. Thank you. That's all the questions.
Slight change of topic, and mine is around the Rari racecourse. And it's sort of a question for Dr. McEwen as well as yourself. It sort of goes back to my questioning before around natural justice, and I wanted to know, it says in the report that Dr. McEwen, met with the submitter in 6.24.13. I just wondered what, whilst I understand there is no obligations to discuss with the landowner the scheduling, has there been any interaction with the landowner and understanding what their impact would be? Because I understand, Mrs. McEwen, you had a recommendation to council back in 2019 that was not taken up, and now you've done further research, and now you think it should be on the schedule. So I just wanted to know, what rationale and justification for that and communication you've had with the landowner.
Commissioner, would you be able to remind me who the landowner is of the...
Timaru District Council.
Right. I went out to the racecourse and met with the submitter and a gentleman who's involved with the race club. I was engaged to do that by Timaru District Council. So, in as much as that was who engaged me to do that work, then somebody knew that that was going on. And my initial recommendation to the council some years ago that you've referred to was in relation to a number of sites that at the time there wasn't quite enough information on the table, but that I recognised certainly had the potential to be recognised. And in the case of kind of clusters of buildings and structures, part of my work was looking at whether things might be heritage areas. So there are two of those scheduled, Caroline Bay and Stafford Street in Timaru, but there was also the potential for character areas. And because character areas weren't considered, as part of the further development of the plan review process, perhaps it could be said that the racecourse and a number of other places kind of fell between the stools to some extent. But because there was a submission to which I was asked to respond on behalf of the council, that's where the site visit came from, and then also my recommendation to schedule the racecourse buildings, which you have as a heritage record form attachment 7.
And just following on from, I think, your explanation to one of the commissioners, around the filtering process for understanding those. One of those was around physical resource to protect the resource. So you talked about two different avenues of filter to do that. So I presume that's gone through that filtering process when you've further recommended this to be on the Schedule 3. And could you explain your justification for that?
Yes, exactly. So that's why the heritage record form that I prepared runs through the assessment criteria, historical and social, cultural and spiritual and so on. And then I recommended an A ranking, which kind of comes out the end of that methodology for assessing significance and then determining a level of significance in that respect. And it's heritage items and areas, there's a sort of an artificial distinction sometimes that is drawn. So, for example, Stafford Street is a historic heritage area that's been included in the proposed district plan. The Royal Arcade, which comes off Stafford Street, is an item, even though it's comprised of multiple buildings. And that's the case, just for clarification, that's the case with the racecourse, is that because they have all got they're all integral to one another in terms of the buildings that comprise a historic racecourse. That's why they've been put forward as an A-ranked item rather than a heritage area, which would be was possibly the other option to go with.
I just have a follow-up question just on Orari Racecourse, and I just wanted to know, was there a further submission from the landowner supporting or opposing?
We had a quick look at the break because Mr Haggart mentioned that this question might be coming, and we didn't see a further submission from the Timaru District Council.
Yes, my question is for you, Mr. Clennan, sorry. Why the different approach for including items in the district plan schedules? I mean, to include a notable tree, to include a notable tree in the schedule, the property owner must agree first, but to include a heritage item, it can be done so without the property owner's permission.
So that was describing, I think, the process that the council took prior to me. I saw that in the Section 32 report as the means of which they undertook that. So I guess that was a council decision to require landowner approval prior to a notable tree being listed, as opposed to historic heritage items which didn't have that same council direction. So as far as I understand it, that was a council decision to do that.
Thank you.
Look, I don't have any further questions of you, Mr McLennan, or Dr McEwen. Thank you very much for the explanations that you've given and responses today. This may, as we're going to hear from other submitters, including another landowner who was a late further submitter, if anything arises out of that, we'll refer it to you, Mr McLennan, and on to Dr McEwen if there's, and you can cover it off in your interim reply. So. Oh, sorry, my apologies. There's just one. Yeah. Okay. One more question. Thank you.
Yes, kia ora. And I just wanted to start by apologising to you, Dr McEwen. I was calling you Ms McEwen, so apologies for that. I had an earlier question that I thought would be helpful for you to provide from an expert perspective, which is the use of the term compatibility, and whether you thought that would be, in light of the Heritage New Zealand submission, that it wasn't appropriate. What did you think about that?
Well, as Mr McLennan just said, compatible is used in the ICOMOS New Zealand Charter, which is the kind of local variant of an international charter that directs historic heritage conservation. I do think that it's a useful word in the context. I'm just looking at, for example, HHR2, in which the matters of discretion are restricted at point 3 to compatibility with heritage item and its setting. I'm not sure really how, if you drop that word, I would have thought that's still implied, because compatibility is what you're looking at, you know, what you want, if you like. And in the ICOMOS Charter, in terms of the use of the word compatible for compatible use, for example, the ICOMOS Charter says that compatible use means a use which is consistent with the cultural heritage value of a place and which has little or no adverse impact on its authenticity and integrity. So I'm a little bit surprised that Heritage New Zealand would have a problem with that word, because it seems to me it gives a useful steer in terms of thinking about doing something new in a way that is sympathetic, which is what adaptive reuse is. It's what we do with heritage buildings, is that we seek compatible alterations, modifications, uses in order to keep them alive, essentially.
I think that is really helpful. My understanding of their submission is that they were reading it in terms of same for same, like compatibility equal do the same, and that is not your understanding of the use of that term.
No, and I looked it up in the dictionary, and it means that you avoid compatibility in the dictionary means two things together without problem or conflict. And I'm a big fan of the dictionary, because I think in heritage we use real life words all the time, and I think that notion of without problem or conflict is exactly what we do seek in heritage conservation. So I wasn't thinking it would be same as, let's pretend it's 1892. I think compatible, we have compatible star signs. That doesn't mean to say that we all have to kind of, get together with a fellow Leo. So it's late in the day, isn't it? If you'll forgive me for that. Yeah.
Yeah, and we see that all the time, as you point out, in heritage. We see different ways of speaking to and respecting the past, with different technologies that are available to us today and different styles of architecture. So I think that was very helpful to have that explanation from you. Okay, I think we can round out the day. Thank you very much again, Dr. McEwen. Thank you, Mr. McKinnon. Good luck with your mediation tomorrow. Ms. Vila, is there anything we need to do before the end?
To think about when you will hear from Mr. Boyes. Thank you. When you'll hear from Mr. Boyes, and whether there's any rescheduling of submitters that needs to be done in the morning?
Perhaps we need to just do a little bit of work with the hearings administrator, just in terms of maybe contacting some of the submitters. Can you perhaps just leave that with? I don't want to keep you unnecessarily here in Timaru, but we'll try and make some space at some stage tomorrow without disrupting submitters who may, I wouldn't wish to disrupt the Limestone group, because I know they've got a number of submitters that will be coming around the district, so once they're here we want an opportunity to be heard. But
and Mr. Boyes is scheduled to be here for the whole hearing anyway, so...
Right, okay.
Unless you'd like to release him once he is done.
I'm sure he can be released. Leave it with us, and we'll talk with the hearings administrator and be in touch with you as soon as possible.
Thank you, Madam Chair.
Thank you very much for that. Right, good evening, everyone.